Yes, honey, it's to do what we can do. Time. Do what we do, show. What's happening? Bitch, I said, ooh, she back so soon. Yes, honey. Okay, I am back. Listen, y'all. I know I told y'all to inform me when people talking shit, right? Because some things you have to address because it just be so egregious and just a bunch of lies, you know what I'm saying? And they're cowards. They don't know how to hit you on the line, so they run and hit this motherfucking live and then just go on a rampage with a whole bunch of bullshit. And they know I'm gonna come back and drop that motherfucking evidence. And also talk about the shit which will make sense and it make it logical. Because the bullshit they'll say isn't. Because here's the thing, most lies are, first of all, most lies aren't able to be proven. That's one of them. I ain't no most, all of them. They're not able. I'm a little groggy, honey. I'm a little sleepy. Well, all lies aren't able to be proved. That's number motherfucking one. Because if a motherfucker said I was talking about them or any kind of lies, prove it. Just people just want to have beef. Weird ass motherfuckers just can't get over defeat. I don't know what to say. And I also told you, I know I told you if somebody talking about, let me know, whatever. Because I have no way of knowing. But I also say, if they ain't graduate high school, if they haven't mastered, words that they teach first graders, if their hair look dry, if they taking care of motherfucking men and shit, all that type of shit. Um, if they salty over, a nigga, whatever, that they've been crying and whining about and all this kind of bullshit, honey, leave me out of that. That is special ed arguments. That's a special ed um person, people. And they need to argue with other special ed people. That's a mentally insane, mentally ill motherfucker. That's been confirmed by more than one motherfucker, and also the motherfucker that they crying and whining about, like just insane. Okay, I got time, nothing to do with that. But them motherfuckers like that can come off anybody else, honey. That ain't what we do over here. We put out news you can use. We have content that makes motherfucking sense. Okay? We do the shit that they can't. And I hate being up on disclaimer number 2 because it's coming off a little, like I'm boasting, I'm bragging, or whatever. No, I don't want to do that. I want to call it I'm telling the motherfucking truth. Okay? Alright, that's the difference. Okay? So, baby, I told you. Listen here. Some of y'all better be happy y'all took that GED prior to 2014 because after 2014 they made that shit harder. Okay, you know what I'm saying? I know a lot of y'all, instead of bringing home books, y'all brought home babies and crack to sell and all kind of bullshit like that. Grown ass men and shit like that. Hey, you know, I salute you, cause you made it. Okay, it's 2024, and you here with us now. Hey, sweet babe, you know, um, but it's so many lives that y'all, can do. You know what I'm saying? That people would be there, that would be, wanting to know, what it is. You understand what I'm saying? Like, you can do, again, I'm going to suggest this. You can do lives and tell us how in the hell you can drop out of school and never bring home a motherfucking report card and everybody's okay with that. Like, tell us about that. How was that for you know? And some people, I'm a teacher, so I have access to different things. And some people name ain't ain't nowhere on no graduation motherfucking papers. Nowhere. And it ain't like it's no shocker, we already motherfucking know that. We can hear it. Like, it's so much shit to talk about and report on if you can. But you have to be crazy and something wrong with your motherfucking ass to think that you can compete with all these people out here who are educated, who can be expert on the motherfucking subject. And some of these motherfuckers can't be expert on shit. But what I just said, hood shit, nigger shit, dropout shit, mentally ill shit, addictions and shit. Talk about all of that. Okay? I don't want to be on here, addressing nobodies and nothings. Okay? And trash. Alright? You call me anything you want to call me, even if it's true. And I guarantee you, it is no worse than I can call your motherfucking ass and it be true. And it be motherfucking true. I know some of you motherfuckers been horned since you were born. I get that. But don't get mad at me, because I ain't fucked nobody on the motherfucking internet. Don't get mad at me. Shit. Alright? And, for the most part, well, um, I can say, well, I know I was treated better than some of y'all motherfuckers. I can tell you that. I know I got something out the deal. So, I don't know what to tell you. It ain't my fault, okay? They made a song that said that. And ain't nobody got time to be. We have to put out commentary and content that is relevant and useful to people and give them $1 billion worth of game. Okay? So, hey, it is what it is. And you got to understand, I don't give a fuck about your, you know, them motherfuckers like that. Shout out to the people on YouTube. Shout out to the people on Twitter. Honey, y'all be, oh my gosh. Jesus. Baby, if I can show y'all these numbers, y'all be like, what? What? As the actor be playing out in them little sound bites. What? I don't know how people be having them sound bites and all that type of stuff like that. You know what? Now, I don't like that motherfucker either, or whatever, but I'm gonna give credit where credit's due. That motherfucker, at times, not at times, for the most part, he plays some, good music. If I'm not mistaken, did I hear him blend the shit in pretty decent one time? Like them DJs be doing, mixing or whatever stuff. Maybe, maybe not. But maybe it wasn't him. It was somebody else. But his selections to be pretty decent. However, I have to hold my eyebrows up when he be using female get crunk songs. I don't know. But anyway, okay. I'm gonna have to edit nothing. He's talking about nothings or nobody's and referring to them motherfuckers out of my program. But see, when I'm on this live, my program is your program, and I'm wasting your time with trash. Trash is what you put outside. We ain't here this murder. I haven't called nobody motherfucking names and shit like that. Or some beefing with somebody. Just crazy. Weirdo.
Charlie made an objection on yesterday that we have to that be kept out, and I don't recall what the court's ruling was. Can I have some clarity on that, please?
Sure. The court's ruling was that if Ms. Love ends up tendering that for admission, that can be redacted out. It can just say quote and then blacked out quote. So it's clear that there was some quotation that was going to be included that got altered. And asked if there were any other notice when they tendered, just let me know about it.
Will do. Thank you.
All right.
Your Honor, as it relates to the correspondence to and from Mr. Wright and the state. I just want to make sure that there's not any, the state intends to, for the purposes of proving their existence, to tender them. And of course, with the redact, the defense, and it as an evidentiary matter, this of the request itself is evidence that we think should be permitted at trial.
So that you're saying.
For instance, I would be tendering the November 30th email in response, requesting a conversation with Mr. Sledge. Given the cross-examination, did the state ever try to sit down and talk with you about Jeffrey Williams? All of those kind of questions prior to making the December 28, 2022 plea. So the existence of the request itself is evidence that we will be tendering, not just making the inquiry of Mr. Wright.
Okay.
Well, they'll have a witness on the stand.
Yes.
That they can ask whether or not that request was made. That witness can testify yes or no. If, depending on what that witness's response is, there may or may not be a need to impeach that witness. And so I can't think of any way, that any legal reason that the document itself would be necessary unless for some legal exception, for example, impeachment.
Existence of the request itself is up to Mr. Wright. A request that was sent to Mr. Wright through Mr. Wright.
Well, the document.
Don't interrupt, please.
Excuse me.
Remember, we had decided that we weren't going to be interrupting each other?
Understand.
That's what the objection is. The hearsay, there's nothing hearsay about it. The document itself, it does not constitute hearsay. We're not offering it for the truth of the matter that
Sir,
it's actually just a request. And the document, the existence of the document is evidence in itself.
My DA's office, from the author of that correspondence, it is not a court statement. It would be hearsay, but more importantly, it would not be necessary. It testifies to that fact, and it testifies affirmatively. Then there is no need for the introduction of the document itself.
Okay, but there's no evidentiary rule that says that if you can get the information in through the witness, you can also offer a document that shows the same thing.
And so what would be the purpose of them offering the document if they have to testify?
Further proof. All right, let's get the witness in.
see, I told you. Sweet baby, you been doing good? You still at home? Who's what? Lord. I gotta check to see if I qualify to go live over there.
Your Honor, Miss Lieutenant, that was received today at 7:53 a.m. Good morning. Good morning. Traffic has been terrible. I am a few blocks away from the courthouse, but depending on how long it takes to navigate these blocks, park, and get into the courthouse, I might be just a little late. I'll ask her to call in because we reached out at 7:53. So I'm going to ask her to call in.
Okay, so is he not outside right now?
I'll get her to call in right now.
It doesn't take an hour to navigate a few blocks around the courthouse.
Oh, wow.
All right, so we'll be in recess until we have the witness.
My
What is going on?
You're welcome. He's here. He's here, Mr. Weinstein.
Child, when I tell you this goddamn case got more twists and turns and shit on, as we can catch them. What is Miss Love? I mean, not Miss Love, Miss Hilton.
We're ready for the jury.
Good morning.
Morning.
Oh yeah, he kind of short. I like his little shoes. I like his little outfit. He kind of short, y'all. I don't know. I don't know how that's gonna work up on that auction. Is it me or is he kind of short? I can't. Sometimes I can't really
We
tell.
just now got ready anyway. Thank you.
Is he about the same height? Is Hilton a little short? Not Hilton. He's a little shorter. That ain't gonna work. Sylvia, that ain't gonna work out for me. Hey Sonya, how you doing?
Thank you. All right. Everybody can be seated. And before we get picked up, maybe from the jury and from attorneys about what our plans were going to be for Election Day, November 5th. And my plan is to have court that day, and I'm going to have my assistant forward the list of early voting locations and times. It appears that Fulton County has early voting starting October 15th and running all the way through November 1st. And that includes Monday through Friday, Saturday and Sunday hours, and almost 45 different locations during early voting. You can vote at any of the early voting locations. It doesn't have to be your precinct. So anybody who wants to vote certainly is going to have plenty of opportunity to early vote. We will probably adjourn court a little bit early, maybe a few hours early on November 5th, but we're not going to take that entire day off. All right. Okay, Ms. Love, go ahead and continue with your examination.
And good morning again, Mr. County.
Good morning.
Judge, but of course, permission
Yeah, that's fine.
Mr. Wright. Mr. Wright, yesterday we were discussing representation of clients that you had and your responsibilities as it relates to them. Would you tell the jury what it means to make an entry of appearance when you begin to represent a client in Fulton County Superior Court?
When we are hired to represent a client, and this was civil, criminal, anything, you make an entry of appearance with the court so that you are officially letting the court know, I have been retained to represent this individual in whatever the matter is. That entry will generally, I'll just sit back. That entry of appearance will identify the court, identify yourself, identify the client, and basically shows your role that you are officially in that case.
Is it required that you make an entry of appearance anytime that you begin to represent a person in a criminal matter in Fulton County Superior Court?
Yes.
Okay. And once you make an entry of appearance, does that announce to the court, the state, and any other attorneys that are interested that you solely, along with whomever you designate, are the person that is representing that person?
Essentially, yes.
Right. And once you make an entry of appearance, are you bound to that person until you yourself just, better question, once you make an entry of appearance, can you unilaterally decide, I'm tired of you, I'm gone, and do nothing else?
Let me answer it in two ways. In terms of the court seeing you as the official representative or the authorized representative of that person, until you're released by the court, you remain that person's attorney as far as the court's concerned. Sometimes there may be a falling out or just a parting of ways between attorneys and clients prior to that. But until you get the court's approval on a motion to withdraw or substitution of counsel, but until you're released by the court, you remain that person's attorney.
Would you tell the jury the steps that a criminal case, for instance, when you send in an entry of appearance, is it always at the same place in a criminal proceeding, at the very beginning, middle, end?
It really depends on when you're retained by the client or the client's family. Sometimes you can come in the very beginning, before a case is indicted. That's when you hear words like prelim or first appearance or things of that nature. Or much later on, at indictment, where you have arraignments and other initial proceedings for indicted cases. Or sometimes you're hired much later in the process. The case may be on a trial calendar already. So it really varies with each case. When do you actually come on board?
Do you recall the stage of trial or the stage of the criminal process for case 22 SC 183572, this particular case you're testifying in, or the predecessor indictment that this superseded, do you recall the point at which you filed an entry of appearance for Antonio Sledge, the point in this case, not necessarily the date, just where the case had gotten to?
Understood. I don't remember the exact date that I filed an entry of appearance, but I was involved in the case before it was indicted, meaning he was affected by this case long before indictment. So we had some initial things, preliminary hearing, and things of that nature that we had to deal with. So I can't give you a date, but very early on, even well before the case was indicted, I was involved in the case.
Okay. And when you say you were involved in the case, are you specifically referring to what ultimately turned out to be this indictment?
Yes.
All right. When you are have filed an entry of appearance and you remain on the case, and the case is placed on a trial calendar here in Fulton County Superior Court, and it reaches, say, a final plea stage, would you explain to the jury generally, not fully in detail, but what final plea means as you understand it here in Fulton County?
Okay. To give you a quick primer on criminal cases. Once the case is formally charged or indicted, you have an arraignment. That's where you formally plead guilty or not guilty. Then you have what we call sort of discovery. That's where the state provides what their evidence is. The defense, we file motions to suppress, motions for more discovery, motions for experts. I mean, a variety of stuff, but we're sort of developing the case to make sure we're getting everything out and sort of on the table. Then after that process has sufficiently occurred, where discovery is exchanged, certain motions may be filed, may be heard, eventually the court puts it on a final plea, which says, hey, all this stuff has been done. Have you come to a decision on what you're going to do? Do you want to proceed with trial, or do you want to resolve the case? And a final plea date is significant because there's generally two kinds of pleas. There's non-negotiated and negotiated.
Before we get into that part, are you able to encapsulate, without going further down the line into non-negotiated and negotiated and all of that, are you able to just encapsulate what that date is?
In terms of what a final plea date?
Yes.
Well, final plea is your Fisher cut bait date.
All right. And
Okay.
on that Fisher cut bait date, are your only options to enter a plea, go to trial, or do you also have the opportunity or ability to request something different than either going to trial or entering a plea?
I would add a third. Take a plea, go to trial, or beg for a continuance. So sometimes you can get it, kick the can down a little bit and say, hey, we need more time. So one of those three, and it still brings you back to final plea date as either
At a later time, though.
yeah, at possibly a later time. It's, are you going to take a plea, or do you want to go to trial?
All right. And are there any particular reasons that might guarantee you a continuance? Any particular of any sort?
If there's a major issue with discovery, something that either hasn't been disclosed, sometimes a medical condition of the attorney, the client, something extraordinary generally. Some courts are a little stricter on holding that final plea date and holding our feet to the fire, and other courts are a little more flexible.
Were you to tell a court that you simply are not ready, you cannot be effective, are you generally given a continuance if you request one?
Generally, yes, with caveat, depending on the judge, depending on the court. Some courts, again, are much more firm and strict because, again, they're trying to keep cases on track.
Right. Will you know what the court is going to do without asking?
Generally, if you've been around long enough, you've gotten to know the tendencies or the requirements. Different court, yes.
Question. Can you state with certain whether you're going to get a continuance if you don't ask for a continuance?
Your Honor, I'm going to object for relevance.
Sustained.
All right. So, are you able to tell the jury if you were Mr. Sledge's attorney even before this case was indicted?
Mm-hmm.
Did you appear with Mr. Sledge at a plea and arraignment? Was there a plea and arraignment for him that you were a part of or someone on your behalf?
I'm not sure. And to explain that, this case occurs. I have a heart attack in March of 22. So from that March 22 and then heart surgery, I'm off the grid, out of practice essentially until December. So of 22.
Okay.
So I'm out of pocket for about 9 months. So there are things which may have occurred before that, and I just don't remember if the arraignment had already occurred or not. I'm not sure, but I may have missed some things in that 9-month period when I'm on leave of absence. When I came back, I think arraignment, everything had already occurred, because I think we were already quickly moving towards trial count.
And were you already in conversation with the state during the time, even before you appeared back in court regarding this case and your client? Before December 28, 2022?
I believe the sequence was in November. The state sent sort of a inquiry email, and I then contacted my client to firm up, hey, am I still your guy? Am I still your attorney? And are we going to be moving forward? And I think they also had to know, are you ready to come back? Well, my client. And I also had to make sure that, hey, I've passed all the tests, I've done everything necessary to be able to resume my practice. Everything fell into place. I did come back, and by December, I think, was when I started to communicate that, yes, I'm still his attorney, and we started to move forward with different things.
I'm showing you what has been marked as State's Exhibit 450 Yankee. Would you take a look at that? And Your Honor, it's the 450 Yankee we've identified previously.
Thank you.
Without reading into it, without reading it out loud, rather, would you please look at it and tell me if you recognize the document that I have placed before you that is labeled 450 Yankee?
I do.
All right. How do you recognize it?
This was an email that was sent to me, like I said, in November. And it was, when we receive a letter of this nature, it's sort of an inquiry.
Without getting into all of the details, is that an email that I sent to you on November 30th?
Yes.
All right. Is there an attachment to the email that is also a part of State's Exhibit 450 Yankee?
Yes.
All right. And did that attachment also make its way to you in that email on November 30th?
Yes.
Is that a fair and accurate copy of both the email and the attachment that you received from the state on November 30th, 2022?
Yes.
Your Honor, the state tender states 450 Yankee is evidence.
It's admitted.
Mr. Wright, would you please read the body of the email itself? And by the body, I'm talking about, yes.
Good afternoon, Attorney Wright. It's always good speaking with you. In the event that your client wishes to speak with the state, in this case, I've attached a standard offer letter for your consideration. Please let me know if you can provide any further assistance. Adrian.
Now, looking at the proper letter that is attached. All right. With the court's permission, I'd like to publish the proper letter. It's a blank proper letter, but it's a, thank you. And for the record, this will be pages 2 and 3, I believe, of State Exhibit 450 Yankee. Are we signed in to Zoom? Thank you. While we are pulling that up, with a simple yes or no, is a proffer letter the same thing as a plea agreement?
No.
All right. And is that distinction made within the proffer letter that you received?
The general language distinguishes between,
Scroll up to the first
or
one.
at least makes it clear that this is not in itself a plea agreement. This is really just an agreement to start having conversation between the state and the client.
Mr. Wright, are you able to see the first paragraph of the proffer letter that is before you on the screen? Can you see that? I have some readers if you don't.
No, I'm just trying to clear this audio box.
May I approach and
Yeah,
are you now able to see it?
I am.
I don't want you to read the entire document that's in evidence, but would you please read into the record just that first paragraph, starting with Dear Mr. Sledge?
If I just read off the letter itself.
That is fine.
Dear Mr. Sledge, the Office of Fulton County District Attorney, Atlanta Judicial Circuit, has been informed that you may wish to make a proffer for the purpose of providing information that you may have regarding the individual or individuals involved in the enterprise Young Slime Life hereinafter YSL, or otherwise have information regarding your own involvement. This is not a cooperation agreement or a plea agreement. The following terms will govern any proffer session with you.
Okay. Now, without going into each of the terms, was a requirement of the proffer agreement, and starting with this particular one, that Mr. Sledge actually sit down and have a conversation with you present, along with an investigator with the district attorney's office and a prosecutor from the district attorney's office.
Yes.
And based on the request made on November 30th, 2022 to you, was Mr. Sledge's complete truthfulness and candor material conditions required in this proffer?
Yes.
All right. Did the proffer letter inform Mr. Sledge that if he knowingly withheld material information or willfully made false or misleading statements during the proffer, any statement made or other information provided during the proffer could be used against him in a subsequent proceeding against him for perjury, obstruction of justice, or making false statements to law enforcement?
The letter does give that notice.
Okay. Does the letter also inform your client that if he or any person acting on his behalf subsequently takes a position in any legal proceeding that is inconsistent with what is contained in the proffer, whether in pleadings, oral argument, witness testimony, documentary evidence, questioning of witnesses, or any other manner, the district attorney may use the statements in this proffer and all evidence obtained directly or indirectly in any argument and for cross-examination, impeachment, or rebuttal evidence?
does say that.
All right. Barring those circumstances, was it your understanding that the proffer would be used against your client?
Generally, when we do a proffer, it's sort of a, whatever you say, it's sort of a, what a queen for a day. You get to say it.
Explain
without-
Queen for a day to the jury.
You get to basically say whatever you're going to say and it not come smack you in the face, meaning it's not going to be used against you and hit you over the head with whatever you tell them. It's a way that the state evaluates the information that you have without you being in a position where, well, now that we've had this conversation, you're using it against me. Well, I never should have said anything to you. So that is, the proffer is designed to sort of both sides be able to feel where the other side's coming from without anyone lessening their legal position.
And have you just described what your understanding of this proffer agreement or proffer request was?
Correct. Any proffer on state, federal, I sort of hold that general opinion.
Okay.
It's a case-by-case basis, whether it's good or bad.
So let's talk specifically about the language in this proffer. Does paragraph 2 of this proffer read, the office of the Fulton County District Attorney herein after referred to the district attorney requires complete truthful statements from you. Any statements made by you at this proffer cannot and will not be used against you in any grand jury proceedings or at trial against you in the district attorney's case in chief. No statement made by you during this proffer will be used against you to increase any future recommendation by the district attorney as to an appropriate sentence for you should you be charged in this matter. However, this agreement does not apply to any previous statements you made to law enforcement officers.
Your Honor, I'm going to object under relevance and also 403 waste of time.
Your Honor,
Yes.
as it relates to questions on cross-examination about whether or not a request was made to sit down and speak with Mr. Sledge and Mr. Sledge's answer, the contents of a request to sit down and speak with Mr. Sledge and the circumstances or the requirements are relevant for the jury to assess any information they hear from witnesses on the stand.
Okay, well, they've heard that occurred, so move on.
Thank you.
Sustained.
Thank you. Did your client agree to sit down with the state before entering into plea agreements with the state?
You know, I don't have any memory of us actually doing the proffer. I was going to ask you if you have a signed proffer agreement. That might help refresh my recollection. I remember receiving the proffer, at least the proffer letter. And then later on, we ended up in a plea negotiation, but I don't recall us actually executing the proffer process before that.
Do you recall any verbal communications with the state conveying that your client did not wish to give a proffer? Do you recall any?
Hang on.
Objection, Your Honor, leading and suggesting an answer.
I'm not suggesting an answer. It requires a yes or no answer, but it does not suggest one or the other.
Overruled.
Do you recall any verbal communications with the state?
Again, because I don't have any recollection of actually doing the proffer, I do not think that we were in a position that we accepted the invitation for a proffer. I also have a specific recollection that a few weeks later, I then, based on some things which were sort of happening with the case, reached out to you, knowing the proffer had been extended and knowing, okay, I'd like to have some more discussion about maybe resolving this case.
Okay. Did any part of that involve your line or your client agreeing to sit down with me to have a discussion before he entered into a plea agreement?
I just don't have a memory of having a conversation with you prior to the plea. So at this point, I would say I just don't recall that. If it did occur, if you can refresh my recollection, but I don't recall there being a meeting between you.
If your client wanted to meet with the state, would you have arranged it?
Well, yeah, we certainly, if my client had expressed an interest, then I would, of course, it'd be my duty to follow up on that.
And would you have, based on your practice, would you have sent that via email? How would you have conveyed?
It may have been a phone call, but more than likely I would have emailed, so I would have had something in writing to confirm it. And if there had been such a meeting, there'd be a signed proffer letter, because I would have wanted the protections of the proffer letter in place before that meeting. I wouldn't have put them in a meeting without a proffer.
Have you had an opportunity at my request to go through all the correspondence between you and the state as it relates to your client and this case? And let's stop there. Have you had an opportunity to go through your correspondence?
I have.
Is there any email, note, letter, designation from you that you were able to find that gives you any belief that your client at any point wanted to sit down and talk with the state?
No.
I'm going to show you what, in your honor, we will, pursuant to conversations outside the presence of the jury, modify 460 as necessary. But as I'm going to show defense counsel 460, I would like to approach the witness after they've had an opportunity to look at 460.
Okay. Is 460 wide?
460 Yankee. Thank you, Judge. For the court's edification, we're reviewing the paper packet that I provided the court in the defense yesterday.
I apologize, y'all. They dropped. They dropped down. And I'm sleepy. Come on, go ahead. We're gonna put it on. Ooh, they open. Yeah. Did y'all hear what I told y'all yesterday about open? That's a real one. What is going on? What is this? This a raggedy ass case, child. There's so much going on. Ooh, honey. Mm. Y'all, my appetite. Y'all know what I want? I want me some fried chicken that you find at the buffets. Oh my goodness. That's what I want. I've been thinking about it too. And guess what? I want a piece of breast meat. I don't know what the hell. Okay, let me see. It's crazy. That's what I'm at.
Without reading out loud, anything that's on 416, do you recognize correspondence from you to the state contained on 416?
believe so, yes.
Correspondence that was sent to the state at my request this weekend. Did you find anything as it relates to this case in addition to what's contained in the
I did. Ultimately, what I was sending to you in that exhibit was some of the stuff I had found to make sure that I guess everyone was on the same page as to what our correspondence was.
and show you 461 Yankee and 462 Yankee. Now, talking about the sale, are those issues?
Yes, this does look like an email that I sent, which was a compilation. Same kind of thing, sending you old emails regarding this case.
See anything between Stacy 460 Yankee and 461 Yankee?
I do not.
Do you see any difference in issues?
I do not.
I'm now going to ask you to take a look at 451. Would you just take a look at 451? Does 451 Yankee accurately reflect correspondence sent from the state to you on December 27, 2022 at 4:57?
Yes.
Looking at 452 Yankee. And when you look at it, after you've read it to yourself, would you tell the jury whether 452 Yankee accurately reflects correspondence sent from the state to you on December 27, 2022 at 5:06 p.m.?
It does. I do not.
Looking at 453 Yankee. Does 453 Yankee accurately reflect correspondence sent from the state to you on December 28th, that's Wednesday, December 28th, 2022 at 1:45? That's 453 Yankee.
This appears to be an accurate copy.
Recognize receipt of alterations.
I do not.
Showing you 454 Yankee. Does 454 Yankee accurately reflect correspondence sent from the state to you on Wednesday, December 28th, 2022 at 1:46?
It does.
4:55 Yankee accurately reflect correspondence sent from the state to you Wednesday, December 28th, 2022 at 1:54 p.m.?
Does.
And showing you State's Exhibit 456 Yankee. Does 456 Yankee accurately reflect correspondence sent from the state to you on Wednesday, December 28th, 2022 at 2:34 p.m.?
It does.
And showing you has been marked already as State's Exhibit 1AS. Do you recognize that as the
Yes, sir. It appears so. No.
Is a document that for purposes of that document signed and agreed to before or after the documents that you just
I'm sort of lost. Your question is, were the last two signed after receiving the other ones? That's what I'm not sure.
Yes. Overruled.
So the document that is 1AS, that's signed after State's Exhibit 450 Yankee was transmitted.
Oh, let's not do them individually. Just ask the question again and maybe he'll understand it next time. It's just a time sequence, right?
So, my question to you, the document that is labeled 1AS, that's signed and agreed to before or after, before any of these documents that you just reviewed were transmitted. That's my question.
Let me answer it this way. I want to make sure I'm on the same page.
How about asking for clarification?
How about let him answer and maybe he'll be able to answer what it is that you're trying to get at anyway.
The documents you've been showing me were all drafts of the plea agreement that were works in progress. as we were proceeding. First couple were the day before the plea. That's why they're in the evening. Then when we showed up to court the next day, while I think the format was y'all were in the conference room, I was in the back and shuffling back and forth, but you would email me and that way I would go over the different versions with my client. But what you just showed me were different versions which were evolving as we were getting closer to a plea agreement that we would execute and sign. The signed one, which is this 1AS, was the final version that ultimately got executed, that he signed, and you could see, I guess, with Judge Glanville, when we did the plea, that was the one executed. Ultimately, I have some concerns, but I'm acknowledging this is what we signed. This is what we ultimately did for the plea agreement, and the other renditions or iterations were showing the progress going from point A where we had no agreement to expressing what our concerns were to getting an agreement hammered out. Is that so? All those were before this one. Okay.
Did the state ever request to talk to your client without you?
No.
Did you ever offer up your client to talk to the state without you?
No.
Was the only way that the state communicated with your client through you?
Correct. Either through me or with me present, but not by himself.
At the point where December 28, 2022, where this case began trial, were there options that you had in terms of going to trial and or asking?
Again, let me answer it this way. I'm not trying to be difficult in explanation. Legally, yes, we had options for the trial. Those things all in a very mundane, simplistic way, yes. But then as a practical, my client didn't have the resources where he could hire me to conduct a year-plus trial. So those resources weren't there. So he also expressed other concerns he had unrelated to the trial. So you'd have to ask him. There are a lot of different factors that go into that. It's just not a simple yes, no. But yes, did we have different legal options he could choose? Yes. But why he made the choices he made, that's something you'd have to ask Mr. Sledge.
And were you in the state to stay in here during the time of question?
Yes.
And when you spoke about your client not having the resources, did you ask to withdraw from the case?
I did not. Ultimately, whether or not I would ask to withdraw and remove myself so that we either try to get appointed counsel or get new counsel, that would come after he makes a decision of what choice does he make among his different choices. Because he chose to go forward with the plea, then we never reach the issue of that.
And did you ask for a continuance?
We did not. Well, I don't believe we did. However, I think I had them fully clear. You can double try, but I just want to say it might have been, it was right around that time frame. In fact, I think I had just finished the jury trial, so I think I was already clear. So no, let me go back. We did not ask for a continuance.
And did you convey to the state certain things?
Hey, Mo.
Yes, yeah, understood. What I'm saying is we definitely discussed different things that based on where my client's position was, where the state's position was, some things we were able to work out as demonstrated in the different iterations, and then there was something.
And Mr. Wright, my question is, were there things that your client insisted, or that you insisted on behalf of your client, that the state changed?
Yes.
Were there things out of line to
I'm going to say yes, and here's the explanation. Almost all the things we asked manifested itself in iteration number 3. That was the version before version 4, which is the one that ultimately got executed. So when we were looking at version 3, we saw everything and we're good to go. Version 4 introduced item number 8, which was not what he wanted.
And is version number 3 the one that is marked states exhibit 456A?
No, this is not. And I'm referring to version number 3. Okay.
Exhibit number, which one you're referring to as version number 3? I'm going to remove 456.
Your Honor, excuse me. Before the witness answers that question, do you mind if Mr. Shaw and I step take a look at the exhibits? Just not sure that we have.
Sure. Yes.
And if they have the one.
I think it's for which one is which.
I did name them.
I know.
Your Honor,
Yes.
excuse me, I appreciate that it's early in the day, but could we just have
Yes,
5 minutes?
Yes, let's take our morning recess while we do this.
Thank you.
Good idea.
These are-
sure they can do that. I mean, I think these are the things that were originally sent over as electronic copies, and that maybe, and they were like a file within a file kind of thing. So that's probably what the complication is. Yes, you may.
Your Honor?
Yeah, and we're going to take a, yes.
I was going to, because they're going through the documents, and I shared with counsel for the state when she came up, the document I believe I was looking for is 455 yen.
Okay.
But I'll confirm it when I get them back.
Okay.
But that's the one that I think is the one that I'm looking for.
Okay, well, you'll get them back and we'll do that in front of the jury.
Yes, Judge.
I mean, you can certainly look through them, not in front of the jury, but we'll confirm whichever one it is once we've got the jury back. Okay, so we'll take like 15 minutes so y'all can take a look, and everybody who needs to can use the restroom. Yes, sir. I think it, up at the bench, I think it was not these documents necessarily. Oh, yes, it was. Yeah. It should be somewhere within one of those documents. So are you going to tender those for admission, or are you just going to have the witness talk about them? Okay, but I think there's an issue with regard to what ought to be redacted. Why don't y'all just talk? And then if y'all can come to agreement, great. If not, then we'll take it up. So, 10:30, I'll plan to come back. Okay.
They breaking it out red light. Oh my gosh.
Okay.
What we discussed at the bench regarding State's Exhibit 460. And State's 460 is the paper copy of Mr. Sledge's email, Mr. Wright's email.
Right.
On the next to the last, I'm sorry, the last page of State's
Yeah.
460. And Mr. Sharp is standing next to me, so if he has that, he can pull it up and confirm that I'm getting this part right. There was an issue at, you wanna look at mine?
I don't. Continue. I was trying to interrupt. I don't have 460 printed out, so I'm just.
Okay, go ahead.
Okay, so at the bench, there was an issue, number 4, does the court have its copy?
I do.
All right, so there was no problem from counsel for the defense that actually voiced any concern about the first full sentence.
Uh-huh.
The concern voiced by Mr. Adams, I think echoed by Mr. Sharp, was the second full sentence. And then they wanted to keep in the third and the fourth sentence. What I told them was that sentence, that number 4 was made in response to the email, and you can tell that from the time and date that it was sent. That was sent in response to the email that was sent to Mr. Wright, and that was dated December 27, 2022 at 5:06 p.m., which was State's 452 Yankee. The email that contains, and it may have been that we did include it twice. So Mr. Wright sent us an email on December 27, 2022 at 8:43 p.m. in response to the email that I sent to him that was subject Sledge Agreement updated. And in that email, Mr. Wright enumerated 1 through 8 regarding factual acknowledgments. 452 is the email he was responding to that the state has sent. And number 4,
Yeah.
yes. And so to the extent that the counsel for the defendants have all indicated during the break that they would like redacted from any prior iteration, anything that was not included on the final State's 1AS, the final plea agreement,
Uh-huh.
to the extent that number 4 on State's 452 Yankee gives context to that number 4 on State's 460, it would be necessary to be included to show that that was something that the state put on there that it believed to be true, that Mr. Sledge said no, and this was his response through his attorney.
Okay, so I'm confused now. On the different iterations that lead up to the final agreement, I understand that one of them is this number 4 that the state was proposing that he say
That he was saying.
that he, Sledge, had personal knowledge that YSL Associates were planning to murder Donovan Thomas Jr. And that is not ultimately what number 4 said. But are you saying that,
In response,
are you saying that the defense wants redacted the earlier version of number 4?
yes.
Yes.
I think we're going way down the rabbit hole. The state seems to be, we don't need any redacted.
Well, I think it is going to be admitted or at least tendered for admission into evidence. And the reason that it is at issue is because Mr. Sledge said there were things that I absolutely wanted changed that didn't get changed. And this establishes that there were very material things that would have been beneficial to the state that got changed because Mr. Wright and Mr. Sledge requested that they be changed. So I understand why that is relevant. I mean, if these are going to come in, I would certainly think that we need an instruction that they're not to take any of this as factual, because it's not in fact what he ended up agreeing to.
I agree.
Yes. Yeah. Okay. Mm-hmm. Mm-hmm. Right.
Is purely forced from anything Mr. Sledge stated. Okay? There's nothing that Mr. Sledge said, okay, this is my story, and then the state came up with these factual acknowledgments, and then Mr. Sledge was like, oh, well, you don't have that quite right. This is what the truth is. These were drafted by the state.
Okay.
So if I would ask if we're letting basically incorrect, I'm going to say incorrect information that Mr. Sledge has never agreed to, and we're going to expose the jury to this. I think we need to be more stronger with the instructions to say these were drafted by the state and not based on anything Mr. Sledge said. Because I've been doing this for a while.
All right, I get your point. I get your point. And y'all, this is why I had us come a half an hour early, is because 8:30 to 9 was when we were supposed to be figuring out what was coming in, etc. But so Miss Love, are you not in agreement with redacting things that didn't ultimately come in to the final agreement?
Correct, for the reasons that the court earlier alluded to, and also.
All right, and you do realize that some of what might come in like this, if the version of number 4 comes in that is a proposal that YSL Associates were planning to murder Donovan Thomas Jr., that there are concerns with putting that.
I do want to hear the court. I do want to understand fully the concerns that all of them that exist. And ordinarily, I would simply leave it at this. Yes, I know there are concerns, but in as much as Mr. Sharp has indicated that, well, his version of reality, mine differs slightly, and I would not go so far as to characterize.
I'm not going to give an instruction that says this is not based on anything. I am going to give an instruction if this even comes in.
This comes in. I think the jury would want to know, well, where did the starting point come from? And the only way we could bring it to the jury, because I didn't really know until this morning, to be honest, where the starting point was. It's always been a question mark. How did these get the first version? Where did it come from? The only way we could really bring that to the jury is to call the drafter, acknowledge
It's,
who I assume is Ms. Love, and ask, well, these acknowledgements that you drafted, when did you draft them? Was it based on anything Mr. Sledge said, or was it based on the discovery? Because, and I'm being right here in the office. I've never been a prosecutor, but I was under the assumption that there was something that Mr. Sledge said that led to the first statements, and then it was like an editing process. But the first version was not based on anything Mr. Sledge said. And that's important. Because the jury has to determine, okay, did the state just come up with these? Did Mr. Sledge say certain things in the back and if we don't make it clear to them that Mr. Sledge is not the genesis of even the first version, I think that question becomes unanswered, and the only way other than an instruction would be to call Ms. Love.
All right, Ms. Love, what's your response?
Your Honor, one, again, the idea that
All
this,
right, I don't need like
I'm not
a
trying to go-
full-blown
my response,
rehash of everything. What is your, let me re-ask. What do you propose?
I propose that the court instruct the jury that it is to take as fact no information contained in any iteration of the plea agreement unless that assertion or that factual acknowledgement is in the final version to which Mr. Sledge.
Let me ask you this. Would you be able to get essentially the same information before the jury? And I believe the information you want before the jury is that very material things about the factual acknowledgments were changed at the request of Mr. Sledge and Mr. Wright. Is that essentially the point you want to make?
Blandly, yes. I think that I would rather ask Mr. Wright, did the state ask, because essentially that's what we're doing, because we couldn't sit down with him. Did the state ask your client if he had personal knowledge that the murder of Donovan Thomas was pre-planned by YSL members? Did we ask him that? And did, through you, your client, tell us no? Did he say no? He
So
doesn't
what
believe that the shooting was,
he says he did not know.
right.
He thinks it was not planned, but more impromptu, or at least very short or little planning.
Right. So we don't need all of that.
What's his basis for knowing that? I mean, that's part of their problem.
That it was impromptu with little planning?
Uh-huh.
Well, because he was at the house with, if we're talking state's theory, because Mr. Sledge still has not met with us, but if we're talking what we believe is that everybody was talking about it. They were at the house. We have more than one witness who says at Defendant Williams' condo, they met up. And
After
it was
the fact.
Yes, after the fact. And they talked about it. They talked about catching.
Okay, they could have talked about it and it never come out whether it was planned or not.
And based on the conversations, this is what I have gathered, based on the conversations that Mr. Sledge was privy to, his understanding was that it was not pre-planned. And that is the reason when he says what he does, that he says it. So we're not trying to get into what he thinks. We'd be sufficient with, did we ask him that? Did he tell us no? Did we at first have something
Okay,
to
so
that
I think
effect
that's a
in
lot
it?
safer way to go about it is, did we ask him that and did he say no?
And did he
And leave it at that and not follow up on, here's what he thought instead.
I
Okay,
completely agree. But
okay,
the
well,
part
that's
that
not
I
what you
think is
said a minute ago.
okay.
So
The part that
go ahead.
the part that I'm concerned about and would like to also put before the jury was, and did we include that question as part of the factual acknowledgments initially? Is that something that he absolutely said no
Okay.
and refused to acknowledge and had insisted that we change?
All right, so it seems like if y'all the defense wants in portions of number 4 that maybe the sentence at issue could read, he thinks shooting Peanut was not planned, and then redact the remainder of it. Because that shows that he is saying, no, what the state is asserting is not true to my knowledge or belief.
And if the court lets me leave Mr. Wright, I can say, did he tell us? No. Did we
Okay.
ask him, did he have personal knowledge it was pre-planned? Did he tell
Okay,
us? No.
but if we're talking about how to redact 460Y if you
Okay. I see.
tender it,
Yeah.
then that would be, I think, a much safer redaction.
So taking out everything except he thinks the shooting was not planned?
No,
or
taking out, leaving in everything except, but more impromptu or at least very short or little planning. Mr. Sharp.
Well, I just have concerns with the state. Here's the state can have their theories. Mr. Sledge on the stand has said no one talked about the murder. Okay, they talked
Right.
about
At the
Mr.
coffee
Kahneman.
shop.
Yeah, no. At the
Oh.
no. They talked about Mr. Thomas had passed, but no one was saying this is what happened. There was no
Right.
discussion. So when you ask someone, if Mr. Steele asked me, hey, was that murder pre-planned? And I say no, then it insinuates, it gives the impression that I know about the murder. That I have some information about the murder.
Yeah.
And that's my problem, is just saying that in a vacuum.
Okay, so how about, the beginning of what he says is really the answer. He said he did not know, and the rest of it is elaboration.
And Judge, the
Hey, Purple.
portion that was, okay, so based on what Mr. Wright wrote back to me, we included a line that was not initially included in the previous iteration that I think is 452Y.
Okay.
And I think that line is number 8. And we drew the same exact conclusion number 8 of 1AS. Number 8 of the document that did get admitted, which is that defendant personally knows that one or more YSL associates committed the murder on behalf of YSL. So based on the response that we got from Mr. Wright, from Mr. Sledge, that was what we concluded too, and that is why we put in here number 8, which is different, and it may not be in the prior iterations, but as we went back and forth,
Okay. So, I think that it would be safer in terms of what gets put before the jury if you do this through question and answer with Mr. Wright. Would you be, you let me know whether you're going to insist on tendering, but.
I'm certainly not going to do anything the court says don't do.
Well, I'm not telling anybody how to
and I know.
try your case. That's not my job to do.
Understood. I'm not going to tender it before the lunchtime hour, at which point, if there is an issue that we need to hash out or I need to say.
Okay.
But at this point, I am very much intending to handle this verbally with Mr. Wright on the stand, because I think it's something that I can do clean.
All right. Is that going to be true with regard to also not tendering the different versions, just talking about them?
Right now, yes.
Okay. Yes, sir.
Let me just point out that in regard, and very briefly, because I don't want to, go back over everything we just discussed, but number 8 is referenced by.
You're going to have to give me some
number
8 on which.
1AS, the final iteration.
All right. I don't even have that in front of me, but I know it is. I just, there's a lot of evidence in this
It
case,
is.
and I only have 2 screens. So
It's the
give me
one.
a second. to
Right, I
give
can
it-
orient the court if it helps.
If you'll just give me a second. Okay, that works too. All right. Go ahead.
So 1AS, Section 8
Yes.
is the portion that Ms. Love just referred to, where she says that we made changes to the document based on what Mr. Wright said back to us, and so we came up with 8. The
Right.
defendant personally knows. Well, if the court recalls, that is what they asked Mr. Sledge about when he was on the stand, and he specifically disavowed it. He said, no, that's not accurate. That's not true. And so if we go back to what we talked about earlier this morning at the bench, my simple request was just that, and I think we may have reached there. I kind of got lost a second ago. Is that in regards to them sending this iteration and Mr. Wright sending back the response that shows up in number 4, right? Number 4, where he says he said he did not know. That's the answer to the question. And I think that's where the court ended up. That's the only.
No, where the court ended up, and we talked about that yesterday, was the he said he did not know was to the version that the state had proposed that said this was planned beforehand. And the answer was he doesn't know that.
It was not planned, but more impromptu, or at least very short or little planning, is because that is speculation. That's his opinion. The fact, and you agreed earlier that.
Yes, with regard to whether it was planned or not, that's a separate issue from whether he knows personally that it was done by a member of YSL.
But maybe I'm just not understanding, because I took the court's previous ruling. I thought that they were going to redact. As a matter of fact, they agreed that they were going to redact that particular sentence. That's the only thing that we objected to, because that our position was simply opinion. It was speculation. The fact that it came from Mr. Wright doesn't make it any less speculation as to him trying to explain why his client thinks that. But we asked that be kept out. We agreed, and we thought that that part was not going to be read to the jury or presented to the jury.
I don't think that part has changed.
It was the email, but that's what we discussed, because we were discussing whether or not these correspondences, including the emails, were going to be presented as evidence. The state said, well, we don't know, we might, we may, and our position was that, well, if this gets presented, we don't want that line should be redacted, just like the other line where they proposed the line about
What he had said.
Right.
Yeah, right. And that's what we're talking about right now. But that's an entirely separate thing from what number 8 ultimately ended up saying. So if Ms. Love is going to somehow get from whatever it was he said,
Number 4, Ms. Rice.
if she thinks she can get from it was pre-planned, no, he didn't know that, he couldn't say that, to somehow that answer being the basis for putting in he personally knew somebody did it. I mean, I don't know how she's going to get from one to the other, but obviously that is what they ultimately decided was okay to sign, and y'all can cross-examine Mr. Wright on that.
Your Honor, I'd also point out that how we got where with any of these assertions is not relevant or pertinent to whether or not the defendant, it does not make more or less likely whether the defendants did or did not do anything here. So how we got to any of these, in my opinion, is not relevant.
Well, Ms. Love, you're the one that's putting them all into
I'm
issue
putting
right
them-
now.
I'm putting them into issue to impeach what Mr. Sledge said regarding his, regarding whether his.
Okay, so I think that you can ask a few more questions that establish that, yeah, there were very material alterations made from what it started to what it ended up with. And they were made at the request of Mr. Sledge. But frankly, you even have Mr. Wright on the stand saying, but there were other things that the state wouldn't change. So how you deal with that is up to you, but
Since I want him to put in front of the jury everything that he recalls as being true, I don't care about the truth getting in front of the jury. I am talking about this idea that the state.
well, the easiest way to do that is, so what was it that you wanted changed that didn't get changed?
Right.
And then Why is it that well, that would be speculative, and I just said I wasn't gonna tell y'all how to try your case, but, okay. So we are not at this point going to be admitting any of these.
We're not
just gonna be
tendering them.
discussing them with him.
At this point, correct.
All right, yes, sir, Mr. Steele.
Your Honor, just to follow up on, I believe Mr. Shar said, would you also go through an analysis of confrontation clause, because the statement now comes from a party opponent and it's used for litigation. It is a clear, to me, bullseye on confrontation clause. So it's really Ms. Love who should be testifying if the state wants to get that in, because that is a confrontation clause, because where it came from, all those questions cannot be cross-examined to Mr. Wright.
Well,
Second-
okay, I'm sorry, I thought you were
No,
finished.
second part, and I apologize, I'll be very brief. Second part is a 403 analysis. You know, it's like saying, Ms. Love saying to Mr. Adams, who represents me, did Brian Steele destroy the murder weapon in your presence, or in the presence of Mr. Harvey? And then Mr. Adams responds, no. You know, that's really bad for a jury. That is really bad, and that's really what's going on. So I would ask you to just limit it. The point is what you said. Did the state give ample opportunity to Mr. Sledge through his counsel to make amendments? Answer, yes or no.
Mhm.
Did the state make those changes? Yes or no? And he might say some not. And we may have to go into a portion by portion, but otherwise, I think that it's a wrong witness. There's a confrontation clause, and I think it's very prejudicial for
Okay.
Your Honor, we've had the witness on the stand that made the statements, that signed them. We've inquired of him. He's
I
made
think that
some.
does take care of the confrontation clause issue. And with regard to 403, I mean, I agree. We've spent the whole morning on this, and let's target the questions to get to the cogent issue, which is, were they able to make material alterations upon request? All right.
Yes.
Okay, so we ready to get the witness back in and the jury back in? Yes?
I mean,
I have a heater that he can use if he's cold,
oh no, I mean,
so we don't turn it down.
so, I was just gonna-
I'm good. And Ms.
And a couple of the jurors who are fanning themselves because they're too hot. But yes, it's not an idea to determine the reason.
no, I'm good. Thank you.
you able to discern, are you able to tell whether, and I'm putting in front of you states 460 Yankee, which has been admitted as evidence. And are you able to determine if 460 Yankee was sent in response to 452?
I don't know that that's been admitted. 450 was
452
admitted.
has.
No, I don't, did you say 460 was admitted? And it hasn't. Only 450.
Your Honor, the state without reading anything from 460, thank you, Judge. Without reading anything from 460, are you able to tell if 460, the last 2 pages, were sent in response to 452? Yankee.
I've been on here 2 hours, and yet I dozed on and off, and nothing has been accomplished with this witness unless I missed something. This is crazy.
I do not believe so.
Is there one or anything that you have
Right, Mo.
heard of that occurred between when 452 Yankee was sent to you and 460 Yankee was sent from you?
Okay.
Without saying what it is, because we have internet things. Do you have a record of any correspondence that occurred in the minute?
The record would be, I'm reviewing my emails, and without going into the content, there's what I saw and had on the 27th of December, and then what we were interfacing back and forth on the 28th when we were in court.
Do you, looking at 452 Yankee, is 452 Yankee, did you say earlier that that accurately reflects an email sent to you on December 27th?
I did, but I'm looking and thinking,
Right, Mo.
there were at least 4.
Real quick. So yesterday, she paints herself into a corner. Okay, and I told you that she was gonna try to get herself out that corner at some point during this trial, but she couldn't wait. So she got this witness who's a lawyer to start that process. Now I've been falling asleep on and off. I can tell you that. I've been go eat the last little bit of expired Alfredo, and I'm gonna call it that today, right? Now I'm gonna still be on him, but that's what I'm saying. I'm gonna probably follow him out, okay? Cause my for some reason I told you I don't know what the hell it is with the bone in my, in my bottom, honey. It is sore, so I got to go to that heating pad. But you know, I know she want to make sure that the jury know that they're not pressuring nobody to sign these agreements, you know. But my goodness, I looked at the time and we've been on here, and I'm like, we still stuck here.
Versions, but there might have actually version, which is what I thought my response to, it looks like this may have been an updated first version, meaning I'm just seeing some slight differences. That's why I'm hesitant to just say yes, that this is it. I can't say, is this iteration that was in that process of getting us to the end? Yes.
All right. Are you able to say if there is any material change from the number 1 under the factual acknowledgement section from 452 to whatever version you're looking at that you think you might have been responding
To jump
just number 1 on the factual acknowledgement. Number 1.
okay. Number one's are,
Don't
one
say
is
what it is.
one is the same.
Okay. My only question relates to number 1.
Okay.
All right. And so as it relates to number 1 on the factual acknowledgements that you were responding to when you said 460Y,
Mm-hmm.
is that number 1 the same as in 452Y?
Yes.
Is that the same in the document that has been admitted as 1AS in a prior hearing?
Just to. Yes.
And is that the same as number 1 on State's Exhibit 444Y?
All right, we already established that 1AS and 444Y are the same document, so we don't need to ask that question for all of them.
All right. Did you convey in 460 Yankee that I have in my hand that you did now? Did you convey in an email to the state on December 27, 2022 at 8:43 p.m. that is a part of 460 Yankee? Did you convey changes that needed to be made to the plea agreement in the form that you were looking at, whichever one it is?
Yes.
Were those changes reflected in the document that is 1AS? And I don't need you to read it.
Yeah. No, I was going to say all except all the changes were ultimately incorporated. The only issue with the document 1AS is number 8.
Okay. So are there any changes that you saw need to request that you do not see reflected in 1AS? And they don't have to just be in states 460. Are there any changes in 1AS are there any changes that you asked to be made that aren't made in 1AS? Material changes.
What I'll do is,
Number by number on.
first with number 3, we indicated
Wait, you cannot say
Okay.
what's in there. I just need you to roll.
number 3.
I don't know of any ruling that the court has made that says he can't indicate what the change that he requested being made. And that's what I understand that he was about to explain.
Your Honor, it's going to get into.
So the question was, are there any changes that were requested to 1AS that were not made? So he's entitled to answer that question.
Okay.
And if you want a full answer, we don't know what he's going to say, so
He asks
is the final
So
document
that
that got
question.
signed.
Right.
So, given all of our discussions, Ms. Love was trying to be careful about what, careful. So, if you're objecting to,
She always laughs. She just, I mean, I think.
So, Mr. Wright, would you just follow along with me and let's do this exercise using only the numbers under the factual acknowledgement section in document 1AS. May we do that?
Yes.
All right.
The
So,
can I make a suggestion? 1AS is, or a version of it, 444Y is in evidence. Would it be beneficial to display it?
Your Honor, my understanding is it's not in evidence.
444Y is, and 1AS is the same document. Is it not?
I don't believe it is. And I,
Oh, it's so annoying.
Please do.
and Your Honor, if we can approach, I can explain. We already discussed this at the bench.
Okay. No, you're right. I remember. Okay. Never mind.
just saying numbers,
if we could just use numbers
I would say.
and was there a material change as it relates to number 1 of 1AS that you requested that was not reflected in number 1 of 1AS?
No,
Is there a material change to number 2 of 1AS under factual acknowledgements
no,
that you requested that was not made?
no,
Is there a material change to number 3 of states 1AS under factual acknowledgements that you requested but was not made?
3, yes.
So we'll put that down. And we'll come back to it. Was there a material change to number 4 in states 1AS that you requested that was not made?
No,
Was there a material change to number 5 in states 1AS under factual acknowledgements that you requested that was not made?
No.
That Mr. Sledge requested that was not made?
no,
Was there a material change to number 6 of State's Exhibit 1AS under factual acknowledgements that Mr. Sledge requested through you that was not made?
no,
Was there a material change to number 7 under factual acknowledgements as reflected in States 1AS that Mr. Sledge requested that were not reflected in number 7 on 1AS?
no,
Can you just say same question for number 7, same question for number 8?
Okay. Same question for number 8.
Yeah,
And if I
same.
think number 8
Yes.
wasn't on a prior,
and yes, but, and again, it wasn't on a prior edition, but it
was on the
added to
last.
this one. So, but
So I can't,
the subject matter was one of the things we said.
okay. So, Your Honor, I can't ask the same question. Okay.
Well, then don't ask the same question.
Number
It's not the
9.
same question.
Was there a material change regarding number 9 that was requested by Mr. Sledge through you that is not reflected in number 9 under factual acknowledgements of states 1AS?
No,
Is there a material change to number 10 on states 1AS under factual acknowledgements requested by Mr. Sledge that was not made on the final document?
no,
Same question for number 11.
no,
Same question for number 12.
no,
Same question for number 13.
No.
Same question for number 14.
No.
Number 15, same question.
No.
Number 16, same question.
No.
As to the sentencing acknowledgments that are reflected in states 1AS under section 5, did you review those? Are you comfortable telling the jury whether or not you went over those sentencing acknowledgments with your client? Just yes or no before you explain anything.
I would have went over the entire agreement, including that section, yes.
Okay. Did you allow your client an opportunity to ask any questions that he needed to ask?
Yes.
Did you restrict his ability to ask you questions?
No.
Based on your knowledge of over 15 years of interacting with your client, did your client appear
Understand.
comfortable asking you anything he wanted to ask you?
Yes.
Did you answer your client's questions as thoroughly as you could possibly do in your capacity as his attorney?
Yes.
Did you answer them in a way that, based on your 15-year knowledge of him, you believed he fully understood?
I hesitate. My answer would be yes, but again, I'm not a mind reader. So other than perceiving his responses to me and that he seemed comfortable, I can't purport to say what all is going through his mind.
I didn't ask you that. I appreciate your response. I appreciate your clarification. So I asked the question I did for a reason. Based on your 15 years of knowing him, did he give you any indication that he did not understand any one or more of the provisions under number 5 sentencing acknowledgments, which are in 1AS?
No.
And when you said yesterday that you had represented Mr. Sledge in 2 cases over the last 15 years that were felonies and 1 that was a misdemeanor, would you explain what it is, how you're able to determine when he doesn't understand something as it relates to a plea, and how you're able to determine when he does understand something? What does he do when he doesn't understand something?
Well,
Your Honor, I'm going. Same objection.
Sustained.
How do you decide that something needs more clarification when you're interacting with Mr. Sledge?
with Mr. Sledge or any other client,
I just need Mr. Sledge.
well, the point is, I'm going to state what's, I guess, in front of us in terms of what any particular paper is going to say. Make sure that it appears to me that he understands it. Give him an opportunity to ask any questions if he doesn't understand it. And then in a document such as this, where he's going to initial, that's just another way of him indicating that he has seen it, he's had an opportunity to discuss it with me, and he doesn't have any questions that we need to address to court or follow up.
And do you pay attention to body language when you're asking him if he understands something?
Yes?
Do you pay attention to pauses?
Oh
or
my
hesitations
God, this
when he
is
responds
overkill.
in order to determine if he just doesn't want to say it or if he really understands it?
I don't speculate and go that far.
Uh-huh, yes.
I'm trying to get a direct response so that I know how to proceed. But I understand your question, but I'm saying I generally am not going to try to surmise based on just body language. If there's something that creates a red flag for me, then I'm going to follow up with a question.
Yeah.
Your Honor, I'm going to ask a question that's going to harken back to something yesterday. It's going to sound not relevant. I ask the court's indulgence for a moment for me to ask this question. You remember yesterday when you were telling the jury that a particular question sounded like a hot topic, and I asked you, what did you see from me
Mhm.
that made you think it was a hot topic.
Understood.
Okay? So when you're talking to your client, what do you look for to see or make you feel like he does understand something?
I'm listening.
Well, Mo, with that last question, um, does this line of questioning not support Monk's claims that they asked for changes and the state refused? One of you just asked me this. I forgot what you call it. Ask a question that you want answers. But I believe that what she is doing is that what she her line of question and what she's establishing does support her side of it. You know, um her side of the story, because it shows that they did with all those different agreements, and you know they're pointing out when he asks for something to be changed, and they sent it back. Only thing he said that wasn't done like that was question 3. He said it was the issue with question 3. I don't know what the issue was, but and also if the state, okay, sometimes you were some you know they try to negotiate an agreement with you, and you're not, now you may allow certain things but you might not allow other things. He could be referring to the other things that they didn't agree to. Okay, so they're not going to change everything he said if they're not in agreement with it. So then that's when the negotiation starts, and then usually the government doesn't budge, and the defendant signed the agreement, as is. You know what I'm saying? So,
And
To object, I believe that question has actually been asked and answered.
Sustained.
Nonverbal cues that you look for to see whether or not your client
oh my
understands.
gosh.
I would say yes. I mean, I'm looking at their facial expression. Do they seem to be very clear on what we're discussing, what the topic is, what their response is, and obviously, if the client is very emotional, that's the more obvious. But I'm just trying to make sure, have you heard it? Do you understand it? And what is your answer? And then ultimately, we go from there.
Have there been instances during this plea or any other with Mr. Sledge where he's asked you the meaning of certain words that he did not understand?
I don't have a specific recollection.
Rhetorical question. That's what it is.
However, any time definition.
Beyond it being something you referenced in
No, I'm hitting buttons.
And so at the time that this document was being read into the record, were you paying attention?
I was paying attention, but I missed it. So apparently not good enough. Just as when I went over it with my client, which I did.
Did we miss something? Hold on. When I hit a button, hold on. Let me go back to
I can only say we missed it, and it's in there.
Oh, wait a minute. We gotta get that point.
Be taken out
Oh,
Even in
for me to ask this question. You remember yesterday when you were giving any indication that he did not understand any one or more of the provisions under number 5 sentencing acknowledgments, which are in 1AS?
no.
And when you said yesterday that you had represented Mr. Sledge in 2 cases over the last 15 years that were felonies and one that was a misdemeanor. Would you explain like what it is, how you're able to determine when he doesn't understand something as it relates to a plea, and how you're able to determine when he does understand something? What does he do when he doesn't understand something?
Well,
Your Honor, I'm going. Same objection.
Sustained.
How do you decide that something needs more clarification when you're interacting with Mr. Sledge?
with Mr. Sledge or any other client,
I just need Mr. Sledge.
well, the point is, I'm going to state what's, I guess, in front of us in terms of what any particular paper is going to say. Make sure that it appears to me that he understands it. Give him an opportunity to ask any questions if he doesn't understand it. And then in a document such as this, where he's going to initial, that's just another way of him indicating that he has seen it, he's had the opportunity to discuss it with me, and he doesn't have any questions that we need to address to the court or follow up.
And do you pay attention to body language when you're asking him if he understands something?
Yes,
Do you pay attention to pauses or hesitations when he responds in order to determine if he just doesn't want to say it or if he really understands it?
I don't speculate to even go that far.
Uh-huh, yes.
I'm trying to get a direct response so that I know how to proceed. But I understand your question, but I'm saying I generally am not going to try to surmise. Based on just body language.
Not relevant. I ask, of course, indulgence for a moment for me to ask this question. You remember yesterday when you were telling the jury that a particular question sounded like a hot topic, and I asked you, what did you see from me that made you think it was a hot topic?
Understood.
Okay? So when you're talking to your client, what do you look for to see or make you feel like he does understand something?
I'm listening.
Object. I believe that question was actually answered. Yes.
Sustained.
Are there nonverbal cues that you look for to see whether or not your client understands something?
I would say yes. I mean, I'm looking at their facial expression. Do they seem to be very clear on what we're discussing, what the topic is, what their response is, and obviously, if the client is very emotional, that's the more obvious. But I'm just trying to make sure you heard it, you understand it, and what is your answer, and then ultimately we go from there.
Have there been instances during this plea or any other with Mr. Sledge where he's asked you the meaning of certain words that he did not understand?
I don't have a specific recollection of him asking about the definition of the word. However, anytime he had a question about the content of a statement or what that means, he did not hesitate to ask it.
Did you take care to explain what you would consider legalese or legal terms to Mr. Sledge that you thought he may have a problem understanding?
Anything that is of a legal effect, legal character, I'm going to make sure he understands in very plain terms, him or anyone, what that means.
Did you go over each one of the 6 sentencing acknowledgments, both before and at the time that Mr. Sledge signed or initialed the 6 sentencing acknowledgments in States 1AS?
Yes.
And what about the last paragraph underneath that 6th sentencing acknowledgement? Did you go over that with him before and at the time that Mr. Sledge signed the document that is labeled 1AS?
Yes.
Is there anything you haven't talked about that you now can think of that makes you feel in any way there was something he didn't understand?
Objection calls for speculation.
All right, let's go past that. Thank you, Judge. When you signed States 1AS, was it at the same time that Mr. Sledge put his signature above yours?
It would have been immediately after, yes.
And on the same date that it was signed by the DA? By the Assistant District Attorney, that is?
Usually he'll sign it, I'll sign it, then I'll present it to you, and then get your signature.
Was there any material addition that you asked to be included in State's Exhibit 1AS that State refused to include?
There was no addition, no.
Okay.
Or rather, let me say, no addition that we asked.
Okay. Was there something you requested be taken out of the plea agreement that is a part of State's 1AS? And I stopped that question right there for a reason. Is there something you requested be taken out?
Yes.
And is it contained within a number?
Number 8.
Okay. And at what point did you request that number 8 be taken out?
Even in the very beginning in my initial email, we were given an indication that he did not have information.
Wait a minute, you're getting into it. I'm asking you about a time frame, just the time frame, because of.
From the very beginning,
Okay.
that was one of the things that was an issue for us.
Was number 8 included in any previous iteration
I would have,
before States 4? Based on your notes, what iteration did the date and time that number 8 first appeared in,
well,
based on your notes, and without saying what number 8 is?
understand. And let me work my way backwards. I'm going to look through the earlier iterations, but I can tell you the one before this exhibit, which for my records was iteration number 3. It was not in there. So the subject matter of number 8 had been removed from earlier versions, was not present in iteration number 3, such that it appeared again in iteration 4.
And so, would you tell me, or the jury rather, what iteration between States 450 and States 456 that agreement did number 8 first appear in, just by date and time and exhibit? If it's in there.
Was not in 451Y.
Do you understand the question I'm asking?
Well, no, I am. I'm sorry. I'm answering in a way where
So, but-
iteration by iteration, I'll be able to say if it appears at all. I do not believe it appeared in any prior iteration in that form. But I'm looking to just make sure the subject matter, if it did, I can answer your question and say it appeared in this.
if you find it, then point it out, but otherwise, just reach yourself.
Okay. In 452Y, number 4, the subject matter of that appears. It does not appear in 453. It appears in 456, also number 8. And I skipped over 455Y, but it does not appear in 455Y.
So, as you read over and initialed 1AS with your client, did you come out, did you ever speak to the state about him? That's your recollection. Request that number 8 be removed.
No, I did not. I have no recollection of seeing number 8. I understand my client initialed it, and I can see his initial. I also understand it may have been enunciated by the state at the plea, but where we went from 455Y, where it was not in there, and then it was in there, I don't know how it got there or how we missed it, because neither my client or I appear to have realized it was there and it came in.
Are you saying that you did not read this document before you all signed it?
No, we read it and signed it. I can't dispute that. But
And-
how that number, when that was something from the very beginning we were contesting, I can only say we missed it, and it's in there.
Right. And when you say you were contesting it, how did you contest it? What did you, without saying what you said, but how did you contest it?
Well, by telling the state that information, that's the subject matter of that, is not something that he has knowledge of or information on. So I'm sort of hamstrung to answer your question.
All right. And so at the time that this document was being read into the record, were you paying attention?
I was paying attention, but I missed it, so apparently not.
Yeah.
Just as when I went over it with my client, which I did, I'm not saying I didn't, but that is something that to this, I mean, it sort of was a surprise of this trial for me, was that was in there, and how did we miss it?
And when you speak of that was a subject matter beyond it being something you referenced in, you said it was, you saw it in reference in 452 Yankee number 4, and you saw it in 456 Yankee as number 8, the final iteration. Is that fair? Did I get that right? Okay. Do you have notes, or do you have email, text message, or anything that reflects, hey, 456 or number 8 on this document, not the final, but number 8, take it out.
To answer your question, going back to when this was happening, when we saw 455, it was not in there. Everything seemed consistent with what we had asked. When we were handed 456, I think we must have assumed, and I don't want to speak for Mr. Sledge, well, that 455 was what was being handed to us to execute. And we did not notice because, again, it's an addition. It's a completely different sort of addition, and it's in there. And again, I'm not disputing it is in there, but I can't explain to you how we missed what we thought we were signing, or what I thought we were signing, was 455, not 456, with that additional number 8 embedded in the factual allegations. And I don't have an acceptable explanation as to how we missed it.
Okay, so looking at 455, and you're on the last 3 questions I have. Looking at 455, is 455 Yankee number 8? 455 Yankee was the last iteration.
Correct. And I'm not going to go into it, but the subject matter of number 8 in this is different. What grade even for 50? Yes.
Okay. And does 455 Yankee have 13? How many factual acknowledgments are in 455 Yankee?
15.
And are there 16 in Stacy Exhibit 1AS? There you go.
Yes, there's 16 in 1AS.
And beyond was there anything in particular about number 8 on 1AS that you brought to the state's attention at any time before now?
In the very beginning, going into the subject matter.
You can give me just date and time if there's an email.
On December 27th, the email at 8:43, item 4
Okay.
was related to the subject matter of item 8.
Did you respond specifically to item number 4? I mean, did you respond specifically to item number 8 when you wrote item number 4?
I'm looking for the iteration I had when we sent those responses. It may be. Maybe if you could hand me guess, the first version or first updated version, then, because I think I've got my stuff intertwined. But what I was going to say is I was going to reference what the subject matter of number 4 is. Well, not out loud, but what I was going to say is, yes, it's the same subject matter.
And were you speaking specifically to a number or in a previous iteration?
Correct.
All right, cross-examination.
Your Honor, for the record, I'm just putting 1AS back, Ms.
All right.
Winfrey, and I'm taking back the ones that were not.
Thank you.
You're welcome.
Good morning, Attorney Wright.
Good morning.
I believe we met briefly to introduce myself yesterday or the day before, but again, I'm Doug Weinstein and I'm Diamante Kendrick's attorney.
Yes, sir.
If I speak to you in a normal speaking voice, can you hear me okay?
Absolutely.
I don't need to yell or shout.
You do not.
Okay. We talked about proffer sessions, and a proffer session, again, I believe you said, is when a defendant meets with the state, correct?
Correct.
So to avoid legalese, I'm just going to talk about meeting with the state instead of using that word proffer. You okay?
Yes, sir.
All right. So if there would have been a meeting between Mr. Sledge and the state, you would have been there, correct?
Yes.
Was there a meeting between Mr. Sledge and Attorney Love before December 27th?
No, not that I have any recollection of, and I was, I never want to give an incorrect answer, so I was cautious, but I don't believe we ever actually sat down for a proffer.
Was there a meeting between a meeting between Mr. Sledge and Attorney Hilton before December 27th?
No.
Was there a meeting between Mr. Sledge and any member of the district, any attorney in the district attorney's office before the 27th of December?
Not that I'm aware of. No.
What about an investigator with the attorney's office?
No.
I have a slight objection just as to clarification because there, I'd ask that the meeting part based on other interactions, just vague. Was there any
The
meeting?
objection is vague.
Okay, let me clarify. When I have used the word meeting, what I mean is a proffer session. So to all of those questions, if I had used the word proffer session, were there proffer sessions?
I'm not aware of any proffer session that was ever conducted or even a more informal interview with anyone from the DA's office or law enforcement as it relates to this case.
So there being no proffer sessions, I believe you received the first proposed plea agreement on December the 27th with a series of factual acknowledgments, correct?
Yes.
So how in the world, to your knowledge, did the state come up with those factual acknowledgments for your client to agree to without having met with your client?
Your Honor, I'm going to object based on relevance and speculation as it pertains to how the state did something or came up with something.
Nick, overruled.
I believe the state was trying to surmise through its overall
Well,
investigation.
now he asked your personal knowledge, so if you could answer that, please.
I don't have any personal knowledge how the state came up with these factual knowledge.
So you don't know how the state put those words in your client's mouth?
I do.
As to the characterization of
Sustained.
Okay. How many plea negotiations have you conducted in your career?
Definitely over 1,000, maybe 1 to 2 or 1 to
And these plea negotiations are like any other negotiation that takes place between parties, correct?
Absolutely.
There are things that you want in the final agreement, right?
Yes.
They're the things the state wants in the final agreement, correct?
Yes.
Do you get everything you want in that final agreement?
No.
And is this plea any different than the other pleas where you don't get everything you want?
No, it's not.
I have no further questions.
All right. Does anybody else have questions from the defense?
And Your Honor, I
for
have
this
a
witness?
motion as to part of that, but I'll ask it at the time that we break.
Okay. Mr. Adams?
Attorney Wright, good morning, sir.
Good morning, sir.
Like Mr. Weinstein, you and I have known each other a long time, haven't we?
Yes, sir.
Got a number of questions for you, and I want to break them down.
Okay.
And same ground rules. If you can't hear me, you don't understand the question, just ask me to repeat myself, clarify, whatever you need.
Understood.
Let me kind of start with Mr. Weinstein left off. Proffer session. It's been a reference, which is a meeting between your side, you and your client, and the district attorney's office. Never happened. True?
Correct.
Sustained.
You did receive, as we've seen previously, that email with the proffer agreement attached. Is that right?
Objection asked and answered.
I did.
Sustained.
You have never seen, never received, and there is no signed proffer agreement.
Objection asked and
anywhere,
answered.
is there?
Sustained.
And your interest in representing Mr. Sledge would have been to try and get whatever the best situation was for him. Is that true?
Objection vague and relevance.
Absolutely. In anything, the best interest of my client, that is tenement. That is the absolute goal. I want not just keep them home, not just some things you might think. I want the best possible solution for the case.
In this case, representing Mr. Sledge, you indicated you'd known him for well over 15 years, true?
Yes.
And at the time that you came into this case, you were aware of the indictment and exactly what he was charged with in the indictment.
Yes.
You knew that he was charged with one count of RICO, violating the Racketeering, the RICO Act.
Yes.
You knew that he was charged in count 30 of the indictment with possession of a firearm by a convicted felon.
I did.
The count 30, the possession of a firearm by a convicted felon, is something that he was accused of. The allegation was that he committed that offense in December 2020. Is that right?
Yes.
That was included in the overall indictment with the RICO count. True?
Yes.
Okay. Having represented Mr. Sledge before, you knew not just him, but you knew his family as well.
Yes.
You knew his mother.
Yes.
And so when you were in court over the course of the last number of days, and you heard testimony and questions about him wanting to get home to his sick mother, is it in fact true that his mother was ill?
Yes. I have personal knowledge that at the time we were going over this stuff, that was something he expressed and was stressed over.
That was a concern of his.
Yes.
You knew, and I want to kind of reference some dates. He was arrested somewhere in June, around June of 2022. Is that right?
I'm relying to some extent, but I'll say, to the best of my knowledge, yes.
Well, you know that the case was indicted. The indictment was handed down in May of 2020.
Actually, that being the case, yes, he was arrested not long after.
Okay. You, and I don't want to delve too deeply into it, but you shared that at least an early part of that you were having some health concerns yourself.
Yes, and let me back up a little bit. The reason I paused on my answer was, remember, there was sort of an earlier part where he at some point had charges related to this. Those charges ultimately went away. Then much later on, there was an indictment and then an arrest. That's why I sort of paused, because that earlier date is not immediately known to me. But as to once this case was indicted, then the arrest, even though I was not back to my practice yet, I was aware of it and was sort of watching from the sidelines.
Okay. You were in court and heard when he was testifying about that previous matter you're referencing. In other words, his arrest and where he was charged with the murder of Donovan Thomas.
Correct.
And so, at the time that you come into this in 2022, you have knowledge that detectives with the Atlanta Police Department had previously charged him with Donovan Thomas's murder, and then ended up dismissing it, or dismissing the charges, right?
Objection relevance.
Goes to his
Yes, that's the point. I was aware from before, so when this occurred, it wasn't necessarily something new to me. I was already aware that there was some history.
You mentioned a couple dates when you were testifying earlier. We talked about you getting into the case somewhere around October or November of 2022. Is that about right? And when I say get into the case, when you were healthy enough,
Correct.
To kind of resume your practice and get into Mr. Sledge's case.
Yes, sir.
By the time you would have interacted with him or started representing him on this case in either October or November of 2022, he would have been in jail for a number of months, true?
Correct.
He would have been in jail at the Fulton County Jail, true?
Correct.
And since he was in jail at the Fulton County Jail, that presupposes, and you know, that he did not have a bond.
Correct.
Now, if you're in jail and you don't have a bond, you stay in jail, true?
Correct.
The only way you get out of jail, if you're in jail without a bond, is you either, the case gets dismissed, right?
Correct.
Or you negotiate some sort of plea or deal that gets you out of jail, right?
Correct.
Or you go to trial and you get acquitted, and that gets you out of jail.
Correct.
Mr. Sledge wanted to get out of jail.
Yes.
He had been in jail for a number of months by the time you spoke to him, and he was anxious about getting out of jail, wasn't he?
Objection, counter, asked, answered, and sustained.
He discussed with you his desire to get out of jail, true?
Objection, asked, answered, and it gets into, yes.
Sustained.
Were you attempting to get him out of jail?
Yes.
All right. Now, Mr. Sledge, you were in court previously when there was some discussion about what an Alford plea is. Is that right?
Yes.
Now, and one of the ways that a defendant, Mr. Sledge, could resolve a criminal case is with what's called an Alford plea, right?
Yes.
Now, an Alford plea, as you would have discussed with Mr. Sledge in one of his previous cases, revolves around someone saying, I'm not guilty of the charge, but I'm going to plead guilty because it's in my best interest. Is that right?
Correct.
And you would agree with me that entering a plea of guilty, whether it's under Alford or just a straight guilty plea, can sometimes be in a person's best interest, right?
Oh, absolutely.
And that may sometimes be regardless of whether they consider themselves to be guilty of the offense or not.
Objection,
True?
Your Honor, relevance.
Correct. Correct.
Because as you've testified previously, people enter pleas for different reasons. Isn't that right?
Correct.
having, were you the one who did Mr. Sledge's bond hearing, or was it another attorney?
It was probably me. I just don't have a wallet.
It was in late 2022. True?
Well, you know what? No. His arrest on this, I wouldn't have been able to do the bond hearing. So I'm not sure who represented him for the bond hearing as it relates to that June arrest. I was thinking of the old case, but as to that, I would have to say no, I was still on the sidelines where I wasn't cleared to practice yet.
One thing that you became aware of, though, when you came onto the case in late 2022 is that, as you indicated before, Mr. Sledge did not have the resources to go to trial.
Correct.
And it is true, as you testified. Did you hear his testimony about that?
I did.
And did you testify also earlier that you knew that he had limited resources and he just didn't have the resources to take this case to a year-plus trial, right?
It was something that was heavy on my mind in terms of when I'd be able to return to practice, to be able to assist Mr. Sledge, because knowing he had limited resources. And even, I guess, because of the relationship over the years, even though he didn't have the resources I would have liked to become involved in this case, I was going to do what I needed to do to help him. And therefore, even though it wasn't, a huge fee for, or resources for a big year plus whatever kind of trial, I wanted to get involved, make sure I'm here to get him out of this situation and help him in this case. So, I know that was a long answer to your question, but yes, it was something actually heavy on my mind, which made me say, let me get back, be healthy and effective in making sure I can represent.
One of the things that you would have discussed with your client, Mrs. Sledge, would have been the risks of going to trial.
Yes.
That is certainly something that you would have counsel to consider with regards to what decision you would make.
Yeah, every client, we're going to have that conversation.
It is true that you would have counseled him that, hey, look, Mrs. Sledge.
Objection, Your Honor, when it gets into specifics of the risks that Mr. Wright considered existed in this case, I think that is privileged information unless now Mr. Sledge is waiting.
Mr. Wright understands the obligations of the attorney-client privilege.
And
Does not reveal any attorney-client privileged information.
And I was going to say, I cannot answer that question because you're asking me something specific to Mr. Sledge.
Sure. What you knew, though, is that had he gone to trial and convicted, he would have been facing a potentially long period of time in prison.
I would say I would know for any of my clients that when you're facing these kind of charges, the potential consequence of a conviction could be a very lengthy sentence. So it's extremely serious. So you want to make sure you can stand guard and do the best to make sure you get the best result for your client.
And that is something that you would, without going into any specifics, that is something that is a factor that you would have discussed with Mr. Sledge. True?
Again, not specific to Mr. Sledge, but to all my clients, to make sure that their eyes wide open. We talk about good, bad, all the possibilities, so that you can make sure, as an attorney, that my clients have a full understanding of the risk, the reward, and all the possibilities in between, so that they make an informed decision on what they want to do.
You were aware, were you not, that the state, the district attorney's office, was interested in whether or not your client would testify, to take a plea and testify. You knew that, didn't you?
Yes, as of, I think, the first email was sometime in November, when sort of the first communication that sort of gave us an idea that they would like to talk to him.
Were you ever present in court where any representations were made by Assistant DA that we're looking to make deals?
I first appeared in court in the middle of December. That's sort of when I came back, but I also appeared on behalf of Mr. Sledge. I don't remember the details of what occurred that day, but I will say, when I reached out to the state to say, hey, let's talk, it was middle of December. So it was after, I think, that first couple court appearances in December.
It would have been after, also, there was that November 30th correspondence between you and the state.
Correct. I had not yet responded to them, but it was in middle of December that I essentially was now responding to them and saying, okay, let's talk.
And that November 30th email was an email that you received from the state. It was unsolicited, true?
It's easy when you have emails to say, I remember this. It may have been a phone call where it is customary that even though you may see us in court, everyone seems to be one side or the other arguing. Professionals, we call each other, we talk, we communicate about different cases we may have going on. So it was not unusual for Ms. Love or someone from her office to just reach out, call me as sort of that first step. And I think there might have been a phone call followed by that email. But again, I just don't have a recollection of a phone call or what the conversation is, but it wouldn't have been unusual. I've known Ms. Love probably 10, 12, also maybe 15 years. So it, as one professional to another, it would not be unusual for her to reach out to me to basically see, is my client interested in something?
Now, during that period of time, from November 30th to whenever it was you reached out to the DA's office, you would have been talking to your client about
With all my with all my clients, I'm going to communicate to them, hey, here are communications or statements or developments, anything about their case. So again, not talking specific with Mr. Sledge conversations, it is my norm and usual that if the state reached out to me, I would have made sure to reach out to him. And more often than not, I don't like jail phones, so I don't want to be listening to. So I will try to go see my clients and have that conversation.
at the jail.
At the jail.
I want to backtrack a little bit and ask you, you testified just a moment ago that you weren't sure as to whether or not you represented Mr. Sledge at the bond hearing in regards to this case. Is that true?
Yeah, I just don't have a memory. I may have, but I may not have. I just don't want to misstate something.
But it helped to refresh your recollection about whether or not you represented him at the bond hearing, if I would show you a document.
Absolutely.
I'm going to show you for purposes of the record what I've marked as defendant Williams Exhibit 257A and 257B respectively. I'm going to go ahead and put those here, let you take a look at them. That's right. And once you're done, you just tell me whether or not that helps to refresh your recollection as to who represented Mr. Sledge on the hearing.
Seeing this, it does refresh my recollection.
Okay, so tell me if you would, whether or not you did in fact bond hearing in this case?
I definitely filed for bond, and I either represented him myself or I had someone stand in for me if there was an actual hearing. So I'm not sure in that time frame that I filed for it whether I had been cleared. So I can at least state I filed for it, and I either was there and represented him or I had an attorney stand in my place.
When the bond was denied?
So it's still on me, yes.
Okay. All right. So let's jump back to December now, right?
Okay.
So we're in December, and if I heard you correctly, the state has sent you an email on November 30th, and so now you're talking to your client in mid-December to see what he wants to do in regards to the case.
Okay.
At some point, you end up in court, and I'm focusing now on December 27th, December 28th, because the plea was entered on December 28th, true?
Correct.
All right. The correspondence says that the very first time that you and/or Mr. Sledge would have had an occasion to consider the state's proffered plea agreement was one day before he entered his plea. True?
Yes, and to give you detail, that day, I actually, once I received it, went to see him to go over it. And then ultimately, it's when I got back that I sent the response. So that's why you can see I received it around 5 or so in the evening. I didn't respond until about 8 or so at night because I needed to basically go talk to him and get his feedback. And
So-
ultimately, I then sent feedback back to the state.
All right. So we're talking now about maybe 4 or 5 o'clock p.m. on the evening of the 27th is when you first received from the state this plea agreement that they had drafted up, right?
Correct, that the first one.
Right. And again, this plea agreement that they sent to you with the different paragraphs and provisions was something created by them, not by
Objection,
Mr.
Your
Sledge.
Honor, asked
True?
and answered.
And when you went to the jail to meet with Mr. Sledge on the 27th, this would have been the first time that he had any opportunity to look at anything called a plea agreement. True?
Correct.
You would have discussed this plea agreement with him. True?
Well, again, not specific communications with Mr. Sledge, but with all my clients, I'm going to take the plea agreement and go over it with them. So any meeting where a plea is ultimately in the air and being discussed, that yes, I'm going to go get my client's feedback.
So by the time you see him on the evening of December the 27th, 2022, you've got a plea agreement with you, and you're going to have a conversation with him about whether he wants to take this plea, right?
Correct.
Okay. There's still, of course, the option of him going to trial. True?
That remains an option unless and until he takes the plea.
But hanging in the air at that time, with the plea agreement on one side and potential trial on the other side, was his concern about getting out of jail to see about his sick mother. True?
Objection, asked, answered.
Sustained.
Also hanging in the air was the possibility of him not having the resources to go to trial. Right?
Objection, asked, answered.
And as you would do with any client, you'd have discussed whether or not there were things in that plea agreement that the client simply could not agree to or would not agree to.
Objection,
True?
asked, and answered.
I would say again, not specific to Mr. Sledge, but when a client reviews a plea agreement, if there are factual allegations, because there's not always factual allegations in the plea agreement, but if there are, we're going to go over those. And if we go over those and there's some disagreement or there's some need for clarification, that's something that I will go to the state and indicate, hey, there's some issues here. We need clarification or changes or what have you, so that we can make sure these are accurate.
And in this case, you actually did that, didn't you?
I did send an email to the state indicating that there are some clarifications that we would like.
Okay. So there's some negotiations now going on, or some correspondences, communications going on back and forth between you and the state, you on behalf of Mrs. Sledge and the state,
Yes.
for the 27th of December, carrying into the 28th of December, the next day.
Yes.
The next day, he's actually in court.
Yes.
He's brought into court, and you have an opportunity to talk to him in a holding cell, a holding area.
Yes.
Okay.
He's in a holding area. And it's typical a lot of times that the client will be one place, the state may be in here or in a conference room, and I'm sort of the messenger of sort, going back and forth to help facilitate a negotiation.
You had the opportunity to discuss with the state that there was a factual allegation in their plea agreement that you did not want, or you wanted it changed. Remember that?
Correct.
You talked about number 3.
Correct.
Now, the subject matter of that, number 3, revolved around
Your Honor, I object as to the characterization of the number 3, and I'd object based on vagueness. Are we talking number 3 in 1AS or number 3 on one of the other exhibits?
all right, let's reference what ends up being the final version of the plea agreement. I believe that's states 1AS. Okay. Do you have those in front of you? I want you to be able to.
I do not have that in front of me.
Mr. Wright, I'm going to give you what's been marked that states 1AS.
Okay.
You had a chance to see what would ultimately become stage 1AS, the conditions, the provisions, the factual acknowledgments that were part of that document. True?
Yes.
Okay. Prior to the execution of that document on the 28th of December in court, you had an opportunity to communicate with the state that you had a problem, or y'all had, to use your words, some concerns about that factual acknowledgement, right?
Yes.
Now, that factual acknowledgement revolves around this incident by a video where Mr. Sledge is alleged to have been in a video holding a gun, making threats to someone else, to another person, correct?
Correct.
When the state presented any of the iterations, including that last one, right, of the plea agreement, they wanted Mr. Sledge.
Objection as to what the state wanted.
The factual acknowledgement revolved around Mr. Sledge acknowledging that while associated with YSL and to support and express loyalty to YSL, the defendant, that would be Mr. Sledge, and co-defendant Demikian Garlington and Quindarius Zachary appeared in the video with another person. AS, wherein defendant brandished a weapon used in a drive-by shooting, and wherein on behalf of YSL, defendant threatened to harm a person named Kel, a rival gang member who had begun a relationship with defendant's ex-paramour, girlfriend. That was the factual acknowledgement, correct?
That was the factual acknowledgement.
You communicated with the state, and you requested that they change that, correct? Or that it be removed.
Your Honor, objection is a compound, and I don't.
Sustained.
They did not change it.
Your Honor, I object and ask that whatever question there was.
Can you pose a question?
Sure.
Okay, when
When you saw that
compound, that
acknowledgement,
means it's two
the manner that
or
I've just
four
read.
questions.
in any of the iterations prior, leading up to the 28th, you communicated with the state and asked them that it be changed. True?
Yes.
They did not change it. True?
No, they did not.
Mr. Sledge still initial that, correct?
Correct. And that's an example of sometimes, as other counsel has asked, try to get everything you want in a negotiation. Some things you may have to live with. And ultimately, this was an item where someone could try to argue whether two things are, is this just a boy-girl and another boy issue, or is it a YSL issue? But a decision was ultimately made that if it wasn't getting changed, we either had to live with it or stop the process. And ultimately, that stayed.
Okay, so he just elaborated on what I told you most likely happened, why it wasn't changed. Because the state didn't agree to it. My boyfriend came in here and got y'all straight, okay?
But the reason that you wanted it changed, when you spoke to the state, you told them that that information was not accurate. True?
True.
You told them that this wasn't the factual acknowledgement that referenced it being done on behalf of YSL, that was not true. This was about a girl.
Your Honor,
And not
objection
about-
as to the compound nature of that question.
You told them that that incident was not about a gang-related incident. True?
True.
You told them that it was about a dispute over a girl. True?
True.
But they did not change it.
Objection, asked and answered.
Were you present? You were present in court when Mr. Sledge testified that he thought that he would have an opportunity to, notwithstanding his initials, explain his answers if put on the stand. Did you hear that testimony?
I did.
Did you again, without going into any privilege and to your observation, well, actually strike that. Did you have a conversation with the state about whether or not Mr. Sledge would be able to explain anything that he had some disputes with in the factual acknowledgments?
The conversation was had back when we were doing the plea, and then even since then, it's always been broadcast or at least made clear by me, hey, if there are some differences in some of the content of some of these, my client will ultimately want to explain. If you put him on the stand and he testifies, he's going to want to explain what he means, as if and he acknowledged this, because something can be true, but also be true with other components to it. It's not always just one way that one person sees it as opposed to how another person sees it. And he wanted to be able to at least explain that. I think he often referred to it as his truth. And that was really him just wanting to explain.
You discussed that with the state.
Yes.
Objection, asked and answered.
You can answer.
I would say yes, and again, sometimes the state would agree and they would make changes, sometimes they would not agree. But it is incumbent on me to make sure, hey, eyes wide open, full disclosure, we've told you. So it was not going to be a surprise that, well, Mr. Sledge may have a difference of opinion.
It was your observation that the state wanted this plea to go through as much as Mr. Sledge did. Is that true?
Objection, Your Honor. Relevance is to, and speculation as to what the state wanted.
Speculation.
Somebody asked, I don't know.
True.
I had a belief.
Okay,
Yeah,
that's also not what was asked.
Well,
Maybe ask your question.
You,
And relevance as to what the state wanted.
The judge would know best what she can and cannot do, and whatever. But when she instructs in such a way to where she is assisting either side, I don't know if that can be considered, the judge is providing legal advice, right? When she asked her, well, can you ask, if she put can you in front of, whatever her suggestion is, then that's different. But telling them what to do like that and how to ask the questions and all of that, whatever, and apparently she ain't reading the room, because them little weasels over there on the defense, they look for any and everything to try to, to get out of this case. So, I don't know.
based upon your conversations with the state, your knowledge of the case, your communications back and forth with the state, your evaluation of the plea agreement, you formed or you observed that the state was just as interested in getting this plea done as Mr. Sledge was. Isn't that true?
So objection.
Go ahead.
Objection. It calls for speculation about the state, and whatever his observation is or belief was is not pertinent to any material.
Sustained.
Was it your observation that the state wasn't really concerned with Mr. Sledge, they really
Objection.
wanted Mr. Williams?
Same
objection.
Sustained.
And I have a motion as relates to that.
Sustained. Ask your next question.
I thought you were waiting for the emotion. All right. Before Mr. Sledge was brought out into court on that video that we saw and entered the plea, I know there wasn't a proper session, but separate and apart from that proper agreement, the one we talked about earlier that was mailed to you, did you ever get an email from the state saying, hey, we want to talk to him before he enters a plea?
I'm not sure if they asked, but on the same token, my client never expressed an interest in talking to him. So I can't necessarily say it was the state or the defense that kept that conversation from happening. Ultimately, the conversations really were just the negotiations back and forth.
Okay. Got a question I want to jump ahead and ask you about first and then come back to the plea. So the plea is entered on December 28th, 2022, right?
Yes.
You had that meeting that was talked about on June the 9th of 2024, right? At any point between December 28th of 22 and June the 9th of 2024, did the state ask you to bring your client in for an interview?
Objection, Your Honor, relevance.
I don't believe so. I know we didn't meet with the state until we ultimately did in June of this year. But we always just sort of figured we were standing by, and it was always our hope we weren't going to have to testify. So we were hoping, hey, we're on the sidelines and we're no longer relevant in this. And then ultimately, it was this year that they said, we need to sit down with you, and yes, you will be testifying
2024,
in 2024.
in the middle of the trial. Okay. How about this? Did the state ever send you any questions that they might want to ask your client?
Objections, Your Honor,
Can I-
at relevance as to whether or not the state ever sent any questions.
All right, so, move on to your next question.
You knew when the plea was entered in December of 2028 that Mr. Sledge was a potential witness to be called at trial. Is that right?
Correct.
And after he entered the plea, he got out of jail. True?
Objection, asked and answered.
He didn't
Okay.
just get out of jail as a result of entering the plea, though. Am I right? There was a bond component of that also, wasn't there?
There was, but
In fact,
Your Honor,
There
I
were
ask
two-
that the witness be allowed to finish his response.
Yes.
I'm sorry. I thought you were done. Go ahead, sir.
well, I was going to say, I want to say, I think the bond, we worked that out as part of the plea as well, so that was not going to be an impediment to him getting released. So, in other words, it really sort of was all connected.
His plea was on count one, the RICO plea, the RICO charge, right? He also pled guilty on count 30, the possession of a firearm by a convicted felon charge, right?
Correct.
He was sentenced on count one.
Correct.
His sentence on count 30 was left open until after the trial, this trial concluded, correct?
Correct. In my practice, I find it is not atypical for states when they do enter into an agreement with a defendant to try to have something held open so that the defendant's participation, they can make sure the defendant just doesn't show up and show out. They come and do what they indicate they're going to do. And therefore, count 30 being held open was not atypical.
Right. His plea agreement and his plea required that if called to testify, he come in and he testify truthfully, consistent with the plea agreement, correct?
Correct.
Because count 30 was left open in terms of sentencing, he couldn't get out of the jail unless he got a bond on that charge, true?
Correct.
The state consented to a bond on count 30, didn't they?
Your Honor, I'm going to object as to characterization, and the court can check, and I will not speak on evidence, but I believe that this is a matter that,
All right. How much longer is your cross going to be? It's we're approaching lunch hour.
More than half an hour.
Okay, let's break for lunch. And I think we've got a couple of motions to deal with. So let's say, it's 12:30 now. Let's be back at 2. what I may do, because I have a lunch meeting, is let's break now and let's just come back early. So I don't know how long 2 motions and whatever else we have to deal with is going to take. Can we all be back at 1:15? All right, I'll see y'all then.
Thank you, Judge.
My sleepy ass, I'm telling you. Oh. I'll let it run back. Um, while we wait, I don't know what time they go to lunch. They go to lunch at 12. Let me see if I can figure out. Is she done with him? Oh wow. Yes, so she said be back at 2, y'all. Um, that's 40 more minutes. Okay, well, I guess I could hold y'all. I can carry it live by myself. I always have. And you have people that enjoy speaking, and I don't even drop the link all the time. So, you have people asking, where's the link? Where's the link? I appreciate y'all um, talking. Okay, now she told them to be back at 1:15. Maybe she told the jury to be back at 2. So I don't know what's going on with Judge Whitaker. But, anywho, I appreciate y'all for that. As you know, and we have, my whole goal and objective is to create original content course would be entertaining and educational and so on and so forth. But hopefully somebody will learn something. I don't care if it's even through bullshit, as long as you learn something. You know, my goals and objectives are satisfied. I am quite sleepy and delirious. Please believe that. It's scratching, but it ain't really scratching where I'm itching at. Is nuts. Can't be defined. Now, I'm going to talk about something that is going to make Mo hair stand up on the top of her head, on her toes, on her fingers if she has some. Are y'all hairy like that? I'm hairy like that. I have hair. Let me see if I still have it. Baby, wait. I said a little bit, but I don't say no more. I used to have hair where you could see it on my fingers and on my toes. You know what I'm saying? On my legs and all that stuff, but that shit has gone away, honey. And I didn't, I don't even shave, child. That shit is gone away. I mean, the hair used to be so thick to where I wore pantyhose. It would come through the pantyhose. You know what I'm saying? You know, I'm a good clean girl. Draws, slips, and pantyhose. Okay? Okay, they're back. Let me give them some acknowledgement. See what's going on. As I stand here, contemplating on the right way to the sun.
And one of them relates to the comments by Mr. Weinstein during his cross-examination of Mr. Wright, specifically the comment was maybe about an hour and 19 minutes and 32 seconds from when we stopped. But specifically, the comment that Mr. Weinstein made, to which the state objected, was, you don't know how the state put those words in your client's mouth. And my objection that the court sustained, obviously, is that it was an improper comment, improper statement put before the jury. And even though the court sustained it, Mr. Weinstein and others' ongoing efforts have been to spin a narrative that the state has forced something on one of the witnesses or more of the witnesses. But those particular words, Your Honor, that you put this, you don't know how the state put those words in your client's mouth. It amounts to Mr. Weinstein making a statement, not asking a question, and him making an assertion that the state, in fact, did something that it did not do, which was put those words in your client's mouth. Everybody's heard the testimony and seen what happened. And in as much as that statement was an improper statement in front of the jury, and it could be construed by the jury as something, notwithstanding any court's instruction, that they could take as fact, we would ask that the court under 17-875 admonish and rebuke Mr. Weinstein's statements and admonish him to make no further efforts to put such improper statements before the jury. My second motion deals with Mr.
Let's take them one at a time. Yes.
There was nothing improper about that question to the witness, Your Honor. I was inquiring about the facts, sorry, I'm losing the word, but the facts that were put forward that the state created. The state doesn't deny that they put those together and gave them to Mr. Wright's client without any input from Mr. Wright. I think it was a proper characterization, and it was a question. So the witness could answer that, just as Attorney Love has said. All the evidence is out there. It's all before the jury. The jury can draw what they want from that evidence. So there was nothing improper about that.
All right.
And I actually, well, that's all I'll say.
So I think it was a mischaracterization. It was in the form of a question, but I believe it was a mischaracterization because if we had been talking about the final version that Mr. Sledge adopted, that might have been a fair statement to say, you know, they were put in his mouth. But these were not things that he ultimately adopted, so the state wasn't putting those words in his mouth. So I think it was a mischaracterization. I don't think it goes so far. I mean, you objected, I sustained it. It doesn't go so far as to want an admonishment before the jury. But let's try to be careful in our characterizations, even when we are asking questions, all right?
Yes, Your Honor.
Okay, what's your second motion?
Mr. Adams' question to the same witness that the state objected to, but that the jury heard. Isn't it true, and I'm going to paraphrase, that you knew that the state didn't want your client, the state wanted Mr. Williams? That's been the lie that they've been, the narrative that has been promoted from the start. We don't agree with it or adopt it, and we certainly don't agree with the idea that we, do these things without a basis for them. So in as much as Mr. Adams made that assertion in front of the jury, we do believe that that merits an admonishment and rebuke under 17-875, and we would ask that the court give him one.
All right, and that statement was essentially it followed upon another question that was not as objectionable in this way, but that had been sustained. And Mr. Adams, she pretty much doubled down on it and said something to the effect that the state wasn't interested in getting Sledge, they were interested in getting Williams. And that's inappropriate to have asked that witness, and I don't know why you thought that there was any basis for that being an appropriate question, because it would call for speculation anyway. So what's your response to the state's request that you be admonished with regard to that?
God, it was not a question it was a question that I believed was an appropriate question, given the context of both this witness's testimony and his client's testimony previously. What we'd heard in the narrative that has been put forth, and quite frankly, I believe the evidence has been that the state has been mostly interested in Mr. Williams as a defendant as opposed to the co-defendants, particularly as regards this witness and Mr. Sledge. What has come out, what's been of importance, is this meeting that they had on June the 9th, where the statement is made that is beneficial to Mr. Williams. Part about him advising
Right.
Mr. Copeland or Mr. Sledge to take Mr. Copeland to the police, and that's left out of any questioning of Mr. Sledge. He is asked, or he is, however it comes out. There's no discussion about that. We're not going to ask you about that, whatever portion of it you choose to believe. And so there is this narrative that's out there that they appear to be interested in Mr. Williams, not so much in the co-defendants. And the fact that all of the co-defendants who took pleas were asked, made, or signed plea agreements where the bulk of the plea agreements, and the jury has heard at least 3 of them previously. So, Mr. Williams did this. There is this narrative out there that they're attempting that, and everyone has gotten probation. All of the people that the jury has heard from has gotten probation after they were denied bond, and the state took a harsh position that they didn't need to be out on the street. But the minute they entered pleas, they implicated Mr. Williams in some form or fashion, their plea agreements, then they were released. And so that narrative is out there, and I think that was an appropriate question to ask of this witness who has some knowledge of that.
How does this witness have any knowledge of the state's desires about who they most want to get with regard to the 19 or so defendants that are indicted in this case?
Because he is a defense attorney representing one of the co-defendants who assisted in entering into a plea agreement. He is familiar with the discovery. He made a statement in part of his testimony previously that he knew what the case was about. And he started going down the road of talking about Mr. Williams before there was an objection made and the objection was sustained. And so he does have knowledge of that. He knows about the case. He knows that Mr. Williams is alleged in this indictment by the state's narrative to be the head of this YSL organization. And he knows that plea agreements have been to the benefit of the co-defendants who have pled and to the detriment of Mr. Williams.
And every other defendant still on trial.
Well, but he also knows, I asked him one question about, was he in court when he heard the statement that was made by the prosecutor before the plea? Made by the prosecutor, it was Miss Lizzie Rosenwasser at the time, where the statement was made that we're interested in anyone who wants to make a deal except Mr. Williams. We're willing to make a deal. And so he knows this. We're not doing this blind. He's aware of this information.
I doubt that she would have said it, but if she did, I mean, I can't speak to that. I'd like to see it since he's made that assertion. But the second thing is, as it relates to his assertions regarding the plea agreement, Mr. Sledge, I believe, or either Mr. Wright or Mr. Sledge were cross-examined specifically on whether or not the state asked Mr. Sledge any questions about Defendant Williams. And Mr. Sledge said no. And the idea that we're pushing the narrative when the state itself, as the record will reflect, elicited the testimony about Mr. Williams encouraging Mr. Sledge to take Kenneth Copeland to the police station, belies this argument that the evidence that has been out by the plea agreements and by the state's actions somehow or another support this, in my mind, baseless assertion by Mr. Adams in the form of, or in the disguise of a question to Mr. Sledge's attorney. There has been, Mr. Sledge's attorney could have been asked whether the state, see whether the state asked more questions about one person than another, but actually he was asked and he testified that the question and answer session was more of a kind of get to know you session, and that when Mr. Sledge began talking about Mr. Williams, about the state is that the state said that's a hot button issue. He later said there was nothing that you didn't say that. I just, based on you not asking him about that, I may jump to that conclusion. So putting in front of the witness, this assertion about the state's intention, because as if it's the state that's on trial and that the state is doing something that is just wrong. Is it wants your client? He wants Mr. Williams. It wasn't an effort to censor, an assertion in front of the jury that was improper, and that can't be taken back. And that has been the entire.
Well, they're going to make that. I don't believe, Mr. Adams, that there was any kind of a good faith basis for this witness being. But with regard to what you propose is any kind of curative or admonishment, I mean, I don't know what that'd be.
I would ask that the court admonish Mr. Adams in front of the jury that the state late to Mr. Sledge Williams were improper statements by counsel, that those types of statements, the jury is to remember they are not evidence, but that Mr. Adams should not have made that statement in front of the jury.
Okay. And so they weren't statements. It was a question. It was just an improper question. And 17.875 talks about statements of prejudicial matters not in evidence.
And Your Honor, it's not, there's nowhere in evidence. It was a statement that was dressed up like a question, but he made an assertion in the form of a leading question. Was it your understanding that the state really didn't want your client, he wanted mine? And the fact that he dressed it up as a question doesn't take, our position is it doesn't take it out of the realm of improper statements put before the jury that fall under 17.875 that merit admonishment at the very least, even if not rebuke, but that Mr. Adams should be admonished about that statement. It was improper, and it should not, similar statements, even in the form of questions or disguised as questions, should not be made about the state's intention, which one, no one else can testify about, and two, it was just wrong to put before the jury, pretending it was a question to this witness.
Your Honor, if I may respond.
Go ahead.
I have this with sound ammunition.
Yes.
And I'm allowed to ask questions. I will defer to the court. If the court felt as though the question was inappropriate, there was an objection, and the court sustained that objection, and I abided by the court sustaining that objection. This does not fall under the ambit of 17.875. This is not tit for tat where because Ms. Love was admonished previously, now she's trying to find every opportunity to get somebody else admonished. It's not what this is. Now, I'll abide by the court's ruling, by the court sustaining the objection, but I've stated on the record what my belief was and what my good faith basis was for asking that question in regards to the narrative being put forth at the beginning of this case, and I'll stand on it.
I'm trying to look back at what happened right before that.
I told y'all a long time ago throughout this process that lawyers aren't allowed to use the word lie in the court. That's why she quickly apologized after. I had a personal interjection, but I wanted to make. So, you know how we get up in a body, we get down and tell stories, right? Which is nothing more than you on the phone with somebody talking about the same shit. It just so happens, you're alive, right? And you know, but somehow in the criticism of me, it's supposed to make me look like whatever kind of person bad. I don't know what it is. Like something wrong. Like telling stories from your past or without label as the wonder. First of all, I was and still am a quiet person, not a loud person, but a person that people enjoy to be around.
It was your observation that the state wanted this plea to go through as much as Mr. Sledge did.
Person that people like to be around, just like a lot of y'all, you know. And we had a good time, enjoyed ourselves, what have you. I don't relive past and all that type of stuff. Just telling stories. I started that a long time ago. You have other channels of people. They tell stories about what they were doing. When they tell stories about when they was outside and all this extra shit, they telling stories about their years. And you can label it the wonder years if your ass is eating it too, right? If you're trying to make a person look some kind of way, you know, I mean, you do all that extra shit, right? But it is so ridiculous, right? Because back then, you don't know what I was doing. You don't know if I was partying every day, doing this, whatever. You don't know what I was doing. Only thing I can tell you, I was doing a little bit of everything. Okay? That's all you motherfuckers need to know. I don't even know you. And because the hate is so great, it makes me feel like motherfucking Kobe and MJ. And I feed off of it. It makes me, it feeds into my already established ego and increases it. It makes me, do that thing that I hate and dabble in life shape. I mean, you talking incorrect shit, I'm gonna talk the correct shit. And you can't tell me what I didn't do, what I don't do, whatever, because you're not me. I don't disclose every motherfucking thing to you motherfuckers. I don't have to. Who does that? I don't have to cut on the camera. Okay, well, this is what I'm doing today. Oh, this is what I'm doing for my birthday. That's fucking goofy as hell. That is goofy as fuck. I'm talking about y'all let this YouTube shit, become an addiction, or some kind of crack, become your way of life. You motherfuckers are weird as hell. Tell you that now. Crazy than a motherfucker. Okay, and the people from my past that's still alive, whatever, they're still here. You've heard them. So I ain't got to wonder about shit. They still here. And you've heard them say, oh, you got to do this, you got to do this, you got to do all this extra shit, right? those exes, they still here telling me that, I was their best, or how much they love me, like me, miss me, that shit, whatever. The question shouldn't be, it shouldn't be no bad mark about me talking about, you know, past and stuff like that, as you motherfuckers do. The thing is, where's y'all motherfucking people? Y'all think everything should be on live, on the YouTube or whatever? Dig them motherfuckers up and have them see what they say about your ass. Oh, what you say about me? Oh, you can't do that. Sound did it all. The way I do it. On this motherfucker. And then you have some motherfuckers like the holidays and the birthdays. They was bringing the motherfuckers in with me. And tell me I'm motherfucking lying. And see, y'all push a motherfucker to, put a motherfucker in a snitching position. And I got time for that. It ain't even that motherfucking serious, and definitely ain't shit I want to think about ever again in life. Okay? Tell the motherfucking truth. So if I ain't got nothing going on, and this then certain motherfuckers don't either. Hey. I can't help that some of you motherfuckers might not have nothing good or whatever. You ain't do shit. You have certain people in their quest to compete or to be like a motherfucker, whatever, are just not starting to do shit. Just not starting to do charity and giveaways and content that motherfucker informs and matters and things of that motherfucking nature. Step up their motherfucking fashion game, whatever. Now, let me make this clear. They're doing that based on their ability, their limitations. Okay? And I'm not no motherfucking hater. If something positive and good, I cannot stand your motherfucking ass. Well, if you're doing something good, well, happy congratulations, kudos to your motherfucking ass. But I came here doing all that shit, having all that shit. So ain't none of you motherfuckers influence me to do a motherfucking thing. I'm not copying none of you motherfuckers. And I wonder, like I put on my board, I put a lot of motherfucking shit on there. What do y'all motherfucking player hate and sit there and look crazy or whatever at your friends and family members that had a normal life? Because I swear my life has been normal. Rich, I have a great life, I have millionaire friends, I don't brag and talk about that shit. Y'all put all that on it. Because something's wrong with you. I can't help that things went with, what you want me to do? What the fuck do you want me to do? I mean, just because some of you motherfuckers will fall dead of excitement and shock and desire over a nigga with a couple, that appears to have a couple coins, a nice car, some good liquor, and some game. Huh? Y'all impressed by that shit. Be on the live flipping out acting crazy over the shit. Like what? Huh? I don't understand. I really don't fucking understand none of this. Yeah, I don't. And the only thing I can think of is what I surmise. You motherfuckers are the lowest of the low. You ain't used to shit, you don't know shit, and it is what the fuck it is. Don't come fucking with me. Just because I didn't have that kind of experience. Some of you motherfuckers, that act like the world just started. Don't know nothing about politics. Don't know regular elementary school shit. And then always wondering how the rest of us do. That mental illness shit is, it's just too much. And then you're so crazy you won't go somewhere and get that shit in check for somebody to beat your motherfucking ass. And then on top of that, your hair dry. And all the names that you could call me, that you just said they were true, which they're not. What, fake lawyer? Sometimes I'm a hoe, sometimes I'm lonely. Y'all can't make up my mind which one it is. All kind of jobs y'all done gave me. Live in a nursing home and 75. When you got drug dealers or ex-drug dealers, womanizers, woman beaters, killers, people that don't have a relationship with their children, they're disconnected from their family, they don't have no friends, they got a spotted job record, so on and so forth. You got to be crazy. I don't want Nasty Andy to come out here and just reside. I don't like these personal interjections and shit. So I be trying to get it out on the wall. But I unsub from you motherfuckers for several reasons. One, you ain't talking about shit, but the same shit. Or bullshit, or fucking with people. Two, I need some information relative today, not from 1808. I don't know about the thoughts interrupted. I don't need none of that. It just, I don't, nothing. Just forget it. I don't really know, no slick this ass post to me. Because, some people believe everything others say. That's fine. Do that. But just don't have me embarrass you. Or maybe you won't be embarrassed. But, the people will be looking crazy. The other, people will be looking crazy. Like, what? Those people who accept anything, they don't get embarrassed. Like, leave people the fuck alone. All the motherfucking people I know that I done put on, and there's many more I could. But they wouldn't understand. They'll pick up. Like, why you acting strange? Just like Tony did. Wait a minute, something going on. Well, why you talking like all that type of shit? Because I refuse to give anybody this motherfucking link. Because I know that I might click on here. I don't do it. No. They don't need nothing about this shit. I'm one little baby. Don't find out. But my daughter knows about the channel now. And my other little baby. The one who called me when I was live yesterday. They found me through TikTok. I disabled the motherfucking TikToks, honey. All that contact list and shit, they be picking up and sinking and all that, pulling your shit. Telling you. Like, nope. But I don't need, and then I got people that will find my shit, will be scared to tell me that they know about my channel because they know I would never want them to know about no shit like this. It's not about proving who you are or what have you, but again, I only started out telling this shit to have fun, talk about stories. It started out with a fat boy out on the phone. Remember, I was putting those up. I was doing all of that before I created all these enemies and people that got imaginary beefs with me and shit like that. I'm not having no motherfucking no beef with nobody that took a GED and don't haven't used it to have raise their level of consciousness or their level of education and understanding all that other stuff. I'm not doing it with people who make up words and shit. I'm not doing it. It's ridiculous. They are handicapped. People that, was in the slow learning class. And I know out of all you people out here, I know a lot of y'all was in the slow learning class. What I look like doing that? That's crazy. Y'all gonna run along with that bullshit. You ain't been trap me up in that shit no more. I was a dummy for even entertaining all that motherfucking shit. I ain't called out nobody motherfucking name to start no shit with them. That's a goddamn lie. Run my life back. That's what I'm saying. Y'all, these people telling all that shit. The proof be out there. Just run it back. You can have stuff that would reference certain people, whatever. That ain't me. That's what I'm saying. I'm not gonna argue with no slow motherfuckers that can't read shit or listen to shit or whatever and get it together and retain it. That's crazy. I don't feel like arguing back and forth with no men. I don't feel like arguing back and forth with some people trying to tell me about the law or whatever. I'm not gonna do that. No more. People making up shit, to tell others that so they can dislike who does all of that and with no motherfucking proof. Just because they gotta ask the motherfucking ground. And nobody's asking the motherfucker, well, who appointed you to be the Pied Piper? Huh? Just crazy. Get over it. Damn. I did quickly. Find something to do. Shit. Let me get on this later. I'm tired of having these kind of motherfucking personal interjections. And then you can't even come to this motherfucking sector even before I unsubscribe to get no motherfucking good content and information, whatever. See, I'm out here doing what I'm supposed to be doing. One of them, as a subscriber, waiting for your motherfucking ass to deliver something that's educational and informative. Something I can motherfucking use. And we got a debate coming on tonight and all of that. None of you motherfuckers talking about debate. This is 2020 motherfucking 4. Shit is happening. Your ass should be involved or doing something. Now, I feel like a hypocrite by saying that because I haven't been involved. And I'm not going to be involved in this. I'm going to do my part by going to the polls to vote. But I'm not working at the polls either in a legal capacity or just, one of the people at the polls that be making sure order is kept. I'm not doing either one of them. I'm not doing nothing. But coming out here on the record and giving my personal feelings about, the candidates. I told you again that Hillary Clinton thing tore my chunk ass down. Okay, put me on the sideline. I'm on the injured reserve. Yeah, nobody talks about sports. Nobody talks about just nothing. Whole big old motherfucking men and shit. But being drama, I'm telling you, it's some undercover shit going on. It ain't really undercover. The covers are pulled back. And that's fine. I don't care how you live your life. I don't give a fuck about none of that. But how y'all be saying, don't be coming here acting like you this and you that. It's a whole, I ain't never seen no shit like that in my life. I ain't never seen that. I don't have no men in my life that act like none of that, right? Let me tell you. When I see these dudes, greet, have a good time or what have you, right? They show their closeness and I'm talking about the people I know, they show their closeness and their bonds. But in a manly type way. You understand what I'm saying? It be in a manly type way. Ain't nobody kissing nobody's ass and all kind of old crazy shit. Just weird. They do that real brotherhood shit, right? Like I told you, we was in a circle one day, and I was the only girl over there. And when it was getting ready to leave my best friend Tim's house, the one that be mainly on the phone, the one that the actor spoke to and was talking to about sports and shit like that. And you see that conversation him and the actor was having, that's why I be liking to hear between men. They're talking about sports, they're talking about there's all kinds of shit. They ain't know each other. They talking about getting to know each other like But that type of shit, right? Anyway, I told the story, but we was getting ready to leave. And they said, Andy, come here, since you wanna be a part of the motherfucking be with the men all the time, be a part of the men, you gonna close out with the men. How we do it. It's about 12 of us that was left there, and about men, right? We in a circle. And they had a bottle, but I don't know what it was. And everybody passed the bottle around and drunk out of it. It's almost like, pricking your finger and putting it, together, like blood ties or blood family, whatever. And me, honey, I was like, oh no, I don't know where y'all lives have been. And I said, oh gosh. And I had to do it, and I never forget. I drunk that shit, and I just had kept my lips kind of perched out or whatever till I got in that car. I pulled over to the nearest gas station and went in there and wiped my motherfucking lips. Oh my gosh. But like that's as close as they come, as far as but that's enough. And then they don't be doing fuck shit to each other, whatever. And they don't say they want good things about one another and then talk behind their back smiling for all that extra crazy shit. No. That's what women do. I'm talking about messy women. So I don't know. A lot of strange shit. It can't be explained. I mean, and the answer is it only the roads all lead to one answer. Like, I'm talking about what come out here and baby, kill a bitch. Try to anyway, but nigga. And I say it's some, it's some secretly. I don't give a fuck how many women you can put up, how many you can do. Listen, I don't hear nobody talking. Where the motherfuckers with y'all talking about the shit I do? Y'all can't even get them motherfuckers on the phone. So again, if put it in your face had an award, I would have won that motherfucker every year since I've been out here. If my past was still relevant and present today, had an award to it, I would have won that too. Because obviously, what I can do was doing back then, but who I was doing it with, they still here. I can do it now. Duh. So your argument or your mischaracterization or your ignorance or whatever you try to do, it falls flat. Now, honestly, it sounds stupid. Because I don't even want to do the shit I used to do back in the day. And to be honest, I ain't trying to be funny. Half of the shit, in all my circles, wouldn't get done if I'm not the one that's starting it off. So, try, please. I gotta do better. I just, leave it alone. Like, you're gonna look stupid. But again, I'm not gonna have no more motherfucking elementary arguments. That's crazy. Because they don't even understand what the fuck is going on. And then people who read your shit or whatever, listen to your shit, and they are slow and slow learn development, and they crazy. They gonna say the stuff you post in your lives are BS, which you hear people quote me and repeat me more than anybody, even they slow motherfucking ass. Copy them up, trying to anyway, but can't even understand. They can't get it out, so they have to stop and play the video, write it down, study, go Google, all of that shit. All that shit is time consuming. But they never was a good student in the first place. That's why they ain't stayed at that motherfucker. They brought everything home but books, honey. They brought babies, stolen merchandise, drugs, all kind of shit. Everything home but a baby, but a book, I'm sorry. Everything home but a report card. And again, until somebody can tell me how the fuck, because even if you did get a report card, and I know who the dropouts are, but the ones that stayed there, even if you did get a report card, I know that motherfucker was loaded up with D's, E's, and F's. Tell me how you got that and was able to live. Because we can bring home a C. I brought home my first C in motherfucking 7th grade, and I thought the world was coming to the end. I was crying when I got the motherfucker, but when I got home, it was motherfucking terrifying. One, because I didn't want to disappoint my parents, and two, I knew my ass was in trouble. But because I never got any type of, I got 2 whippings in my life, but I was way young. I wasn't even I wasn't even 7 years old when I got those whippings. But I just knew I was in trouble. Like, where is y'all sensitivity and y'all's emotions like that? Did you not care if you disappointed your parents or not? So you hung up, past the street lights and all that extra bullshit and went everywhere but school and all that shit? I want to hear about that. Those are stories I want y'all to tell. And the problem is, here's the problem where you're so mad at me. I can tell good stories. I done told bad stories. But y'all ain't got no good stories to tell. Y'all good stories, y'all involve selling drugs, stealing, getting shot at or shooting at motherfucking people, and whatever else that comes with that, like not going to school and not getting a higher education and eating sugar motherfucking mayonnaise sandwiches and drinking sugar water because your motherfucking ass hungry. Everybody, it's 50 y'all in the motherfucking house, fucking 25 to a bed and all that crazy shit. That ain't the rest of our stories. That's your motherfucking shit. But leave people fuck alone. And I will bust your ass up with some motherfucking words. Okay? Tell your ass down. Go find something else to do. And everybody, I put on family and friends. Ain't none of them said we live like no shit like that. But I ain't saying everything was all hunky. That ain't what I'm saying. But don't come out here attacking people, especially me, about the way my parents made sure I was good. And the way the men I've been with made sure I was good and still make sure. And if there's some other fucking issues, I have some friends that would make sure I'm good. I told you I've been through that. Where they had to come on through. So I had NFL players, that I heard on the street. What the hell? What's going on with Andy? So sit up here, man, like I don't talk about the bad times too. I don't figure it out. Y'all bad times you were much motherfucking worse. That's why you're mad and angry at me. I have no, well, I don't know what to tell you. But I will tell you. The more you show me that you got a jealousy streak and all this type of shit or whatever, the more I told y'all, y'all kept on fucking with me. And I told you, 2023, 2024, this is what I'm going to display. And you're going to be really in your goddamn feelings. God damn. Now, let me do what you should be motherfucking doing for me. And move the fuck on.
The state objected about on relevance and speculation as to what the state wants. Oh, I actually overruled that one. Never mind.
And Mo, she does have a nervous laugh and a
I made it a different kind of ruling, and I said re-ask your question.
Oh, Mo, you right by her laugh. I want to share that. And our lives be so informative and up to date and in tune with what's going on. And I have to make them personal interjections and shit. Because it still be in me. Nobody can tell me when it should be out. Tell the motherfuckers that brought it out. The motherfucking goddamn don't not to bring it out. What she said? Yeah, she has a chuckle and a frustrated chuckle. She needs on both a nervous chuckle and a frustrated chuckle. Yeah, she really does. And see, I have another observational list and a solution list and a mental athlete. And other people just like that. That be contributing, honey. But Mo, it's something that that this is not, you're not gonna like this. But I also want them to take some Anquil, Ativan, Gabatril, and I don't know, Keppra, I don't know about that one. But some Latuda is going down the list. And what else? Yeah, so yeah, that's about it. I'm putting that on my imaginary prescription pad for some of these motherfuckers too. Yeah, so I am sorry. Tell your hair to lay back down. But yeah. I still got to know. I forgot that word I want to use when you because I'm using maximize and utility, and I really don't want to use that word, that phrase. I got to find another word. Um, Leverage. Damn, that's the word I'm looking for. You got to know how to leverage everything to get where you need to go faster. You got to, figure out some extra money making motherfucking things to do. It is what it is.
based on your conversation with the state, your knowledge of the case, your communications back and forth with the state, your evaluation of the plea agreement you formed, or you observed that the state was just as interested in getting this plea done as Mr. Sledge, wasn't that true? Objection calls for speculation about the state as to whatever his observation is or belief was. It's not pertinent to any material I sustained. And then you followed that up with, was it your observation that the state wasn't really concerned with Mr. Sledge? I think it was with getting Mr. Sledge, but with getting Mr. Williams, which would also have been asking for, what the state wanted or didn't want, which I had just sustained, but asking in an even more pointed way. So it was inappropriate for you to ask that question. With regard, though, to an admonishment, any instruction I give is just going to highlight it again for the jury. So is that really what you want? Why don't I just admonish Mr. Adams privately not to pull anything like that again, or you will get admonished in front of the jury? Would that suffice for now?
Yes, it does. Thank you.
Okay. Are there other issues we need to raise?
I'd just like
I'll
to say,
let Mr. Steele.
Okay.
just for the court, or if you'd reconsider, Mr. Copeland made it clear in his testimony that the police wanted Mr. Jeffrey Williams, that all of he realized.
Yeah, that's a different issue though than prosecution being just about Mr. Williams, which y'all can certainly argue all you want, but that doesn't make that a proper question to have asked this witness.
And just, okay, maybe you resolved it, but you said something I found interesting earlier. I found a lot of things you say interesting, but thrift, T-H-R-I-F-T versus state, seem to agree with the court's, what I think the court was saying. It's 310 Georgia, 499. It's in Division 7, like 6-7. It's a 2020 case. And it seems to say that a question asked is not contained in 17-8-75, but it says pre-termitting. So I don't think they reached that issue, but they clearly didn't reach it, as a statement. I just wanted to.
Okay, I appreciate that. And I do think that's correct. And so I'm glad to hear that an appellate court also came to the same conclusion. Thank you. Yes, sir, Mr. Sharp.
I know Mr. Adams has not finished his cross yet.
Right.
I also have a short
Okay.
cross-examination. I wanted, and as you know, Mr. Botts was flying solo this morning, and I want to be clear. I'm seeking guidance from the court. There's an area of inquiry that I wish to get into, but I don't want to be accused of opening any doors.
Okay.
Mr. Come on, help me out here. Right. Mr. Attorney Wright, thank you. Attorney Wright has testified that there was one specific, and I'm going to have to go up there to see the number. There's one specific, no, not three. There's one specific provision that he asked to be removed, and the state did in fact remove it.
Okay.
And I'm not going to dispute anything like that. I do not plan on getting into the contents of number 8, but I do plan on asking Mr. Wright if, to his knowledge from the review of the discovery, his client made any such statement to the police and any such statement to the district attorney. And the reason I'm asking that is, and then I'm going to conclude it, so this is not a situation where Mr. Sledge said one thing at one point and it was now disowning what he previously said, but rather just a situation where he's never said that.
Okay.
That's it, and I'm not going to get
Contents of number 8 are already in front of the jury anyway, because it's one of the factual assertions that Mr. Sledge disputed, and so those were read out, weren't they?
It's very confusing
They
because
were.
one prior version, number 8,
It's not the same as
is
the
not the
ultimate one.
same. So what I believe Mr. Wright was, what I believe him to have been saying, and perhaps I will confirm by having him point to it when I'm up there, so it won't be read to the jury. I believe he was referring to the part where he said he heard, his client heard someone say, "We caught not
Oh,
add," and then that other number 8 was added in its place. So I'm referring to the original number 8.
okay, I don't know if that was a number 8 or not.
Well,
You'll just
whatever
have
number it
to-
was.
Yeah, you'll have to, because I don't know if he even gave a number.
Okay.
But yeah, that's fine. But I mean, I think that y'all know from, and that's a legitimate question, but I think y'all already know from maybe our discussions up at the bench that I believe Ms. Love made an argument that his knowledge was based on their post-Nutt's death discussions at the condo. And and I may be misremembering it, but I think that was what Ms. Love at least indicated was her kind of basis for putting that in. So if you ask and no, he never made a statement to police, it's then possible that she gets into that. Although y'all, we are getting, I mean, could we focus on what the issues like are in this case, please?
Your Honor, when the court permits, there's one more matter that I think I want to bring.
Okay, so do you have any issue with if Mr. Short ends up asking, that line of questioning? You're gonna have an issue with that?
My response has to do with what Mr. Wright's answer has already been. I actually didn't quite understand what he's asking. If it'll open the door, I'm not sure what he meant. So if he could clarify so that I can respond
Okay.
clearly.
So Mr. Wright is being very clear, and I think the jury gets it, that his client disputed a fact and it was taken out by the state,
Yeah.
which I appreciate. But I think that, heck, if as an attorney, if I heard that, I would be under the assumption that it ended up in the first place, there in the first place, because he must have said that previously and is now disputing it. I'm not going to get into, oh, the state put this in there without ever hearing it out of your client's mouth. I'm not going to get into the dramatics of that. All I'm just going to try to establish is that, to your knowledge, what you asked to be taken out was something that he never said. Not just that he's denying it now, but he never said it.
Okay. Now I understand. So what my response is actually, I'm going to entail a question as well, similar. But so in states 452, while Mr. Wright was on the stand, I asked him about what we're discussing now, and he brought up himself. I don't know how number 8 got in there,
Right.
something to that effect. And he never said, obviously, I told you to check it out. He said it was an oversight on my part. But I asked him whether it preceded, whether number 460, that email that was sent at 8:43 on December 27th, whether it was sent in response to states 452, which was sent at 5:06. He said, well, states 5:06 did not have number 8 in it, right?
Right.
And so that part was fine. But then when he gets to, he said the next thing he sees is states 453, which does have, it has a version of, it has a version of 8 in it.
Right.
But not that exact language.
Right.
As we went back and forth, And he told us what didn't apply and what did apply. What number 8 ended up being was a distillation of that original statement that it contained only the part that he wasn't disputing. So it wasn't a matter of, and
Okay.
that's a
Now,
matter for
your version
argument.
is, that's what he was saying. I think that could be interpreted more than one way. But what Mr. Short wants to ask is, to your knowledge from your review of the discovery and knowledge of the case, did Mr. Sledge ever say, I personally know that somebody from YSL killed Nutt, right?
No.
No?
I'm,
Okay. No.
I'm getting everyone. I'm confusing
Confused.
everyone by
All right. Maybe,
referring to numbers.
okay.
I understood.
They got this good white lady.
I asked, and this is what the state wanted out. I asked the state to remove something.
Uh-huh.
Okay, forget about the numbers 8 or whatever. What he asked to remove was the statement that someone said
We got him bad or something.
got Nutt down bad. Okay, regardless of what the numbers.
Okay.
And I'm not going to ask him what he wanted to get removed. I'm not going to get into the contents. I'm just going to say what you asked to get removed. To your knowledge, your client never said it, and
Oh, that, okay.
in the first place,
Okay.
and when you were representing him, he never told the state that, he never told the state investigators that.
Okay.
Just so it doesn't appear that it's something that he said at one point and is now.
I understand.
So then the question then is not going to be whether or not his client ever said that statement that is now factual acknowledgement number 8.
Right, it's the quote that got taken out from some much earlier version, that is, I don't know where it is because there's so many different versions, but we got, that somebody said we got Nutt down bad or something to that effect.
Of course, I'm not going to say what it says.
Right, okay, but that's what you want to ask about, but you're, okay.
And so, if the court could inquire, if Mr. Sharp, because we have labeled them all so that they're not confusing.
Do you know what exhibit this is gonna be on? I mean, I don't know that anybody,
Or just the date and time.
I don't know, do you have the
I
exhibits
do.
available?
And I gave them
for
to Mr.
review?
Sharp, but
All
if
right,
he'll just
Mr.
tell
Sharp,
me.
can you review and see what exhibit number that is? 'Cause I don't know if it's on more than one. All right, and so if he asks that, he's gonna ask, do you know of anywhere from the discovery that might have come from?
Or in his representation, Mr.
Okay.
Sledge ever telling someone from the state
Okay.
trial.
Which one?
Whatever the quote is.
Yes. Okay. I know it's in Sledge Agreement Updated 2, sent 1:54 p.m. on Wednesday, December 28th.
All right, that's gonna be, I think, 455Y.
That is correct. 455Y. And under number 8 in 4,
Sorry, but that is that is 453Y. 455Y was the one that was sent on December 28th at 1:54 p.m.
that's
Mr.
exactly what I just said.
I'm sorry, I thought you said 1:45. My apologies. Okay.
So it is 455Y.
Right. And I'm not saying it's not in other versions. I just know it's
I
in.
don't know whether it's or not.
I just know it's in there.
All right. And what number was that, please, sir?
It's number 8.
So it's number 8 in 455Y. Okay.
Correct. But of course, not number 8 in the final version because it's not in.
Right.
Okay.
Okay, so you understand what he wants to ask, is that, and I don't know what you think that might open the door to or not.
I think it might open the door to the fact that Mr. Sledge has testified to the fact that he was at the condo with a number of people, one of which has given a statement that Mr. Kendrick and Mr. Stillwell both indicated that they had killed Donovan Thomas using this language. We caught that in Down Bad. And the fact that Mr. Sledge acknowledged being at that condo during that time, if he starts asking, and he being Mr. Sharp, asks, did your review of the discovery reveal that your client made this statement, then it doesn't have any relevance, given that, one, it doesn't show up in the final version, but two, if his whole purpose is to find out the basis for the state putting it in here first, then I can inquire further about what his client did say and what his review of discovery did reveal, whether or not that statement was alleged to have been made during a time his client was alleged to have been at the condo with the person alleged to have made it. So if that's his only reason, then that's what I would offer up. It's opening a door into. That's just from hearing what I'm hearing so far.
Once again, I'm not getting into the contents, and Your Honor, to answer the question, of course it doesn't open the door, but I was just doing this out of an abundance of caution, and obviously the state is trying to jump through a door
And
that's
so
not
is your
open.
question going to be to Mr. Wright, from however you phrase it, whether Mr. Sledge ever said he personally heard that?
I am going to say, I'm not going to use the words personally heard, I'm not going to use,
All right, what are you going to ask?
I'm going to say, Mr. Wright, on direct examination, you talked about requesting that a
Something.
part of
Yeah.
number 8 on 455Y be removed, and the state removed it.
Right.
And without getting into context about what it said, is this something based, and I'm going to get into, you're his attorney, you get discovery, is this something based on your review of the discovery that he ever said to the police? And I'm not going to say what it is, I'm just going to say, is it based on anything that he told to the district attorney or any DA investigators? And I'll say, the thing that you asked moved, it's not a situation where Mr. Wright is now going back on it. It's a situation where Mr. Sledge had never said such a thing. And that's it. And I'm not going to say, oh, the state was doing this and that.
Okay.
I'm going to keep it very simple.
Okay.
That's fine, but we've never alleged that that Mr.
Okay.
Sledge.
I think they just want to establish what he just said as his final sentence, that Mr. Sledge didn't one time say it and then disavow it.
Right.
And given that it's not something that has been put before the jury, what it is, I don't know how it's relevant.
Well, I mean, Mr. Sledge's credibility is obviously an issue.
Right. And the
But-
state is
but-
putting it before the jury that Mr. Sledge has disavowed what's been put in front of him. And I'm just trying to clear it up in front of the jury that
It
he's
is,
not.
yeah,
This
I
is-
understand. It's fine for you to ask that question. Do not ask it in a way that suggests that the state has no factual basis for having ever suggested maybe that's something he could
I'm not going to do that.
agree to,
Not gonna
because
do
then I will let her get into, here's why we said this, okay?
Completely understand.
All right.
Okay, and I think the judge is finding out why this trial is taking so long. Okay, 'cause she came there with her white principles, and and her white ways on how trials normally proceed, right? And what is the normal goings on. She is finding out now why this trial is taking so long. I mean, they are on both sides are very good, regardless if you like them or not. I'm looking at it from a professional view. And they are nitpicking every goddamn thing. All right, I mean, she is having to deal with shit that they are like predicting or forecasting that they may say they may have, and you have to deal with that. But like, not on this scale, right? And they have a lot of witnesses that they have to do double the work with, right? Because of the prior inconsistent statements and all of that. Normally, your witness, you just have to make sure that they seem credible. With the witnesses that the state is putting up, which are being both beneficial to the state and to the defense, because of that, they have to make them seem credible at times and make them seem incredible at times. There's a lot going on. If y'all ain't picked up, I know a lot of y'all have picked it up, but there's a lot of shenanigans going on and make you say, babe, I'm gonna get my pocketbook and I'm finna walk out the goddamn door. But as that attorney said that got on the stand, he was saying that the counties that we won't let you get off the. And I told you, Georgia is a very, 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 very tricky place. East Coast law is a motherfucker anyway, right? But Georgia, Josh Shabuki.
Everybody understand that? That's going to apply to anybody that might examine Mr. Wright. Okay.
So,
All right. What else?
so Your Honor, once Mr. Okay, I'm not going to follow up. I'll just redirect if necessary. But number 3, Mr. Wright made a particular statement on cross, I think, as it relates to number 3, or it may have been under rec, but I think it was number 3, and Mr. Adams followed up on it. And the question was, you asked that number 3 be changed, and then number 3, the state refused to change it. Now, given that assertion has been made and has been affirmed by the witness, we believe that the content of number 3, which I think has already been put before the jury because it was played. I think that the content, just number 3 alone, from Mr. Wright's December 27th, 2022, 8:43 p.m. email to the state, the statement that he makes, the video may have seemed like the issue was gang related, but it was actually about a girl that Sledge was dating, and Kel started kicking it with her. That was the real issue behind that. Not denying the video, but the real issue was the girl. I think that at this point, the language of what Mr. Wright responds with becomes very important because of the characterization made during cross-examination, which was that Mr. Sledge asserted that number 3 was false. And Mr. Sledge has stated that he feels like it was false, and then Mr. Wright asserted that it was false. But the language that Mr. Wright used to correct that assertion does not, it does not assert that Mr. Watts was not a rival gang member. In other words, it does not dispute any material aspect of it. So the only part that we would be asking to Mr. Wright to tell the jury verbatim is what his response was to number 3, so that the jury can fully understand and appreciate what it is that everybody is saying the state refused to change.
I can make this easy. I'll read that. number 3 from Mr. Wright's email out loud to Mr. Wright on cross-examination. And the jury will get to hear it. I'm fine with that.
And on behalf of Mr. Williams, I don't have any objection to that. I asked the question, I believe, and it was specifically because Mr. Wright had on cross-examination said that on that one, number 3, he specifically asked that it be either accepted or changed. And so I don't think to that. I think the subject matter of that language is
All
appropriate.
right,
Okay, good, then that means I can get, okay.
all right, sounds good. Anything else? Okay, let's get Mr. Wright and the jury. And Mr. Adams, you
Your Honor,
come
can
on up too.
Can we approach really quickly regarding a witness? Hang on.
Yeah. Hold on the jury. Mr.
Lord
Wright.
have mercy. This is crazy. This is crazy. Oh my gosh. Granny, you really, you should have thought about this before you built this case. If you the one that put it together. This is crazy. But you know what? I hope those of you that have friends I assume that you're good to your family, but your friends and my family are because chasing a dollar and chasing some other shit it ain't important. And I always, like when I have a goal or something, I always block off a period of time to to do that or whatever. But I don't know what happened. I really don't. I tell you, I'm so sick of this motherfucking stream, y'all. For 40 something motherfucker. Are you crazy? The other thing I, I was on was Restream. I'm gonna see if they have gone up too. This is some bullshit. Let me connect back to Twitter real quick. Got to have a Twitter folks. Twitter folks be in 100 to 1, baby. I'm trying to tell you. John Cena follows this channel. I might want to see if he want to follow my real channel. Hell, I like to have them celebrities or them organizations and shit. Hell, yeah, baby. Stop playing with your mom. Yeah, I want to see if John Cena want to follow my real channel. And it's him too, because there's 1 million some followers, blue check. It's him. What I was saying is about making time, right?
All right, welcome back, sir.
Thank you, sir.
All right. I think when we left off, Attorney Wright, I was asking you, we had gotten to the point where I was asking you questions about the,
Oh, real quick, our families were the first people to love us, right? Okay, and then our friends, right? And then, all the others in our, like our school and our professional world, right? So, that being said, I think we should, try to make more time for the, people that matters. And some of the people that you thought was cool or that could have possibly been friends and family, whatever, shit happens. And they fall by the wayside. And sometimes you become so close to whatever, you begin to act alike, you begin to talk alike, think alike, things of that nature, right? Which is a good thing, which is supposed to be a comforting thing, right? And even when the shit rolls up, it still should be that way, right? But that's not always the case. So we should make time for those friends and family that, we do have those low ups. There's nothing that we can't come back from. Alright? Still trying to hook up a goddamn 12.
the actual plea on the 28th of December. About the actual plea on the 28th of December. Okay. So I want to pick up there. All right. At the end of everything, all of the discussions, the plea agreements, conversations with your client, ultimately, Mr. Sledge,
Yes.
and he was sentenced, at least in part.
Yes.
And he was released from prison, from jail. True?
Yes.
Part of his sentence, the requirement of his sentence was he had a curfew. Is that right?
Maybe so. I'd have to refer to it, but it sounds
Okay.
reasonable.
10 to 6 sound like what you remember, if you remember that?
Again, if the curfew was in place at the time he first got released, yeah.
Okay. It's fair to say that even after he had entered his plea and had gotten out of jail, he had conditions on him pursuant to his plea and sentence. True?
Correct. And it was always an unknown, is he going to have to appear, testify, and go through this?
But that was, of course, something that was, and I'll use the phrase hanging over his head. That was a condition that was upon him. Yes. The possibility of him testifying. True?
Yes.
And of course, the discussions that you would have had with the prosecutor and with your client, again, I'm not asking you specifically what you told him, but subject matter is that if he were to testify, it would be expected that he would testify truthfully and consistent with that plea agreement, correct?
Correct.
All right. Now, it would be fair to say, and you tell me if I'm right or wrong, that you would, of course, make him available to speak to either the state and or the defense in preparation for his testimony.
Correct.
And previously with other clients, and I presume with Mr. Sledge, it would have been incumbent upon you, and you would have discussed with him the necessity of testifying if he were to be called in, testifying truthfully, correct?
Correct.
You've heard the phrase before. He's used the phrase, and it's been here in court, where he said he was of the impression that he would be able to get up and testify to, quote, his truth. You heard that?
Correct.
Okay. You knew and you understood.
Like, what is going on? I apologize. I don't know what's going on. Okay, how to get? I don't know. Yes, I I'm all the great
That's it. And that was one of
memorializing
the reasons he asked it.
that went on during that time frame.
22 to when the state made plea agreements, conversations with your client. Ultimately, Mr. Sledge entered a guilty plea, correct?
Yes,
And he was sentenced, at least in part.
yes,
And he was released from prison, from jail. True?
yes,
Um, part of his sentence, requirement of his sentence was he had a curfew. Is that right?
that sounds
Okay.
reasonable.
10 to 6 sound like what you remember, if you remember that?
Again, if the curfew was in place at the time he first got released, yeah.
Okay. It's fair to say that even after he had entered his plea and had gotten out of jail, he had conditions on him pursuant to his plea and sentence. True?
Correct, and it was always an unknown, is he gonna have to appear, testify, and, go through this?
But that was, of course, something that was, and I'll use the phrase, hanging over his head. That was a condition that was upon him,
Yes,
the possibility of him testifying. True?
yes,
And of course, the discussions that you would have had with the prosecutor and with your client, and again, I'm not asking you specifically what you told him, but subject matter, he would testify truthfully and consistent with that plea agreement, correct?
correct.
All right. Now, it would be fair to say, and you tell me if I'm right or wrong, that you would, of course, make him available to speak to either the state and or the defense in preparation for his testimony.
Correct.
And previously with other clients, and I presume with Mr. Sledge, it would have been incumbent upon you, and you would have discussed with him the necessity of testifying if he were to be called in, testifying truthfully, correct?
Correct.
You've heard the phrase before. He's used the phrase, and it's been here in court, where he said he was of the impression that he would be able to get up and testify to the court with his truth. You heard that you had with the plea agreement, that his truth might not necessarily agree with the verbatim reading of the plea agreement.
Objection
True.
vague as it relates.
Rephrase the question. You knew that he did not agree with everything that was in the plea agreement, correct?
I understood that he did have issues with, yes.
Moving forward then from that period of time, December of 2022, to when the state made contact with you about speaking to Mr. Sledge in June of 2024, you made him available at that time, true?
Yes.
And if I heard your testimony, the testimony properly, this was a meeting that took place at the Starbucks, correct?
Yes.
Would have been yourself,
What is going on? What the fuck is going on? I don't know why it's timing out, y'all. Oh my god. What? 28. What happens with this? What is it doing? Okay. It will not let me beat right, honey.
As Mr. Sledge of what they would be asking him.
No, there were general questions again, but it was not, often when you think about prep, witness prep, you think, hey, got 20 questions here, the 20 questions on it wasn't anything like that. It was really more of a introduction to each other, get to know you kind of meeting.
It did not appear to you to be what you would consider a witness prep session.
Correct.
And that was on June the 9th of this year, correct?
Objection as answered.
Hey, Mr. Adams, can Helen just focus in on what it is that, I mean, we're all familiar with what he's already testified to.
At any time after June the 9th of this year, and when Mr. Sledge was brought in to testify, did the state ever, in fact, conduct a prep session with him where they asked him or discussed questions they might ask him on the stand?
Objection.
No.
Relevance.
No. That was, like I said, we met the one time, and then we've appeared for trial. And to be clear, we appeared to trial a couple times when we weren't called, but they did not ask questions or anything. We just sort of waited. So again, trial was really the next instance of any communication between the state and our client.
Did Mr. Sledge at any time ever indicate that he would not comport with his plea agreement and come in and testify? Did he ever exhibit any reluctance to come in and testify?
No.
Did he ever attempt to avoid a subpoena or to avoid reporting when he was asked to report?
Relevance.
No, in fact, for us, in our posture, we wanted to make it clear if they need to meet with us, see us, when we need to come in, we were always going to make sure we are there and make ourselves available so that at all times it's clear we're fully cooperating.
During the course of that meeting, you described, and I'm going to use your words, that when Mr. Sledge started talking about what Jeffrey Williams had said about taking Woody down to see the police, that, quote, the prosecutor didn't seem to like that topic. What
I said then were words to the effect, and I'll say it again now, that she made it clear that wasn't what she asked him, which is true. That wasn't the question that I heard her ask him. But ultimately, my observations were that it was a topic that she wasn't asking about. And again, it just sort of raised a red flag for me that, is this a hot topic? There's something to that.
When Mr. Sledge testified that the prosecutor said to him, quote, I'm not going to ask you about that, do you have a specific recollection of him, of that being said?
What I can say is, again, I didn't hear Ms. Love say that, but I do know my client indicated that's what he heard. So we were both present, but we heard things differently. So yes, he has always contended that's what he heard. And again, to the extent that what I heard was not the same.
Did he contend that prior to him being put on the stand? Let me rephrase that question so it's clear.
Okay.
You heard his testimony when he testified to that on the stand, am I right?
Yes.
Had he indicated that to you, that sentiment to you, that that's what he heard prior to him coming in here and testifying?
Yes.
I want to, almost done, just have one or two last questions for you, Mr. Wright. I want to jump back to early December of 2022, when you were having the back and forth with the state.
Okay.
In regards to the plea agreement. And if I heard you correctly, that was between essentially the 27th and 28th, is that right?
Yes.
Do you recall stressing to the state or sending them a message, specifically telling them that you were ready, he was good, Mr. Sledge was good to take the plea, he didn't want any media, and that he just wanted to get back to his family? Do you remember expressing that sentiment to the state?
I did.
One moment, please. Attorney Wright, thank you. That's all I have at this time.
Thank you, sir.
Thank you, Mr. Sharp.
Good afternoon, Mr. Wright.
Good afternoon.
Attorney
sir.
Wright.
Good afternoon.
May I approach to just see what the witness has in front of them?
You may.
This is 1AS, which was that final. These are just my own little notes. This shouldn't be. These are all just my own notes. Okay.
Just gonna put these in front of you.
Sure.
Thank you, Your Honor. Attorney Wright, on direct examination,
Mhm.
you made reference to identifying a portion of a certain factual acknowledgement that you and your client disagreed with and bringing it to the attention of the state, correct?
Yes.
Well, you mentioned several,
Mhm.
but there was one in particular that the state changed for you, correct?
I need you to give me a little more info
Okay.
on which one.
And I'm not going to get into the contents of it, but it's in what's been marked 455Y.
Okay. I'm not seeing 55. Let me, one more time. 6.
State's just handing it to me.
Okay.
One approach.
It is.
Okay. Yes. Yes.
Now, we're throwing a lot of numbers at the jurors.
Okay.
Just so we know what we're talking about, 455Y is not the final plea agreement with the final factual acknowledgements, correct?
No.
Okay. On 455Y, on factual acknowledgement number 8 on that document, not the final document, but number 8 on that document, isn't it true that you identified that factual acknowledgement and said that you had some problems with that factual acknowledgement? And I'm specifically the last part of it.
Yes.
Okay. Now, as the attorney in this case for Mr. Sledge, you received discovery, correct?
Yes.
And you were able to see what your client may have said or did not say to any police officers.
Correct.
Okay, and certainly you were representing your client and are aware of what your client may have said or didn't say to any district attorneys.
Okay.
And you're aware, you would be aware of what your client would have said to any district attorney investigators, correct?
Yes.
Okay. The part of factual acknowledgement number 8 that you asked to be removed, and the state removed it. Okay, you with me?
Yes.
The state removed it, we agree?
Yes.
Okay, that part that you asked to be removed, from your review of the discovery and from representing your client never said such a thing, correct?
I can say that my client never said or adopted that statement. And that was one of the reasons he asked it to be removed.
Okay, and I understand he didn't adopt it, but to your understanding, he never said it.
Correct.
Okay, and that's why I'm just trying to clarify. That portion that you asked to be removed is not something that your client once said and is now disowning or saying he's changed his mind. It's something that was never said.
Objection, asked and answered twice.
That's correct.
Okay, thank you. I just want to talk to you about the timeline of you receiving the plea offer and in actual pleading this case, okay? You received the first version of the factual acknowledgements, you would agree, at approximately 5:00 p.m. on December 27, 2022?
Yes.
Okay, and that was the day before the plea was entered.
Correct.
And as I understand, I'm not going to belabor the point, as I understand, you went to 901 Rice Street, the Fulton County Jail, to discuss the plea offer with your client.
Yes.
Okay, Mr. Sledge. And do you recall how long you met with him that day?
Now that I don't know. It would have been long enough to make sure we're going over things for me to get a good idea of what his response would be to our conversation and the things I was going over with him. And then at some point I would leave. And then, of course, as I said, later prepare a response email to the state.
And this meeting with your client, was this you were in the attorney booth at 901 Rice Street?
Yes.
Okay, and as an attorney, or when you met with Mr. Sledge, you were on one side of the booth, there's a glass.
Objection, relevance is to.
I'm discussing their ability to go over this document.
Overruled.
There's a thick glass barrier in between you and Mr. Sledge for this meeting.
Correct.
And he's on the other side of the thick glass, correct?
Correct.
And of course, you have to talk loud, but you can hear each other, correct?
Correct. And let me at least so you know, because this is some time ago, I'm assuming I was, again, because we are almost always in the attorney booth. We get a little key, we can unlock it, we can go in. We can also hand documents back and forth.
Right.
that is my recollection of how I met with him, which meant I would have been able to hand him a copy so he can read it, I can read it, at the same time and go over whatever we need to go over. I'm sort of stating it because it's so long ago. Is it possible that I just saw him through one of the more window only kind of things where I could not have handed him stuff? Possible. I don't remember that. I remember being in the attorney booth.
Okay,
But
so
I just wanted to point out that, yes, we can talk as well as hand stuff to each other
okay.
to review.
Well, let's let the jury know what we're talking about here.
Yeah.
So if the attorney booth, if someone's in the attorney booth, if it's being used, if it's occupied, you can use a visitation booth, correct?
Correct.
And that also has thick glass in between you and the person you're speaking to, correct?
Yes.
And the main difference is there's no pass through in those
Correct.
booths.
We
Okay.
can, all audible stuff's the same, but you just can't pass stuff back and forth.
Okay. And of course, when you met with him on the 27th, met with Mr. Sledge on the evening of the 27th, you had whatever version of the plea agreement was in effect at that point, but not the final version.
Correct.
All right. Could you refer to 1AS
Okay.
for me?
I have it, sir.
Okay, thank you. You would agree that in the negotiations with the state, your client pled to count 1, which was conspiracy to commit RICO violation, correct?
Yes.
And he was facing 15 years to serve. He was sentenced, the agreement was 15 years to serve on probation, correct?
Correct.
Okay. And then count 30, he did plead guilty, and according to this agreement, sentencing was withheld
Yes.
and would be dismissed if he fulfilled the agreement.
Yes.
Okay. At this point, sentencing is still withheld, correct?
Correct.
And the maximum he's facing on count 30 is 15 years, correct?
Yes.
Okay. So right when he testified earlier today, he had a 15-year sentence hanging over his head as well as the probation.
Correct.
Okay. And so his maximum exposure is 15 plus 15, correct?
Yes. I mean, technically less, we'll say any time he's already ticked off since the agreement. But generally speaking, it's 15 plus potentially another 15.
So, and at this point, if he's done a year on probation, it would be 29 years instead of 30 years.
Correct.
Okay. Now, you indicated in your review of the final plea agreement, there was one factual acknowledgement that you testified you missed, correct?
Correct.
Number 8 on the final agreement, you missed.
Correct.
And, well, I'm not going to ask you to speak on behalf of your client, but you missed it.
Yes, I can only say that I missed it. And had I seen that, I would have immediately, because it was of a certain subject that from the very beginning, we had sought to exclude from this. But ultimately, for whatever reason, we missed it.
Okay. Can you, in sentencing acknowledgements, number 5 on that final agreement, defendant sentencing acknowledgements?
Yes.
This final plea agreement between Mr. Sledge and the state, as reviewed by yourself and Mr. Sledge, indicates that your client is facing as much as 35 years in confinement. Isn't that correct?
Correct.
That's what the agreement says.
Correct.
Okay. In fact, he's facing 30, maybe 29.
Correct. It would have been a max of 30. I'm not, so 35 was incorrect.
Okay.
So
Your Honor, I object to the characterization. The language, I'd object to the characterization, and I don't want to speak further, but the question was posed whether it said he faced 35 years, and that is an incorrect characterization. I can,
Okay, do you want to rephrase?
Does the document say that if your client does not fulfill the obligations of this agreement, it may result in defendant being sentenced to serve as much as 35 years in confinement in the Georgia Department of Corrections?
that is what the document indicates.
Okay, is that your client is facing 35 years?
I think it would be a more correct statement to say 30, but
Well-
point is 30 or 35, a whole lot of time.
Well-
But yes, I think the correct number is 30.
All right, you're making my point for me.
Gotcha.
You signed an agreement where your client was facing, you and your client signed an agreement
Mhm.
saying that your client was facing 35 years.
Correct.
And he was really only facing 30 or less.
objection, ask
Okay.
and answer.
Yes.
Your client on that final agreement, there's a word that's crossed off and initialed by your client, correct?
Yes.
Okay, begin was changed to being. It's just switching the letters, right?
Yes.
Okay. And that was crossed out and written and initialed by your client, correct?
Correct.
All right, and you've reviewed the video tape. You were in here when the video was played
Well,
of your
yeah,
client taking a plea?
I was there.
Okay. That was something that Miss Love caught and instructed Mr. Sledge to cross out an initial, correct?
That sounds correct. Yes.
All right, that wasn't something that was caught by your client.
Correct.
Okay, Mr. Wright, you, in addition to what I first asked you about number 8, the portion of number 8 that you pushed back on the state and they changed, you also pushed back to acknowledgement number 3 on the final plea agreement, correct?
Correct.
And Your Honor, may I go back?
Yeah.
Okay, and number 3, which you pushed back on, regarded the video that your client made with Quindarius Zachary, where he was, we'll say, threatening a gentleman by the name of Kelvin Watts, correct?
Correct.
Okay, and you're aware that the factual acknowledgement indicates that your client, while associated with YSL and to support and express loyalty to YSL, made this video.
Correct.
And it indicates, the acknowledgement indicates that the video was made on behalf of YSL, correct?
Correct.
Your-
Okay.
Your Honor, I'm going to object to characterization.
Sustained. I mean, if you read it carefully and then rephrase.
On behalf of YSL, defendant threatened to harm a person named Kel.
You can ask that.
Okay, but the acknowledgement indicates that on behalf of YSL defendant, that would be your client, Mr. Sledge, threatened to harm a person named Kel, correct? That's what the acknowledgement says.
Yes.
Okay, and you pushed back on that and you sent Ms. Love an email, correct?
Correct. Actually, we began taking issue with that characterization from the very beginning. And this was, I think I testified an example of where we felt one way, the state felt another, and that was one of the examples where it was not changed.
Right. Okay. Do you have the emails? Actually, this might be.
460 is right here.
Do you have 460 in front of you?
Yeah.
No.
462, 461.
He-
One moment.
This is the only 460.
Ms. Love gave me this one.
Oh,
I'm going to
okay.
approach, if Your Honor will allow. I'm handing you what's been marked as 461.
Yes.
Going to read to you from your email what you said about acknowledgement 3 to Ms. Love. And this email was sent on December 27th at 8:43 p.m., correct?
Yes.
Okay, and this is the night before Mr. Sledge entered his plea. Correct?
Yes.
Okay. You wrote regarding number 3, the video may have seemed like the issue was gang related, but it was actually about a girl that Sledge was dating, and Kel started kicking it with her. That was the real issue behind that. Not denying the video, but the issue was the girl.
That was verbatim.
Oh, okay, so the point you were trying to get across is you're not denying that your client, Mr. Sledge, made the video,
Correct.
and you're not denying that he had an issue with Kel,
Correct.
but that issue was about a girl.
Yes.
And you ultimately, the state was unwilling to change that factual acknowledgement in the plea agreement, correct?
Correct.
They were unwilling to take out that it was done on behalf of YSL,
Correct.
and they were unwilling,
Your Honor, my objection is vague when the question is they were unwilling to take out that it was done, and earlier Mr. Sharp referenced video, if you could just clarify.
Sustained.
okay, they were unwilling to change the factual acknowledgements on your client's plea that he was to sign the next day, right?
Well, again, some changes were made, but as to that specific one,
I'm talking,
that was one example of where they were not willing to change it, even though we had a difference of opinion as to what it was about.
and,
So the it is still unclear. So
and
if you-
factual acknowledgement number 3, I'm sorry, yeah.
Okay.
Yes, my objection was to, could they specify what it we're talking about? in terms
And it may help.
Factual acknowledgement number 3, which relates to the video that was made
Yes.
with your client and Mr. Zachary in it, correct?
Yes.
Okay. The state was unwilling to change the language that it was done to support and express loyalty to YSL, correct?
Correct.
And they were unwilling to change the language that it was done on behalf of YSL.
Correct.
And Your Honor,
Yes.
again, I object.
You can
as to
clear
the
it back
characterization.
up on redirect, or are we already? Yeah, that was,
I haven't
you
done a
still have
redirect.
redirect, so you can clear it up then.
They were unwilling to change the language where it said, wherein on behalf of YSL, defendant threatened to harm a person named Kel because of that individual's association with a rival gang. They were unwilling to change
All
it,
right,
right?
all right. I think that the state's objection is a valid one, and I don't know if you want to, if you need direction, but why don't y'all approach?
Okay, Attorney Wright, do you remember at this moment, in your email, you did not indicate specific changes that you wish to have made, correct?
Actually, in my email, the way I even described I put, here are recommended changes, and then I went number by number, all the way 8 through 13 for
Okay.
the agreement I had at the time.
I get it. It's not like you went through it like you do in Microsoft Word and mark it with red or anything like that, like an editor would, correct?
Correct.
Okay, but the point you were conveying in that email was it was not gang related, correct?
Correct.
And it was over a girl,
Correct. As to that issue number 3.
as to number 3. Okay. And ultimately, the final version of Mr. Sledge's plea agreement includes language. You would agree that it includes language that indicates that the video and the making of the video and the threats were gang related.
Correct. That number 3 is an example where there was not a meeting of the minds with the state, and that's where they did not remove the information, consistent with what we were suggesting be removed.
And the gang related versus a girl was where the meeting of the minds was not happening, correct?
Correct. I mean, ultimately, the state included sort of both things in there where we were saying it was really about the girl.
Right. And you told Mr. Sledge that he could explain this later to a jury.
Objection, Judge. One that asked, answered, and province of attorney-client privilege.
Then attorney-client privilege.
Okay. Mr. Wright, from your dealings with Mr. Sledge, you are aware that Mr. Sledge did not completely agree with factual acknowledgement number 3.
Objection, asked and answered.
Sustained.
On the date that he pled, he did initial that factual acknowledgement, correct?
Asked and answered. Yes.
Your Honor, this is the first time I'm questioning this.
I know, but lots of other people already have, and we've gotten that information at least a couple of times.
Okay.
I mean, you're welcome to ask whatever it is that we're leading up to.
I believe on cross, you indicated that in negotiations, you can't have everything, and sometimes you have to live with some things, correct?
Correct.
And your client initialing number 3, even though he didn't completely agree with it, is an example of having to live with things, correct?
I think I previously did state that number 3 was an example where there wasn't a complete meeting of the minds, but his choice was to either walk away and proceed with trial or enter into the plea agreement.
To go home, Mr. Sledge would have to live with that as part of the negotiations, correct?
Objection, Your Honor, that part is asked and answered. and-
Sustained.
All right, here's my question. Is it fair that Mr. Stillwell would have to live
Objection,
with your
Honor, asked
client?
and answered.
No.
I'm sorry. That is not what I meant to add. Objection, relevance and improper question. Is it fair that Mr. Stillwell will have to do anything is an improper question for this witness. So forgive me for
Sustained.
Was Mr. Stillwell a party in these negotiations?
objection. That is, again,
I'll permit that question.
Was Mr. Stillwell a party in these
No.
negotiations?
And-
Was your client signing a factual acknowledgement that wasn't true? Is that something that Mr. Stillwell should have to live with?
objection. One,
Sustained.
The signing of these incorrect factual acknowledgements, you would agree that it affects more people than just Mr.
Objection, Your
Sledge,
Honor.
correct?
Overruled.
I will state this. Any person in a case where there are multiple defendants, once they enter into a plea agreement that includes certain factual stipulations, that can impact all the defendants, not just themselves. So to your point that yes, when Mr. Sledge was completing his plea, his focus was on him.
And your focus
Your
was,
Honor,
and your focus was
Hang on
on
just a
him.
second. Hang on.
And my objection was to the characterization of the incorrect or improper factual acknowledgement. So the answer, I think, sort of dealt with, but my objection was that that was a mischaracterization or improper characterization.
Was
All
factual,
right, well,
was,
the jury's heard the testimony, so.
was factual acknowledgement number 3 completely correct from your client's perspective?
We indicated that we took issue with some of number 3. Some of it we were acknowledging and some of it we took issue.
And he initialed it and he got to go home.
Correct.
Objection. I
And
didn't ask him.
it affects these other gentlemen back here, correct?
Ask him, ask him.
Sustained.
No further questions.
Okay, does any, John, questions? Questions, Mr. Williams or Mr. Harvey? Okay, all right. Anybody need a break before we do redirect? Okay, let's take a quick kind of 10-minute break. Try to be back here close to 3.
Your Honor, may I ask for that?
Yes.
Okay.
Wasting time and wasting money. However, there's a reason for all of these things that is being done. Okay, it's to benefit or to give one side or the other a leg up. You know what I'm saying? Like I said, goodness. I hope the people that tune in or that tune in understands the law so you can understand what I'm saying. I know that, and what I mean by, let me change that. You can understand the law, okay? Let me say this. I hope people understand the law from a, this is going to be confusing, right? But from a psychological perspective, right? Because if you don't have any legal experience, then that's the next thing I'll need you to go to understand what I'm saying. Okay. Much about this process is about stress. Okay.
Thank you. You're right. You were asked in coronation.
Is about presenting your story, establishing your point, making sure you do it within the guidelines of the law, making sure you meet the goals and objectives of your indictment, proving on your elements and facts that you have stated in your indictment. Okay? So, when something such as a witness do damage to your strategy and all that shit I just named, you have to recover some kind of way, right? You have to, just like you're playing a game of spades and you fuck up. A lot of time I don't be paying attention and, so on and so forth, whatever. And I don't let a book go. Now, either my partner or myself got to find a way to get another book because I done fucked up. You know what I'm saying? It's the same kind of concept. So what happens is, instead of going on with the normal, what your plan, you got to deviate a bit. This is a deviation, which I was calling it out before everything was happening. I told you she was going to have to dig herself out that hole, and I told you what the hole was. That boy put her in there by saying what he said about the pressure on the plea agreement. Now, I know folks that don't understand the law from a psychological perspective and don't know from a legal professional perspective, and you're gonna just look at it basic, somebody's, they just wasting time, they're doing wrong, each side is doing each side wrong. It's just real basic, and you don't understand the structure. You don't understand how the RICO is put together, how everybody can be held liable, or none of that. You just don't get it. Okay? Now, if you was out here with Mr. Kelly, you should understand RICO. There shouldn't be a question about it, because we covered it extensively. Okay? And the people that I assisted in their knowledge about the law, let's see, now when you become my enemy and shit like that, that change shit, or you put me in a snitching position, that's what I'm going to do. Just don't get, But they came out and spoke, at least gave you the textbook definition of the RICO. So everybody should be speaking intelligently with regards to this, or again, use, in my opinion, but hey, it is what it is, right? There are other sources that you can go to get the information. There's a girl named Katnot Williams. I think Attorney Kayla Bumpus sometimes, goes into it. Hey, Karen, I might do the debate tonight. I don't know. I'm trying to get my hours up on Twitter and stuff like that. I don't know. We might do the debate tonight. That'll be fun to watch and educational. And then we can throw up a poll. My plan was always to throw up a poll every live, but I be forgetting that. So, but anyway, the thing about information and education is to pass it along. But you need to pass it along, correct information in the correct way. This is in my opinion. Those are my thoughts and feelings on the shit, right? And I can't ask for people to take their personal feelings out of it and use their professional feelings because there aren't too many professionals around here. And you have to understand that they are going through all of these, all of this extra shit for a reason. If it wasn't for a reason, then it wouldn't be allowed. So while they, when I say they're wasting time, I'm looking at the bits and pieces, where they are wasting time. Meaning they're asking questions that I feel like are unnecessary and are repetitive at this point, right? I'm not saying that this process isn't. This process is a waste of time because, again, this is something that was created by the state's witness. And now they got to do all this extra shit. Okay, if I were in here with the law students that I came to this sector with, for some reason, I don't know why I told them to come here. I told them that maybe we would do some kind of study or research or a project involving, in this case, Hunter. I quickly changed my motherfucking children. But they would understand, even the first year, they would understand that this process is, although it's a waste, for a lay person, oh my God, it's a waste of time. But for a lawyer or legal professional, we understand why they got to waste this time. You understand what I'm saying? It's a pain in the ass, but hey, this is a situation that love created. I call it Child Shibuke. It starts 9, I think, Eastern Standard Time.
Mr. Sharp, I believe, regarding factual acknowledgement number 3 that
Okay,
was
Ms. Karen.
contained in the final plea agreement that your client signed. Do you recall that?
Yes.
I want to ask you whether State's Exhibit 452 Yankee, which was sent at Tuesday, December 27th, 2022 at 5:06 p.m., as indicated by its label, was that document, the document that preceded the email in 460 Yankee from you dated December 27th at 2022 at 8:43 p.m. I'll let you look at that. Paying particular attention to number 3 in State's 452 Yankee.
Yes, it does appear to be number 3 in Exhibit 452 Yankee is what my email note was referring to.
All right. Would you please read exactly what number 3 in State's Exhibit 452 Yankee says that was sent to you before you sent the email in 460 Yankee?
Okay. Wallace associated with YSL and to support and express loyalty to YSL, defendant and co-defendant, Damian
Demikian,
Garlington, and Quindarius Zachary appeared in a video with another person, AS, wherein the defendant brandished a weapon used in a drive-by shooting, and wherein, on behalf of YSL, the defendant threatened to harm a person named Kel because of the individual's association with the rival gang.
Now, exactly what did you respond with relation to number 3 when you sent that email in 460 Yankee?
Objection. That's
Your
been asked and
language.
answered.
What'd you say, Mr. Adams?
Asked and answered.
I
Yeah.
gotta allow some leeway.
Go ahead.
In 3, I said the video may have seemed like the issue was gang related, but it was actually about a girl that Sledge was dating, and Kel started kicking it with her. That was the real issue behind that, not denying the video, but the real issue was the girl.
On any part of 460 Yankee or any other communication you made with the state, did you ever assert on behalf of your client that Kelvin Watts was not a rival gang member?
No, I did not go
Oh,
into, no.
Okay. And
He can explain his.
Your Honor, I don't mind explaining, but I wanted to ask, with the court's permission, certain questions that are frankly binary questions, yes or no, and then if he could be allowed to explain, I would
Okay,
just
well, he said no, and he was
Okay.
about to explain, so you may follow that up your no if you want to with something else.
go ahead.
I was simply gonna say no. But again, the whole point I was trying to make is that it wasn't, from our perspective, really a gang-related issue. It was a girl-related issue, and then ultimately, you did change it. However, the change ultimately sort of included both. That it's a girl issue, but you also kept the fact of some of the YSL and gang contention. And that was just what I would say is sometimes in negotiations, you agree to disagree about, what was at issue.
Okay. I'm going to ask you the next question. Did you ever indicate in any way on behalf of your client that your client was not associated with YSL as stated in the first part of Section 3 of 1A(s), the factual acknowledgement?
There has never been a time where I've ever contended or represented to you that my client was not YSL.
Okay. And is there ever any indication from you through your client, from your client through you to the state, that the portion that says where a defendant brandished a weapon used in a drive-by shooting is incorrect, inaccurate, or false?
The answer is no. And further, again, we took no issue with the video. The video is what it is. The issue was just, we were saying sometimes what the motive was. The motive was a girl-related motive, not YSL. Yes, he may be YSL, and yes, the video he does.
Hang on just a second.
Object to the response that he may be YSL, that invades the province of the jury.
Your Honor, we're talking about his.
Overruled.
Okay, go ahead.
Maybe, again, it's contended he's YSL. Maybe, and the video is what the video is. We were simply taking issue at the motive or why the video ended up being created had more, it was focused because of this girl situation between two guys. The fact that Kel or my client or whoever they are was a secondary and what we said not the primary issue.
Okay. Did you ever indicate on behalf of your client in any fashion, whether in 460 or some other way, that the portion wherein on behalf of YSL defendant threatened to harm a person named Kale was false?
No.
All right. All right. So is there any statement contained in State's Exhibit 1AS, Section 3? Is there any portion of 1AS, Section 3 that your client, through you, contended was false? At any time that you conveyed to the state?
The part which says that ultimately his actions in the video.
Wait a minute. Where's the word ultimately in that?
Okay, well, no,
Sustain.
Okay.
He's
Okay.
trying to explain it.
okay, I'll just start by reading and then I'll pause and explain the part. While associated with YSL, comma, and then here's the part, and to express support and loyalty to YSL. That part is, again, it was not a gang motive. That was the part that my comment would take issue with, that he wasn't shooting this video or making any comments or doing anything. This was about the girl, not about trying to support or express loyalty to YSL. Now, the rest of quite honestly, the rest of it is essentially just describing the video. It's correct. And then ultimately at the very end where it was added, had begun a relationship with defendant's ex-paramour. That was correct. So the only issue was an inference that it was in the furtherance or in support and express loyalty to YSL. That was the only part that we took issue with. So that's where, when I say sometimes there's something where we agree, but also part of it disagree. That was the part of disagreement.
And to not split hairs, but did you at any point say in your email or anywhere else that that part is factually incorrect?
No, but also understand my email came the day before. As we started getting into these later versions, I was here in court. I wasn't sending emails. At that point, we were communicating verbally back and forth because we were sort of both here. So but the point being is, that was something that my recollection is, hey, we changed it to the extent we're going to change it, and that ultimately you weren't going to change it further or, eliminate that. So my client, as he, I think, testified to, would say, look, some parts I may not have liked, and guess what? When asked, I'll explain it. But ultimately, I don't want to not do a plea. I want to get the plea done so I can move forward. And that's that point of compromise.
Thank you for explaining that. All right. Your Honor, I would also at this time ask the court to conditionally admit 452, 460, and 453, not for publication at this time, but subject to additional restrictions as the court sees fit. And we can discuss outside the presence of the jury.
If we want to talk about them more, we can talk about them more.
Yes, Your Honor, thank you. While you were on cross-examination, you testified that
Okay, so right there, apparently whatever it is she's trying to conditionally admit, and I'm listening in and out. I'm so sleepy, trying to do too much. Whatever she's trying to conditionally admit, that means that she's trying to admit some evidence before the fact has been proven, okay? Before something has been established, okay? Think about it like laying foundation, all right? Okay, so, and that is also dependent that, the evidence will be relevant to that fact, okay? It would be the 3 R's, okay? So when you hear that, that's what that means, okay? So they'll do it, a lot of times it's done out of the ear of the jury and all that, and then if the fact needs to be established, that conditional evidence is relevant, then she would move to have it admitted on the record. Well, so it's going to be on the record now, but I'm talking about like on the record in front of the jury and all of that, okay? So that's when you hear that. And also, you hear her saying, and this is her case. That's what, throw that in.
some of the factual allegations that were contained in the final plea agreement were not ones that you had agreed to. But on direct, am I correct that you said number 3, you asked to be changed and it was changed, but not exactly like you wanted?
Mhm.
And then number 8 was one that you said today that you missed back at some point when you were reviewing the document.
That is correct.
Okay.
I have said today that number 8 was missed.
Okay.
And a review of it versus our earlier comments to you, they can't be reconciled. I mean, in other words, it's clear that that was not something that we would have anticipated. In other words, it was something we objected to and wanted removed. Ultimately, it reappeared in that final version. We did sign it again, and I'm not taking issue. We missed it. And unfortunately, had I seen it the day of, I would have paused, stopped everything and said, this is a hard stop. We got to figure this out.
We'll come back to that in just a moment, okay? Other than number 3 and number 8, do I remember correctly that everything else your client through you acknowledged was
Objection, Your Honor. Asked
accurate?
and answered.
Sustained.
When you spoke of some of the factual allegations, were number 3 and number 8 the only 2
Asked
you
and
were?
answered.
I'm
Sustained.
outside of what's contained in the final 1AS. Is there any other thing that you asked the state to change that we
Your
did
Honor,
not?
asked and answered.
I think that was also asked and answered.
I did. Okay,
Objection.
we'll move forward. Now, as I said, when you mentioned number
Oh my
8
God, he
being
gets on my
something
nerves.
that you had not seen before, are you able to tell the jury the first time that you can now recall paying attention to number 8?
number 8, when you were questioning my client and number 8 came to light, one of the first things I started to do was go back to read to figure out where that came from. And of course, my reasoning without going into the content was that was one of, from the very early things that we said, hey, this is not accurate. And then I'm thinking, where'd that come from? But I went back, I realized it was there. How we missed it, how I missed it, I don't know. But apparently I did.
If I show you number 8 on 455 Yankee, an email dated December 28th, 2022 at 1:54 p.m., are you able to recall whether this was a document that you reviewed while you were actually in court?
I believe that was one that I did review while in court. I think you said 155?
Yes, sir.
Yes,
455.
455.
Did I say one? Thank you.
I don't know.
455, yeah. Now, without reading out loud number 8,
Okay.
read to yourself number 8. And after you've done so, would you please tell the jury whether number 8 under factual acknowledgments under 455 Yankee is something that you asked the state to change?
If we,
With, just
okay.
because I can't have you read it.
No, I'm not going to read it.
Okay.
But what I was going to say is, having read it,
Mhm.
ultimately, the very final part, the last sentence,
Mhm.
really the and then everything after that is the only thing we would have asked to be removed from this paragraph. So essentially, you could say almost the last 2 sentences.
And so $455 number 8.
Yes.
I'm going to object under 403, misleading the jury. Mr. Wright has been referring to number 8 on the final agreement. Now we're talking now. Ms. Love is trying to talk about number 8 on a prior
Okay.
version, which is not the same.
I hear you. I think she was maybe about to ask some questions to clarify that.
I was, Your Honor, and just to be clear, because there was this cross-examination about what was agreed to, what the state refused to move.
Right.
So this, we believe, is a proper line of inquiry, and we'll try and keep it as concise as we can. So, may I continue?
You may.
So, Mr. Wright, when you speak of the change you requested on number 8 of 455 Yankee, does number 8 on 456 Yankee, is that the difference, and is that the line that you're referring to that appeared in the final version?
Well, they are 2 completely different statements.
Right. And does 456 Yankee contain the line that is now contained in the final version?
No, what I can see is that in 455 Yankee, where item 8 in that document was the one we had been talking about, and we took issue with the last couple sentences of it. When it becomes 456 Yankee, that is moved to being now number 9. The lines in question were in fact removed, but a new number 8 is inserted, and the new number 8 is what I said we missed. We didn't see that because it had not been part of the prior version. So, but you can sort of see by comparing the two that what happened was it got kicked down to 9, a new number 8 was put in, but number 9 does in fact remove the line at issue in the.
Is that in 456, that line in 456 Yankee, is that number 8, the line that appeared in the final version?
It did.
Okay.
And again, I'm not sure how we missed it. I think because I'm thinking, and again, I can't speak for my client, I can only speak for me, that we were still going off the last thing we had seen. Honestly, I know this final version got emailed to me. I'd be interested to know, just to be sure, what time the plea happened versus this email, because that would make sense as to if I didn't see this last version email before we ended up taking the plea. And again, I'm not saying it did happen. I'm just saying I'm trying in my mind to figure out how we missed that. How did that happen?
And as you were asked on cross-examination about your understanding and your client's understanding or initialing of each of these acknowledgements, was there any acknowledgement other than 3 or 8 that you ever felt you needed to explain,
I don't think this particular question's been asked before.
that you ever felt you needed to express to the state, my client may need to explain these further?
I know that I trust to the state that at some point my client.
Your Honor,
may-
I'm sorry. I'm going to object because I believe that answer calls for something that invades the province of the attorney-client conversation
when-
relationship.
Not when he expresses it to the state.
Overruled.
Go ahead.
But she indicated.
I believe, because at some point it was stated to the state that explanation may be necessary. I don't recall whether we itemized exactly which items were going. I think it was a general statement that, hey, we're signing it, we're agreeing to it, but some of this may require explanation. And at the proper time and place, i.e. if he's called to testify, he's going to want to be able to explain the answer.
Okay.
So I think that generally, without going into any detailed conversations with my client, but that's generally what I recall we were communicating with the state to say, we're signing, sign us up, we're initialing, we're going forward. But some of these things, because there are a couple things in here, may require further explanation. And when asked, they'll have a chance to explain.
Were any of those things inclusive of any other acknowledgement or understanding besides the 2 that you already pointed out? And if you need,
Could
here
I
it is.
have the final initialed?
I think you.
Because I think your question is going to that. I just want to.
Do you have 1 AS in front of you?
455.
1 AS.
No, this is 455Y. I think at some point. Okay. reviewing this, 3 and 8 would be the only ones that I believe he would have, oh, I'll strike that. 3 and 8 were the ones that there seemed to be issues that may require explanation.
Okay.
Just 3 and 8.
Did you were asked on cross-examination whether at any point the state asked to sit down with your client. Did you perceive the November 20th, the November 2022, the November 30th, 2022 email from the state as a request to sit down with you and your client?
Well, it was a proffer offer. So yes, that would essentially be your communication to see about having a sit down with my client. And I think I indicated I received it, but we did not respond until middle of December.
Okay. And that response, did it include any agreement to sit down with the state?
No, it actually was simply saying, why don't we talk about a resolution?
Okay. And as it relates to the questions on cross-examination about the November 27th email and the November 28th emails and where you were when you were able to review them with your client.
You mean December 27th?
Did I say November? Yes, I did
Okay.
mean, thank you. The December 27th and 28th correspondence. At that time, were you and your client aware that you all were not the only people who had yet to resolve your case?
Correct.
Well, the question, having known me personally for as long as you've testified, you have, did you feel that comfortable enough?
Hang on. Relevance as to what he felt? What are you, finish your question so I can.
Because the question,
What was the other one? I'm sorry. Do you
I don't have any.
maybe rephrase?
All right, I'll rephrase. Did you were asked on cross-examination about receiving communication and plea offers, plea agreements on December 27th and 28th and meeting with your client at the jail and in court. Do you
Okay.
recall those questions?
Yes.
At the time that that was going on, did you believe or did your client indicate to you to express to the state that you needed maybe any additional time to go over those agreements?
No, at that time, we were very eager to ink a deal and resolve the case. And ultimately, that's how the 27th happened in the evening, as well as once we show up to the courthouse, how on the 28th, we were trying to iron out an agreement, which we ultimately tendered to the court.
Were you or your client through you ever given the impression or led to believe that if you did not ink a deal on December 28th, it would go away?
No, I don't think there was ever a sense that we were given a deadline. It was, hey, now or never. I think it was just a matter of he's expressed. He had different concerns and different motivations. So again, not speaking for him, but he seemed very eager to ink a deal if a deal could be had on the 28th.
And you were also asked about your desire or willingness to go to trial. If your client chose to go to trial rather than ink a deal, regardless of the financial arrangements that you had made, would you have continued to represent him?
I hate to say I could not have afforded to stay on the case and to go to trial because a trial of this length would have bankrupted me.
Okay.
I mean, there's starve me. I don't know what's the word, but ain't no money being made when you're in a courtroom. And if you're not getting paid for being in the courtroom, there just ain't no money.
Understood. Without getting into what you told your client, would you have made efforts to arrange for him to have suitable or to, okay, I'll withdraw.
All right.
Did you ever move to withdraw in this case?
No. Again, that's something that would have come later, depending on the choices my client made.
Okay.
And because his choice was to get this plea done and to execute it, that never became a ripe kind of consideration.
You were asked on cross-examination a number of times about your client's sentence. I want to show you what I've marked as states 463, and a copy of which has been, not as it's labeled, but the certified has been provided in discovery. If there's anyone that wants to see it, I'm just giving the copy to the witness.
Okay.
463 Yankee. You were asked on cross-examination whether count 30 was held open until the end of this initial trial. Do you remember that?
Something to that effect, yes.
And do you have any memory of it being necessary for your client to be sentenced on count 30 as a result of the way that that particular count had to be filed with the clerk of court?
Actually, we put creative language in there where if he sees his cooperation through, we could actually be in a position to withdraw his plea on that count, and then it would be null pros. So one of the benefits is count 30 will go away, and then he'll just be on probation for the primary count. So that was, I guess, one of the incentives in this agreement was, I guess you now have both ends. The incentive that that count could go away, or the deterrence that, hey, there's a hefty sentence if you go afoul.
And does 463 accurately reflect your client's final sentence that he was given that day, in addition to or under the restrictions of 1AS, the plea agreement?
It does.
Okay. And so would you please tell the jury what your client was actually sentenced to on that day?
Yeah, I'm going to object. That's actually been asked and answered previously.
Well, I haven't seen the document to see what it says, but it seems to me, at least the implication is, no, it hasn't. So I don't know. Do I need to see the document?
I can show it to the court. Now, passing to the court, 463 Yankee, I ask the court to pay attention to the sound. I'm going to walk around. You're welcome.
Okay. Got it. Overruled.
would you please tell the jury what your client's ultimate sentence was?
Ultimately, the sentence that I'm looking at now indicates 15 years to serve on probation to count one, and then 15 years to serve on probation to count 30, consecutive to count one,
Okay.
which would be 30 years of probation. And once this, going to the third page, which is the
Yes.
continuation,
Please, sir.
that if the special conditions outlined in this sentence are satisfied, and there's I won't list them, but there's a few of them, but ultimately, he would be allowed to withdraw his plea as to count 30, and count 30 would be non pros. That's a Latin way of saying dismiss. So that he would only be standing on his sentence for count one.
Okay.
And I know someone had, since I'm here, had asked me about whether there was a curfew, and I do see where there's a curfew as part of this sentence.
Thank you. Wrapping up with the last three questions, you said that you were asked on cross-examination, you testified about whether or not your client initially was charged with the murder of Donovan Thomas and whether the police dismissed those charges. Do you remember that?
I remember
The question.
the topic, coming up,
Okay.
question coming up, yes.
And do you know whether it was the police or the district attorney's office that declined to charge your client?
Yeah, I can't say I've known police to ever have that authority or make those decisions. It was my understanding it was the Fulton County DA's office who made the decision not to pursue those charges any further.
Okay. And the last question is, you spoke earlier about representing your client in his 2015 case.
Okay.
And entering that plea in his best interest under Alford. Do you recall that?
Yes.
And at the time that you represented your client on 22 SC 183,
Yeah, we can't really hear you. Sorry.
I'm sorry. I'm going to object, and we can approach if.
All right.
I mean, they probably done broke the record for amount of sidebars. See, that good old white lady, she came in there and no, I think it's like she's gonna knock it out and be super judge. Shit, I bet she is humble. And like, oh my gosh, what have I gotten into? This is truly nigga shit. How tall is my piece of husband? Let me stop saying.
All right, so Ms. Love, my recollection is that the issue of the 20 whatever 17 plea having been an Alford plea came up during your direct of, I don't feel like it was this witness. I feel like it was Mr. Sledge.
Because it was initially what happened is that
My memory that it did come up with this witness.
Also?
Yes, it was
Okay.
asked.
Okay. It originally came up with Mr. Sledge on your direct because you started reading the factual basis.
that's what I was about to say.
Okay.
So what I was about to say was initially it came up with Mr. Sledge
Yeah.
because of
Okay, we all remember why, but then how did it come up with this witness?
on cross-examination, the question was asked, if, I think something along the lines of, it may have been by Mr. Adams, what is an Alford plea? Do you do that because you feel it's in the best interest
Right.
of your client? And does that consist of certain things?
Okay.
And so because Mr. Adams got into the questioning of what, what's an Alford plea? What does it consist of? Why do you do it? And then there was, I believe, according to my notes, there was questions or there was testimony about Mr. Sledge's mother being ill
Right.
and him expressing stress over that.
Right.
My notes then.
Okay. I mean, I remember now. Thank you for recalling it to my recollection. So what is it that you want to ask?
At any time did he request that this plea be made simply in his client's best interest?
Okay.
Did his client ever request of the state to enter this plea in his best interest?
Okay.
And given that, of course, since now everybody knows that his client knows what an Alford plea is, it's important that this plea and these statements weren't given or made simply because they were in his best interest.
Okay.
Understanding his testimony today, that wasn't something that was ever conveyed.
Okay. Well, those two questions, did he at any time request it and did his client request it? Seem like they would be appropriate. I don't know if you intended on some kind of third question or if that was just your argument, but did you intend a third question after those two?
No, my
Okay.
last question was intended to be, was this plea made under Alford? Or was this plea, did your client ask us to allow him to make this plea under Alford? So
Okay,
there's two
so we
questions
know it
there.
wasn't under Alford.
Right.
So did he at any
Well-
time request that the plea be a best interest / Alford plea, and did his client ever ask?
We know, the jury doesn't know. That's why I was saying that. And I believe that it's,
Well, yeah, they do, because I instructed them already that for the one, they could not consider anything, and for this one, they could if they found inconsistent statements.
Okay.
So, yes, sir, Mr. Short. So as to those two questions,
I am not going to pretend that I was in the middle of their plea
hold
negotiations.
that closer.
I am not going to pretend I was in the middle of their plea negotiations, but I feel that many of us know that the only individual that was allowed to plead guilty under Alford is Mr. Sergio Kitchens, who had zero evidence against him, quite frankly. And so I don't think anyone would have perceived that as an
He brought
option
the-
to even ask.
Okay, well, that's not an evidentiary objection.
Well, I would object to
No.
those questions being asked because I believe any discussions that he would have had with his client about Alford invades the province of the attorney-client relationship. Can he be asked whether or not the plea was entered under Alford? Sure, that's how the plea was entered. But whether or not he had any discussions or whether his client asked him to approach the DA's office in regards to an Alford plea, I believe invades the province of
All right,
attorney-client
if you were to make that objection, that would be sustained, but that objection would not be valid with regard to whether at any time Mr. Wright requested that the plea be permitted as a best interest. So you can ask that question.
Thank you. And Your Honor, as Mr. Wright has already testified that if his client asks for something from the state, he's obligated to convey it to the state. I don't believe that asking him whether.
All right, well, that's already before the jury, so.
Okay, thank you.
Okay, let's get Mr. Wright back in, and hopefully the jury will be ready to come on back in too. Yeah, I wonder, I don't know whether he heard that or not. Can somebody see whether the jury's ready? No, I know that, the jury. Mr. Wright's on his way. Yeah, is the jury ready? Great, they seem to be. Thank you. Go ahead, Ms. Love.
Thank you, Judge. Just two more questions. You were, on cross-examination, did you testify that you were not certain that your client would have to testify
It was
on December 28, 2022?
correct. That the point was, if you need him and you want him to testify, he will. But it wasn't set in stone. It was going to be a game time decision once you made the decision.
And was your client served with a subpoena?
Okay, I need to know what this dude, because this other dude is proving to be more trouble than Woody, kind of. And he is taking these people down so many damn avenues. Now, I don't know how many charges he's had, how many plea agreements with regards to those charges. And I don't know, if his plea agreement included in writing that he has to testify. Okay. And so I don't know if he, just agreed to show up just, based on a subpoena, or is that part of a plea agreement? Jesus Christ, oh my God, this is a lot, man. I need to pull up the indictment. I'm gonna have, oh gosh, you got other people that's not even in the indictment that, oh my gosh. I'm trying to do what I can do to get the right information.
and by the state on December 28, 2022 to testify in the trial of this case?
I don't know if he was served a subpoena that day. I mean, we were served a subpoena recently, and we've never taken issue with service or the fact that he will appear whenever the state wants him to appear. So we've never made issue of service.
And finally,
That's crazy. He started talking about subpoenas after I started talking about he testifying because, you know, he got a subpoena to testify. Oh, that man.
you were asked on cross-examination
Yeah.
about an Alford plea,
We's family now, sir.
and it revolving around somebody saying they're not guilty. Was this one of those pleas?
This plea, no.
Thank you. That's all that I had.
All right, thank you. Is there any recross from any of the defense attorneys?
Mr. Stillwell.
No recross on behalf of Mr. Williams.
All right, thank you very much. Mr. Wright, thank you for your time.
Thank you, Judge.
And remember, your client is excused but not released, so if he comes back, we'll see you again, but otherwise.
Understood. Thank you, Judge.
All right, call your next witness.
Yes, Your Honor. The state calls Mr. Thomas Burnett to the stand.
Thank you.
Oh my God, you see what I said? I said they won't let the white guy examine probably some white guy or some other witness that is, you know, not as controversial. Baby, if I tell you a duck will pull a truck, shove that motherfucker out.
Thomas Burnett. Oh, ThomasBurnette.
Good afternoon, Mr. Burnett. How are you doing?
Hey, how are you?
Mr. Burnett, did you drive or fly here today?
Fly.
You're from another state?
Charlotte.
And what do you currently do for a living?
I'm a service consultant at an Infiniti dealership in Charlotte.
And what was the first year that you began working for Infiniti?
1997.
What did you do when you first began working for Infiniti in 1997?
I was a valet. I was a valet while I was going through college.
And in that capacity, would you drive Infiniti cars?
Yes.
After that, where did you end up? Did you ever end up getting a degree?
Yes.
Where did you get your degree?
DeVry University.
And what was your degree in?
Business administration.
Did you get that here in the state of Georgia?
Yes.
Now, after when you first were working as a valet, what was the next job that you had after getting your degree?
With Infiniti or just the next job period?
Next job period.
I was in furniture sales.
What did you do after that?
I went back to Infiniti.
What drew you back to Infiniti? How did you end up back working for them?
Just a familiarity. I had a relationship with the manager at a store, and it kind of asked me to. There's opportunity, so I went back.
Now, when you went to Infiniti this time, what was your job position?
Currently, what?
Okay, remember I said, you know, we always should be observing and asking questions, whatever. I don't care whatever hat you wear. And it can be either one of your personal hats or your professional hats, right? You know, I'm right now being lazy, so I'm gonna lean all the way in my professional hat, trying to figure out what is this witness here to establish, right? And we do know there was an Infiniti involved, so maybe he's going to be an expert with regards to, I don't know about with that Infiniti, what is he going to establish about it? I don't know. coordinates located. I don't know, but I'm just saying we need to be not only watching, we need to be thinking and asking questions.
But service consultant.
Now, can you explain for the jury what is a service consultant? What all do you do?
I meet with the clients or customers that come in for maintenance or repairs on their vehicle. I assess what the vehicle needs, whether it's check engine light on or a leak or no starting issue. I basically get the information from the client and put that in a manner so where the technicians can properly diagnose the vehicle. Once it's diagnosed, I reach out to the client and let them know what repairs are needed and gain the authorization to fix the car, and then basically handle the client throughout the process on updating them, let them know when the car is ready, payment, etc.
Now, as a service consultant, with what all you just described in terms of your job, what all you do in that job, do you have to have familiarity with the makes and models of Infiniti?
Yes.
Can you explain for the jury how you gain familiarity with Infiniti makes and models as a service consultant?
Well, we have to do certification tests quarterly to make sure we're certified. And then, also just being around the vehicles, you learn and pick up certain common things about the cars. And you have to identify certain things with them to know what year it is, what kind of type of oil it takes. When you're quoting prices, you quote them accurately. So.
Now, as a service consultant, is your primary focus, is it true or false that you're focused on the clients that come in?
Mainly, yes. Yeah.
Now, to be an effective service consultant, with Infiniti, do you have to understand the technician side of the business?
Yes, because I have to basically interpret as far as what the client's saying, as far as sometimes help the technician understand what the issue is. And then there's a lot of terms and expressions that technicians will explain to what's wrong with the car. And sometimes that's not customer friendly as far as understand what actually the issue. So sometimes I have to do some interpretation as far as making it a little easier to understand on what actually is going on with the vehicle.
Now, Mr. Burnett, jumping back to after you got your degree and you worked when you first went back to Infiniti, what location were you working out of?
South Atlanta, Infiniti of South Atlanta.
Is that one on 4201 Jonesboro Road?
Correct.
Now, what year was it that you?
2005.
And how long did you work at that location?
Till 2020, 2021, I'm sorry.
So roughly about 15 years?
Yes.
Now, over those 15 years, how often would you drive Infiniti cars in any capacity?
Every day.
Would you drive them in both daylight and nighttime?
Yes, I currently own Infiniti, and I've also owned Infinitis from like 2007 on. So.
Do you get some perks working for Infiniti in terms of owning an Infiniti or buying one?
Yeah, we do get some discounts or consideration as far as with it.
Now, what kind of vehicle do you currently drive?
Q50, Infiniti Q50, a 2020 Infiniti Q50.
Now, since you've been working for Infiniti, when did the Infiniti Q50 first come on the market?
2014.
Now, when it first came on the market, how would you describe an Infiniti Q50?
It's a sports sedan built on performance. It was pretty unique in design as far as at the time, as far as it had distinct features as far as the headlights, tail lights, the front grille were pretty distinctive at the time when it first came out.
Now, is there any Infiniti model or make that is similar back in 2014 when the Q50s first came on the market?
No, there was a G37 sedan, but it looked completely different than the Q50. It wasn't really. It was a whole different design. So
now, is there any significance to the G37 in terms of the name of that car versus the Q50?
No.
In terms of the lettering or numbering?
Oh, well, like far as the G37 was basically named after the engine size. So the 37 is how Infiniti used to distinguish what size engine was in the car. When the Q50 came out, it was the beginning of the rebadging to where all the same models basically had the same. So a Q50 is the sedan, the four-door sedan. A Q60 would be the two-door car, and then they identify the engine size by the decal that's on the side of the car, whether it's a 2.0 engine or 3.0 or 3.7 back when it first came out in 14.
Now, you have described a decal on the side of the Infiniti Q50. Is that unique to that make and model?
Pretty unique. You don't see it a lot on other makes. Most makes don't identify what engine size is in the car by any type of badging on the side.
So previously, Infiniti, you would know the engine size based on
the
name,
Yeah.
and then after that, they put a visual indication of the engine size?
Correct. Yeah, they were kind of tired of changing names every time a new engine came out. So it went from like G35 to G37, and then it stopped, and then they just changed the badging on all the cars to Q.
That makes sense. Now, are all the makes and models in the Infiniti fleet start with Q?
Correct. Yeah, the cars are Q, and then the SUVs are QX.
Now, you were working for Infiniti in 2014 when the Q50 first came out.
Yes.
Has the Infiniti Q50, does it have a sunroof?
Yes, pretty much probably 80% of the models, or maybe even higher, have a sunroof. The only ones that don't have a sunroof are the Q50As, and that's on the back of the car. You'll see the A, and that was kind of like the base entry level car, which we didn't sell very many of those cars because dealerships wouldn't order them because they knew they wouldn't sell them. So
now, when you said when you went back in 2005, you worked till 2020. What did you do after leaving the South Atlanta Infiniti in 2020?
I moved to a few dealerships around. Initially, I took a job as a service manager at a Nissan store in LaGrange, Georgia. That didn't quite work out, so I worked at the Nissan in Morrow. Then I went back to Infiniti, different location. I was at the Cobb County location, Nally. And then I worked for Lexus for a short period of time before the Infiniti South Atlanta store asked me to come back. And that was in last year.
So you kind of went full circle back to that South Atlanta Infiniti?
Yes.
How did that come about?
I was up there getting the oil change on my car, and the manager that was kind of like a consultant there at the time, he was just working part-time, he was retired. Him and the current manager asked if I was interested in coming back. I had still a lot of clients that would come through the store asking for me and stuff. So they asked if I had any interest in coming back, and it lined up with what I needed at the time, so I went back.
Now, what do you like about working for Infiniti over these years?
I like taking care of customers. Also like the product.
Sustain, hang on just a second. If you hear somebody say objection, will you just pause for a minute while I deal with that? Sustain.
Now, yes, Your Honor. Mr. Burnett, I'm going to show you what's been marked as State's Exhibit 459 Yankee and 459 Yankee Alpha. And again, defense counsel, it's
Yeah, I mean, I searched it because of exhibits from the same.
Sure.
Your Honor, hand in the witness both 459 Yankee and 459 Yankee Alpha. Mr. Burnett, what are 459 Yankee and 459 Yankee Alpha?
Both pictures of a Infiniti Q50.
How are you able to recognize them?
The shape of the vehicle, the headlights are pretty distinctive. The front grille and the tail lights are also pretty distinctive. And it also says Q50 on the back of the picture.
Okay. So this witness must be is being considered as an expert, right? So he probably doesn't have the traditional curriculum vitae CV, right? Which is what you use. I give a prime example. Remember, I was reading the R. Kelly citizen submissions. That was along with his reports and all of that. And you saw a bunch of extensive resumes of those doctors that testified. Okay, well, this brother don't have all that, right? So I think the state did a pretty good job at asking questions to establish why he would be the expert in this particular situation, right? Okay, so apparently he's going to, I guess, talk about the car. I don't know, talk about the damage. You know what that damage, the damage that was caused. What could it possibly come from? I don't know. You know what I'm saying? Or maybe got to try to identify the car. Maybe the car is hard to identify. I don't know. Well, you know why he's up here, but he's up here as an expert. Okay, so that's his role today. You know, maybe he's a material witness, right? Maybe he's going to establish something. We don't know.
And for your testimony to the jury, would using 459 Yankee and 459 Yankee Alpha aid you in describing a Q50 for the jury? Aid your testimony?
Do you mean that he's helped with this?
Yes.
Yes.
Your Honor, at this time, the state is tendering 459 Yankee and 459 Yankee Alpha for demonstrative purposes.
All right, those are admitted as demonstratives.
Publishing State's Exhibit 459 Yankee. Now, Mr. Burnett, earlier when you were describing a Q50, what is the most significant physical aspects of this make and model?
You mean like what makes it stand out the most?
Correct.
I'd probably say the headlights on the front grille.
Now, currently, so you've also had an Infiniti Q50, you said, since 2020?
Correct.
How has, since it came on the market in 2014 to present day, has the shape or the vehicle itself changed much?
Not much at all.
Overruled.
Now, Mr. Burnett, does your Infiniti Q50 2020 how does the front emblem look? Is it any different in terms of lighting?
There's some options on the newer versions of it, like 16 and up, where it lights up at night when the headlights are on.
Was that a feature when it first came on the market in 2014?
No.
Do you know when that lighting first came into Infiniti fleet?
In 2016, when they changed the engine sizes in the car. It went from a 3.7 to either a 2.0 or a 3.0.
Now, is in 459 Yankee, are the rims on the tires, is that standard, not standard? How would you describe those?
Those are standard wheels on it. There's two options. There's the 19s and the 18s. And some have, it's three. So 17s, 18s, and 19s. Looking at it, those appear to be the 18-inch wheels that are on.
Now, Mr. Burnett, earlier you had said, you mentioned about when Infiniti got away from naming the cars off the engine size, that they had a decal. Is that correct?
Correct.
Can you show the jury, if you see it, is that decal visible in 459 Yankee?
Yes. If you go just slightly back from the front wheel, you can see a silver kind of spot or kind of there. That's actually the decal that's on it.
Mr. Burnett, I'm gonna move this mouse. You tell me if I'm getting closer.
Keep going.
Okay. Same direction?
Yeah. You're right there at it now.
That is the decal that indicates the engine size?
That's correct.
Now, turning to 459 Yankee Alpha, can you describe for the jury what stands out to you in terms of it is different about the Infiniti Q50 compared to other Infiniti makes and models?
Just the shape of the tail lights are a little different than some of the other models are. They kind of mirror the headlights where they're kind of a little more kind of sunken into the body of the car.
And what do you all have certain naming conventions for the colors that the cars may come in?
Yes. This particular color is diamond graphite.
Now, when did you leave what was your last job in the state of Georgia before you left?
I was service consultant at South Atlanta, the Jonesboro location.
And when you moved to North Carolina, did you work with an Infiniti company
Yes,
there?
same role, yes. Just in Charlotte, yes.
Now, back in March of 2016, what location were you working in for Infiniti?
Union City, the 4201 Jonesboro Road, Infiniti of South Atlanta.
Now, do you recall a time where any law enforcement personnel ever came by that location when you were working to interact with you?
Vaguely. There was, and I don't remember the exact date or time, but there were some officers that came in. They were directed towards me. At the time, I was like the assistant manager or lane managers, sometimes they'll call it. And I think one of my other employees pointed in my direction. They had some photos or like a poster board of a car, and they just kind of asked some questions about what type of car it was. And there may have been a few other questions. I don't recall what they were. And then they were like, hey, it's part of an investigation. We'll probably be in contact at some point.
Now, Mr. Burnett, do you have any independent memory of what kind of car the vehicle was that they showed you in those photographs?
Not in 2016. No.
Okay. Now, I want to publish, Your Honor, what's already been admitted as 296 Yankee. And the state's going to start the publishing at 8 minutes and 30 seconds.
All right.
Mr. Burnett, while that's getting set up,
Oh, yeah, sorry.
in
Didn't know you-
preparation for your testimony, have you?
Hang on just a
Sorry,
second.
Your Honor.
I don't see anybody waiting.
Have you more recently than 2016 reviewed some surveillance video and photographs for your trial testimony?
Yes.
Your Honor, publishing State's Exhibit 296 Yankee at 8 minutes and 29 seconds. Ms. Burnett, if you can, just watch this screen.
Okay.
Pausing. Now, Mr. Burnett, was, I know that clip was quick. I'm going to publish 292 Yankee Hotel, which is already admitted. Now, is that surveillance video clip that you just watched, have you reviewed that before testifying in court here today?
Yes.
And what vehicle was depicted in 292 Yankee between 8 minutes and 30 seconds and 8 minutes and 40 seconds?
It was Infinity Q50.
Now, I'm going to briefly on the screen, what's going to be published is 292 Yankee Hotel. Let me know when you can see that. Is this a still frame from the surveillance video that we just watched a moment ago?
It's no. Yes, it looks the same.
Now, can you describe for the jury what stood out to you about being able to identify this as an Infinity Q50?
The headlights, the way they appear, you also can see the black grille, and it's kind of hard on this one, but as it gets closer, you can see like a little bit of the logo, like the silver reflecting in the front grille area.
And when you mean when it gets closer, you mean when
As it starts to come, I guess, closer to where it, before it goes off the screen.
Publishing, Your Honor, what's already been admitted as 292 Yankee Indigo. Now, Mr. Burnett, is this also a, I know it's currently blocked, but still framed from the surveillance video that we just watched?
Yeah, that still seems to be the same car, the Q50.
Now, what I'm going to do, Mr. Burnett, is I'm going to replay 292 Yankee at 8:30. You tell me when to stop when you had mentioned the silver emblem, right, as the car gets closer, in your words. So I'm going to play 292 Yankee starting at 8 minutes and 30 seconds, and you just tell me when to stop when you think it would be helpful to see that.
Sorry, it's real quick.
It's all right. I'm going to publish 292 Yankee Juliet. What's already been admitted as 292 Yankee Juliet.
You can almost see the reflection of it right in that screen there.
And when you had described, and by the reflection of it, do you mean, what do you mean by that?
It's almost like where I guess the lights or the street lights or whatever are reflecting off of it.
And
you can kind of, like, if you look in between the headlights, you can see there's something there. It's not black like the rest of the grill is.
And you mean the front part of that Infinity Q50?
Yeah, the logo that's in the front of
it. And when you had mentioned this is this almost basically, when you said as the vehicle gets closer, as it's driving off screen, when you reviewed this surveillance video, is at what point from where the car currently is to when it's off screen did you notice that?
Originally, right, well, when you originally played it the very first time we spoke about it, I noticed it pretty quickly. To honestly, the very first time I looked at it, I was just looking at the car. I didn't even see what was going on in the side. And then the second time you read me back, I saw all the other stuff that was going on with it. So I mean, as you recall, when I first saw it, I was like, "Well, that's a Q50," and you were like, "How do you know that's a Q50?" And we kind of went through the same. I was like, headlights to the grill and same thing, and then also the tail lights you can kind of see as it's taking off.
Now, thank you, Mr. Burnett. Now, since March of 2016, when law enforcement came and spoke to you, to present day today, do you have any other knowledge or information or any information about this case that the surveillance video is involved with?
No.
Mr. Burnett, I'm also going to publish 292 Yankee starting at 10 minutes and 40 seconds through 10 minutes and 47 seconds. It's gonna, it's close. Mr. Burnett, that surveillance video that we saw, have you seen that angle before?
Today I saw it.
Okay. In preparation for your testifying. And in that, what car do you see in 296 Yankee between 10 minutes and 40 seconds until when we paused it at 10 minutes and 48 seconds?
It's the same car from before, it's just a different angle. It looks like we're seeing more of the back end of it.
Earlier, you had mentioned the quarterly training that you've gotten since working in Infiniti. Can you describe what that entails for the jury?
So anytime there's any new models or any new features or anything that's been added to the cars, they will have to go through certification tests on them. It could be modules, so where we have to do like interactive videos and answer questions at the end, or it could just be an article that we have to review and then go back and answer questions. It just depends. Usually on a brand new model, it's more interactive stuff because they want make sure that you're following along and know what's going on. You'll just skip straight to the test. But sometimes on some of the refresher stuff, like if it's just a specification change, like the engine size or new wheel package or something, it'll just be like some articles that we just read and then answer the questions based off of that.
One brief moment, Your Honor. Mr. Burnett, when the Infiniti Q50 came out on the market, when was the first time that you drove it? Did you ever drive a 2014 Infiniti Q50?
Yes, it was besides customers coming in, we also had them as loaner cars. So that was one of our main cars we used as loaner vehicles. So we were constantly pulling them up, getting customers in and out of their stuff. Yes, I've driven them a lot of times.
And what aspect of the Infiniti Q50 made you choose to buy it in 2020?
The size, the performance of it. It's a pretty fast vehicle. It has a lot of power. And from my standpoint, it's also pretty reliable because, again, I see what goes wrong and with them. So that's what kind of drew me to it.
Now, the dealerships or the locations you've worked at for Infiniti, have those all been classified as dealerships?
Yes.
And is your customer either primarily or exclusively people buying a car for themselves? Or brief indulgence, Your Honor.
All right.
In terms of, do you have any familiarity with Infiniti vehicles being sold to rental car companies?
So they would buy directly from, so they buy Hertz Enterprise, they buy directly from the manufacturer. Now we do see them when they come in for recalls and that sort of stuff. So they do bring or if there's warranty repairs that need to be done on them, Hertz Enterprise, they do bring cars to us for us to service. So, but like far as purchasing wise, they buy them directly from the manufacturer.
And Mr. Burnett, what is your favorite physical attribute of the 2014 Q50?
I'm going to object that's too irrelevant.
Sustained.
I would too, Your Honor. That's why I asked. With that said, Your Honor, the state does not have any more questions for Mr. Burnett. Thank you, sir.
All right, thank you. Are there any defense questions for this witness?
Yes, sure. Yes.
Thank you.
Good afternoon, sir.
Hey, how are you?
I'm good. Fabulous. Fantastic. One of the last things you said was that the rental companies, I think Hertz, you mentioned, sometimes brought their cars in to be serviced at the locations you worked at, correct?
Correct, because we're close by the airport, so we would get a lot of their cars brought in. So.
Do you have any personal interaction with any car, any Q50 that would have been brought into your dealership back in January or February of 2015?
I wouldn't be able to recollect that.
And you would not have been the one to observe or look at or inspect any vehicles brought in from Hertz anyway, would you?
Only thing I would do was check it in, which basically would mean getting the mileage, then plate off of it, and doing like a walk around on it for damage. That would be my end as far as inspecting it.
Okay. But in 2015, was it 2015 or 16 when the Atlanta police came to talk to you about Infinitis?
I don't actually remember the exact date.
You have no real memory, no clear memory of when that was, right?
No, not the date, no.
Okay. Is it fair to say that when they came to see you, though, they didn't bring an actual vehicle with them for you to look at or offer your opinion on, right?
No, they were like photos.
They were photos.
Yeah.
The images that you just saw, I'm going to ask the state's indulgence in a bit to put some of those back up again. You would agree with me, though, that those photos.
We're good.
Those are black and white images, right?
What's that? The photos they brought in, or?
Yeah, well, no, the photos that you were just looking at, the video you just looked at, still shot, and then the two videos, one of the car rolling forward from the front, the other one from the back.
Well, the photos here are color. The ones that they.
Now step up.
You may.
All right. Right. So these, and I'm going to reference for purpose of the record, 459 and 459A. These are the photographs that were presented to you from the state a little while ago, right?
Correct.
Right. Now, that's not what I'm talking about, though. I'm talking about the video that you were looking at, that the state played. Would you agree that was a black and white video?
I don't know if I would classify it as black and white. It wasn't the greatest of quality of video, but I would say it was black and white.
Snyder, would you be kind enough, please, to put up what the stage is marked as 292 YI, Yankee Indigo, I guess. All right. Can you see what's on the screen in front of you, Mr. Burnett?
Yes.
All right. Now, you read 292 YI, that's the image that you looked at before, correct?
Yes.
You're not able to tell what the color of that vehicle is, are you?
I can tell it's a grayish color. I mean, just like the color, the car that's behind the white one appears to be like a reddish color.
Okay. So let's see. Are you going to tell me that that vehicle that you said is in Infinity is a, what did you say it was a diamond graphite color vehicle?
Could I say it from the picture? No, I mean, from this, no, I couldn't say it was diamond graphite, but I could say it's grayish in shade though.
Okay. You said that you recognize this as an Infinity because of your familiarity with Infinities, correct?
Correct.
Now, to be clear, you're not a scientific expert, right?
No.
You've never been qualified as an expert in Infinities or identification of vehicles, true?
No scientist, no.
Okay. You've never been qualified in a court of law as an expert in identification of vehicles.
Never been to court before or anything for it, but as far as an expert in knowing Infinities, I probably would say, yes, I know all the models.
Okay. Tell me whether or not that vehicle that you're looking at, the one that you've identified as an Infiniti Q50, has standard size wheels or non-standard wheels on it as you described earlier.
We're talking about the screen, not the pictures, right?
So on screen.
I couldn't, you can barely see the wheels from this.
All right. Looking at that image that the state showed you that's on the screen right now, tell me where you see on that there is an Infinity emblem or insignia on the front grille.
This one doesn't capture it. They tried to roll it forward to where you could see that there is something silver in it, but technically they couldn't stop it at the right time.
You said technically, but you don't see it at all, do you?
Not in this frame, no.
And in fact, when you were describing the image you said earlier, or you saw earlier, you said that you can almost see it. Understand that?
Correct.
All right. Looking at this vehicle on the screen, are you able to tell whether or not there's any damage to the front bumper or fender of that vehicle? Is those been some sort of accident of some sort?
Not on the screen, no.
Are you able to see anyone, if there's anyone hanging out of the sunroof?
Not from this angle, no.
I'm curious. Do you know whether or not the 2014 Infiniti Q50s have? I'm going to use OnStar. I don't know if there's another name for tracking.
It's Infinity Connect, yes.
That's a tracking system.
Correct.
Do you know whether all of the Infiniti Q50s had tracking software in it that would allow you to track the car and tell you where the car is at a given time?
They have the capability, but there's a subscription that has to be paid for it to be able to do it. So if the subscription isn't paid, then it's not active for us where you could track it at the time.
Okay. You testified earlier, and I'm still referencing the images up on the screen, right? You testified earlier about there being an emblem on the side of the Infiniti Q50 that's a little bit behind the front wheel, right? You remember that testimony?
Yeah, but that was off of the picture though.
All right, so put the picture aside for right now and just looking at the image that was shown to you by the state. And this is the same image that was shown to you back in 2015, right?
No, they just had pictures. They had like pictures that came back in then. There was no videos or anything then.
Okay. So APD came to see you in 2015, they didn't show you this video?
No.
Okay. So look at the video that you see right now, that you've identified. Looking at that car, point out to me where that emblem on the side of the vehicle that tells us this is Infiniti.
You can't see it from this angle. Not on the video.
comes to you and they show you some still shots of a vehicle.
Correct.
And they ask you to tell them whether or not it's an Infiniti or not.
They asked basically to identify what kind of vehicle it was.
And just so I'm clear, were the still shots that they showed you still shots from this video?
I honestly don't know where the pictures, I mean, that was 15, 16 when they came. I honestly don't know where they got the pictures from.
And they never told you, right?
No, they basically said that they, there may be some further questions they may ask and they'd be in contact, and that was that.
Was that the only time that they came to ask you anything about any Infinitis?
Yes, I didn't hear anything about it again until was it April or May. I think they reached out. I guess they still have my number on file from when initially I did the interview, and they called and asked if I remembered it. And I honestly didn't remember a whole lot of it at the time. As we talked further into it, some of it started to come back, but I didn't remember what kind of car was involved or any of that until I actually saw the video that they played for me.
When you say they called you, you talking about the DA's office? Or?
Yes, yes.
You didn't talk to anyone from the DA's office back in 2015?
No, I would assume it was just a local police. They were in uniform, so.
Police officer?
Yes.
First time that you've seen that video, and when I say that video, I'm going to refer to 292YJ. I think that's the one that you said you saw from. It's the back view of the vehicle.
Yes, the store or whatever. It looked like a store or something from what I could see.
Ms. Knight, would you be kind enough, please, to put up 292YJ for me? Actually, no, it's not. I'm sorry. Let me correct that. That's 296Y at timestamp 840, 847. Let me confirm that for the record. That's exhibit 292 Yankee Delta. Did you see the image that went across the screen there, Mr. Burnett?
Yes.
And it's kind of you want that one more time, please. Wait fast. Let me ask you a question.
Sure.
Would I be correct if I were to say that back in 2015, no one ever took you to an actual first location to look at any Infiniti?
No.
Almost gave image Mr. Burnett.
Okay.
See that car driving past?
Yep.
That is the car that you took a look at today. Today was the first day you saw this video, right?
This one, yes.
Okay. And then your testimony is that based on that vehicle passing by in the video, between 840 and 847, you can recognize that as an Infiniti Q50, as an Infiniti Q50. Is that right?
Correct, yes.
And then it was written below that even that image, as it went by, you didn't see any Infiniti emblem on the side of it.
No,
You didn't see an Infiniti emblem on the back of it, right?
no,
You didn't see anything that looked like damage to either the front or the fender or of the vehicle, right?
no,
You didn't see anybody hang out the sunroof or window, right?
no,
So the lights on the car,
yes,
and you saw that it was a car.
yes.
Thank you, sir. That's all.
Any other defense attorneys have questions for this witness? All right, is there any redirect?
Yes, Your Honor.
Go ahead.
Ms. Burnett, when law enforcement came to meet you, did they ask you if it was Infiniti or ask you if it was what car it was that you were looking at?
They just asked me to identify the car, the vehicle.
And since you and I have spoken or met, have you always lived within the state?
Yes,
And previously, were we able to speak or Zoom with one another? This is the first day you met in person, you flew in today.
correct.
Ms. Burnett, I'm gonna try, so to slow this video down. So the state's going to publish 292 Yankee Alpha. It's gonna go at a slower pace, and if you see, Mr. Burnett, where you want to freeze it, and you spot the emblem in the front grill, just let me know.
Okay.
So, Your Honor, for the purposes of the record, we're starting at 8 minutes and 32 seconds
Okay.
on 292 Yankee Alpha. Ms. Burnett, did that help any slowing it down, Mr. Burnett?
Not really.
That's fair. That's fair. Now, some of the questions, do you remember being on cross-examination, you were asked questions about, can you see the decal or can you tell about the tires? Do you recall that?
Yeah, the jump, what questions you just asked? Yes.
Yeah. And with this surveillance video that you've seen, is it that they don't exist or you're unable to give an answer on those questions because of the surveillance video?
They
Objection
exist, I'm
calls
just
for
not able-
speculation.
Overruled.
You may answer, Mr. Burnett.
Okay. Of course, the wheels and those things exist on it, and you know it's a Q50, so it's kind of hard to. Being that I know the vehicle, it's kind of hard to know. Okay, that's a Q50, and I know where everything is on it at. But trying to necessarily make it fit into the video where I can say stop right here. I see it. It's kind of a little hard to do in real time. And for the court's time, I don't know if we got this time to start just dissecting and stopping it every 2 seconds to see if we can get to there. But again, I've seen the pictures. I drive a Q50, so I know like, you know, what actually is on the vehicle and where it's located at. But as far as trying to using this quality of video as far as to stop it is kind of hard to do.
Thank you, Mr. Burnett. The state has no further questions for Mr. Burnett.
All right, Mr. Adams.
They may have a couple more questions for you, sir.
Oh, sorry.
They're almost done, but not quite.
So, Mr. Burnett,
Yes, sir.
so even though in the still shots and the videos that we see, right, we don't see the identifying item that you mentioned. You don't see a decal, right?
Not in the video, no.
We don't see the emblem on the Infinity emblem on the front.
Not in the video, no.
We can't identify whether it's standard size wheels or what kind of wheels that you referenced before, right?
Not in the video, no, sir.
So even though we can't see any of the things that you say would identify something as an Infinity, your testimony is that you know that it's an Infinity.
Well,
Q50.
right. So this is not the same car? Like,
You tell me, is that the same car?
it looks like the same car in the video. It's a Q50.
Yeah.
You may.
So you're thinking that 459 and 459A, which has been given to you by the state, you believe that this is the same car that's been shown in that video?
The video is definitely a Q50, yes.
Okay, you think it's this car?
It appears to, as far as the color and everything else appears to be, but
does this
again, these are all standard things. It's not like this is it has custom wheels on it or if it has a custom grill. Those are all the standard things that's on the car. So every Infinity has the grill, has the logo on the grill. Every Infinity has a badging on the side. Those are the standard headlights. Those are the standard tail lights.
right?
So if it's a Q50, then it has those things.
So every Infinity has that that emblem on the grill that we can't see on the video, right?
Q50, yes.
Every Q50 has that emblem on the side that we can't see on the video, right?
Correct.
Every Infinity has maybe standard, maybe not standard wheels that we can't see on the video, right?
Correct.
But your testimony to this jury is that these pictures given to you by the state, the same vehicle that's on that video.
Correct.
All right, that's all.
All right, now you're free to go.
All right, thank you.
All right, and it's just about 5 o'clock, so I think we'll break for the day. And I'm going to remind y'all, sometimes I give you a longer reminder, that you need to decide this case based only on the evidence that's admitted inside this courtroom. So please don't use the internet or any other source, electronic or otherwise, to get any kind of information about this case or about concepts in the law. Don't read, watch, listen to any accounts of this trial that might appear online, in print, on television, on the radio, or otherwise, including social media. Don't discuss the case with anybody or allow anybody to discuss it with you or around you, including don't discuss it amongst yourselves. Leave your notepads, notes in the jury room, and remember, for y'all tomorrow, it's a non-jury day. We'll be working, but we'll see y'all back Thursday morning at 9. Thank you. Okay, Miss Love, you had wanted to, I guess, tender for admission, 452, 453, and 460Y.
So, Judge, they were all referenced, and by conditionally admit, what I was asking for permission to do, since they had all been identified by a witness as a particular thing and true and accurate reflections of them, and because they had been referenced so much during the testimony, my request was to tender or admit rather for as evidence 444Y, since 1AS
You
was
didn't
not.
even mention 444Y.
I didn't mention all of them that I wanted to. I started, but then when the court seemed
Okay.
inclined not to
Okay.
entertain that.
Deal
I-
with it right
Right,
now? Yeah,
right.
Since I didn't know what you were really
Right.
talking about in terms of conditional admission. Okay.
Right.
So 444Y is
Yes.
one of them.
So
Okay.
the state tenders 444Y conditionally upon any redactions that we either agree on or the court simply instructs have to be made. 450Y, 451Y, just 452, 453, 454, and 456Y, as well as 460Y. And we have not tendered 463, which is the certified, which was used to refresh Mr. Wright's recollection. We're just adding that to the record because it was a document that had been referred to. So for conditional admission, we were tendering 454, 450. I'm sorry, 444Y, 450Y, 451Y, 452Y, 453Y, 454Y, 455Y, 456Y, and 460Y, to the extent that those reflect the emails from Mr. Wright to the state. So there
And
were,
then what about 463Y?
that was just the last.
Right, are you tendering that one?
No, I have
Okay.
it in my hand. I was about to hand it to Ms. Winfrey because it is a document that needs to go as part of the record, as something that was used to refresh the recollection. I had it, and while I had it, I just referred to it. It's not being tendered.
Okay.
It's just certified of Mr. Sledge's conviction.
Okay, and tell me what you mean by conditionally admit. Do you want to, do you mean potentially redacted in some way?
Yes, I
Okay.
do.
All right. And are there objections to the admission of any of these in any form
All of them,
whatsoever?
all of them.
Okay.
Now, if the point is they were referenced in testimony and therefore for the purposes of the record, not to be
Well, I wouldn't consider that admitted.
right. But
I mean, I assume every exhibit that is utilized, whether tendered and admitted, tendered and excluded, or just used with a witness, is going to be a part of the record. Is that y'all's understanding as well?
yes.
Okay. So, in terms of admitting them,
So, okay. The emails.
yes. Yes, 450 was, you're right.
The emails, we had lengthy discussions about the emails and about the objections and about the problems with some of the things that were discussed in the objections. Miss Love indicated that she wanted to talk about number 3, which seemed pertinent and wanted to get the wording exactly right. I had no problem with it. The other defense counsel didn't seem to have a problem with it, so we read exactly what the wording is. There's no need to admit that, and There's still problems with the other email, the other factual acknowledgments that are discussed in that email regarding the prior versions of the agreement. I went through great lengths to preview what I was going to ask so as not to open up any doors for quote unquote statements that were never uttered or adopted by the witness to be admitted into evidence. The state is now asking the court to just admit documents into evidence that have those statements on it. Those statements provide nothing to the jurors. I don't know what conditionally means. I'm never going to agree to admitting things subject to redactions when I don't know what those redactions are. And it's completely unnecessary. We have read from the documents to get the words correct regarding specific things from those documents, specific acknowledgments from those documents, and both sides have done that.
Oh, I did it again. I didn't mean to cut him off in a thought, but it's a lot going on here, right? So, again, this is Georgia. Every state has their own lingo, their legalese. You know, most legalese is consistent, but you have states that use alternate, alternate meanings. I mean, use alternate wording, right? Which has alternate meanings. You know, like I could tell you that time when Judge Joe Brown didn't know what was the hearing was that Attorney Cole had to go to with regards to R. Kelly and ads and all of that. A Curcio hearing, right? He didn't know what that was, right? And he's a judge. And right here, it seems like the judge doesn't know what conditional evidence is, right? So I'm not sure why she doesn't. I mean, conditional evidence is just like a proper evidence that's admitted to prove a fact later on, which is the best way to say it, right? They can either prove that fact by letting that evidence stand alone, the conditionally admitted evidence, or, submit additional evidence to prove a fact. Okay? But if the evidence that is conditionally admitted by a judge does not prove that fact, then the judge can ask that it be stricken from the record, and she gives the jury instructions to, admit it. But the evidence has to still meet all the qualifications for admissibility, which are those 3 R's. So I'm not understanding why they are having a big having a big issue behind something Ms. Love wants to admit conditionally. I mean, it's admitted, but it's conditioned on if this, that, and the third checks out, right? If whatever other evidence she submit proves the fact, or if that evidence that she's submitting proves the fact, or is relevant. Okay. If it's not, then it just simply gets taken off the record. Now I can understand. Maybe they're saying if the jury done already saw it, then you could say take it off the record. The jury take it out of your mind, but do they? You understand what I'm saying? If they want to go that route, but she Love talking about is she saying that the evidence is going to be redacted right now? Let's keep listening. I mean, Georgia got a lot of shit going on, baby. It's extra down there.
And that's what the testimony is. The proposed documentary evidence is full of inadmissible hearsay and other things, and also provides nothing to the jury at this point. So on behalf of Mr. Stillwell, I should say, oppose the admission of any of those documents into evidence at this time.
On behalf of Mr. Williams, I'm going to join in Mr. Shaw's response. We've already objected to the admission of any of those documents, and we would. I also do not know what a conditional admission evidence is,
Well,
so
I
I'm not
guess-
opposed.
Right, so I guess she means she wants to, if possible, be able to come to agreement about redactions of them, and if not, then present them to the court with her proposed redactions, which, I mean, maybe y'all can get together, and since we have a non-jury day tomorrow, we can deal with that tomorrow, but I don't mean y'all figure out what the potential redactions are tomorrow. I mean, have something ready to present.
Yes, and so, Your
Tomorrow.
Honor, in as much as the tendering was done today, I'll withdraw that request until I have a redacted version to show counsel for defendants into the court.
Okay.
And the conditional, the court had it exactly right. It was until there was either an agreement or something that the
Or
court
then you
deemed.
can present it to me and I'll make a decision.
Yes,
All right, well then have those ready first thing in the morning.
we will, along with the other additional emails that the court told me to have.
Right, for me, for an in-camera inspection. And then I would like for us tomorrow.
In-camera
that a
means
couple
in
of people
private.
Have forwarded some things for our task list for tomorrow. There's a motion in limine filed by Mr. Ryan about autopsy photos. There is a motion in limine by Mr. Williams that provides some law and argument on an issue that we had raised our last non-jury week but not decided about. I can't remember whose statements they were, but some of the wiretap statements we've kind of gotten partway through and gotten, I think it's fair to say, probably bogged down on one particular call and whether there's hearsay within hearsay and whether it qualifies under 801 D2E. So we'll circle back on that issue and maybe make our way a little bit more through that. And then I would like for us to at least start on what's everybody's understanding of which exhibits have been admitted and which haven't, kind of what the status is of the exhibits so far. I covering everything that anybody's forwarded. Is there anything else? There might be.
I haven't yet seen, but I know that they probably are in my inbox. So we'll, since we should be, I guess, ready to respond to the motions in limine, if they're new.
Well, the one of them, I think, is new about the autopsy photos. The other one's kind of just a follow-up on some of them. Yes, sir.
And we filed a brief on that yesterday, I believe. So I just want to make
Maybe
sure that
that's
you.
what I'm thinking of. Is the Williams motion limine separate than the Mr. Nichols brief
Yes.
on that?
Yes.
Two separate issues
Yes.
or the same issue?
I did not repeat what the Honorable Mr.
But
Nichols
it's in
lawyer
the same
said.
topic?
Yes.
Okay.
I just added other law.
All right. All right. And honestly, that'll probably carry us through the day.
Yeah,
probably
we'll
wanna
ass
get
out.
any other one?
This
other
high
topics
spirit.
Or items we need to be thinking about?
Could the court just inquire who's the next several witnesses? It got kind of,
Sure.
I know it's a witness issue, I was told.
Yeah, I was-
So Thursday and Friday, who do y'all anticipate your witnesses being?
Second, let me get that list. Officer Adrian Pitts. Miss Sharon Latners. Potentially crime scene tech Turner, Miss Denise Bell, Officer Sean Hill.
Turner Bill and who?
Hill,
Hill?
Officer Sean Hill.
Okay. All right.
Crime scene tech Jenkins, Detective Thorpe.
Okay. That, we won't get through all of those in 2 days, so that'll give y'all the list of the next several. All right.
And the one main one, if we, the one that has.
It's just the gremlins that are apparently in residence here in Muncie.
Tell us, love, the one main one. What, girl? Tell us. Shit.
That one doesn't seem to be working at all. We may need to put new batteries in some of these.
On our list is available, that we had mentioned last week, that we had approached the bench about regarding a condition that they had a lay witness.
I can't remember. Do they know who you're talking about? I can't remember.
They witness me, they ain't
Do y'all know
expert.
who she's?
Regular.
Your Honor, I'm gonna withdraw that. We'll leave it at where we have it right now.
Okay.
I'll speak to anybody who asks about that, but we're.
Mr. Weinstein, you seem to want to say something.
Normally it's like I use the restroom, actually it's on a different subject.
All right.
Just briefly, I'm not going to be here, Your Honor, tomorrow. Ms. Singer-T is.
Okay.
But I guess I'm going to go back to the old saw that I keep bringing up, Your Honor. And just briefly, just give me 1 minute. 1 minute. I'm going to renew my motion for the court to limit the state's time. I'm going to cite your authority under 244403, 246611, and I'm just going to ask you, please read, if you haven't already, U.S. v. Reeves.
I've read it.
I think it's very persuasive on your ability and the logic and reasoning behind putting a time limit on the state. We just got through with a witness, Your Honor, that the state said was going to take 3 hours. And we spent, now that was just 3 hours on direct. And we just spent a week on that witness, Your Honor.
Well,
So
we had 2 witnesses this week.
5 days, and then, yes, Your Honor, I'm not going to disagree
Well,
with
wait,
you.
no, this is only, what
When
is today? This is only
it was
Tuesday.
Tuesday, I think it was Tuesday, Wednesday, Thursday, Friday, and then Monday, but whatever. It was far, far longer than 3 hours. So please look at Reeves again and consider it, Your Honor.
So, I am reticent to say, for this witness, you can only have X amount of time. However, okay, we've got a, how many count indictment here? With at least 8, in addition to the RICO count, 8 different sets of crimes. And the case law also provides that the state is entitled to, and it is, a violation to prevent them from being able to present their case. And I know that's not what you're asking, but how am I to know how long it is going to take them to efficiently present the amount of evidence to cover all of the things that are in this indictment? That being said, I will say that not so much, honestly, even the amount of time that was taken up with Mr. Sledge, because I assume the 3-hour estimate was thinking Mr. Sledge was going to be a cooperative witness, and Mr. Sledge didn't ultimately end up being so much of a cooperative witness. But y'all, I mean, the amount of time that was taken up by everybody with Mr. Wright was probably a bit excessive. And I put everybody who asked questions almost in that category. I do think that the state needs to, I don't know, get more targeted and focused with the examinations, and then there seems to be redirects take almost as long as the directs, and that should not usually be the case. And nobody ought to be rehashing things that have already been established, either at, I mean, a little bit of leeway every once in a while to, okay, let me refamiliarize you to this as I lead into what I want to get to. But like a 5-question, you know, there's this, there's that, there's the other that everybody's already heard, and I'm addressing this to everybody who might need to hear it. That we don't need.
Baby, if I tell y'all a duck can pull a truck, shut up and hook that motherfucker up. Almost down to the science. I told you what the train of thought is when it comes to interviewing. Okay, I told you like, and I told you like a 3 question, you know, to nail it down, to focus and establish what you're trying to convey over to the jury. You know, the judge said, you know, there's 5 questions or whatever. She spoke to the number of questions. I spoke to the number of questions right to when I was telling you about, like it was too much. I think all of us recognized, either on the professional, through our professional lens or our personal lens, that they're taking too long. But through my professional lens, I know that, you know, what she's doing. And I know that she's going to have a little leeway to do that. But I also said that, you know, the 3 questions to make, you know, to establish what you need to establish is, to me, is enough. Okay, and I'm being lenient. That's 3 questions after the initial question, and then for you 3 questions for you to land it how you need to land it, and establish your point. This is, you know, it is a bit much. And what was the other thing we talk about? That the judge went over. I don't know, but all that stuff she said, we've already gone over prior to, or with regards to Mr. Kelly. I forgot what she said that was applicable to Mr. Kelly's situation. I forgot. So, like I said, it's a lot of things. It was with any profession, I would guess, that is enumerated and unenumerated, meaning it is written and it's not written, but it's law. And the only way you would know those things is if you took your ass to them people class. Okay? And came out with a Juris Doctorate, okay? Oh, motion in limine, right? We remember those from the R. Kelly situation, where the defense was trying to get evidence in with regards to the parents, right? Motion in limine serves as that particular process that either precludes, excludes, or admit evidence, right? So they got a motion in limine they need to work through. So for anybody that wants to get a better understanding of the law, this case is the one to watch. This case is the one to pay attention to. Now, you're not going to get those little nuances that, know what's going on and why they're doing that or whatever, That's, like when I say they're not talking to y'all, that's no offense. A fool would be offended by that, by the truth. That's crazy. Because if they were talking to y'all, you would know what the fuck is going on. Duh. But as you see, they can be talking to each other and everybody don't know what the fuck is going on. They be lost in the sauce. So it's not to be offensive when we talk about those things that separates us from each other, right? And what those things could be your profession, personal shit, this and that, whatever, right? But it separates us. Our belief system, our whatever it is, our status, shit like that. It shouldn't be, taken to be offensive. Now, let me give a caveat. Let me give the it's not really a caveat, but well, yeah, it is. Like now, because some nasty people done treated me nasty, I have to be nasty on the record and, put them in their place. It doesn't apply to everybody. All right? Just the motherfuckers who's fucking with me. You have to understand that. So nobody should be triggered by me talking shit. Because other people talk shit and y'all seem to be just fine, I'm saying, I'm only popping a button because motherfuckers think I can. It's the fact that I won't. But I can. You should know that. It should be enough that I pop that you should know that, right? But anyway. But right now, your girl's on the budget, honey. I got to order this toilet paper and something else I got to order. I got to order some more stuff to go on my goddamn lips, honey. Because this is getting rough, baby. It's getting rough. And I will continue to shout out those that I love and protect and that love me and that I like, to be honest. You understand what I'm saying? I don't give a fuck when we met, okay? Because you idiots don't understand. When you met somebody, they are now somebody you met in your past. I know mental health, envious and jealousy, drugs and alcohol prevent you motherfuckers. Oh, and just being a no good motherfucker. It prevents you motherfuckers from, saying, yeah, that's right. Or yeah, and when it's right. That's what I'm saying. But I'm going to forever be show some level of gratitude to those people. And now that I've ran into motherfuckers like y'all, oh baby, I think them motherfuckers can walk on water. You can't tell me that. You can't tell me that. I think that I didn't show them all the. I ain't been mean to nobody or whatever, but I ain't think that I said that I appreciate you for being my friend. I appreciate you for being family. I appreciate you for being one of my friends. I appreciate, you know what I'm saying? I don't think I've said that enough. Because you motherfuckers have shown me the way. You understand what I'm talking about? Baby, you don't appreciate a good thing till you run into some motherfuckers like y'all. Okay? It is unbelievable. And it's a damn shame that, we got to get it from the parents to figure out what the hell happened. Why you like that? So, yes, I'm a forever goddamn remember the motherfucking times. We're gonna forever be motherfucking connected. Surely is. That ain't never, let me tell you something. Now, credit card man, we was always so private and whatever. I mean, everybody knew about us, that's not what I'm saying, but I'm talking about like, just, we spent a lot of time, alone or popping up at them places that he liked to go or, doing shit with my child or whatever. But, so, he is a part of my non-traditional family. I'm a part of his non-traditional family. But it's just us two. Okay? Now, his wife, except for that time that lady called me, his wife, she's not a part of my non-traditional family. Because I told you, credit card man, he's a, bad boy out there on them streets. She better check his phone number every week, honey. Because, shit. But, that's different. Like, me and my roommate, we're in a non-traditional family with his exes and all kinds of shit, right? Now, I don't know this new woman, but it's got to be somebody because he's never stayed out, for a series of days or something. So it got to be serious. But I know that, he's going to pick somebody. They all going to pick somebody that is, equivalent to my bitch ass or better. That's the rules. Anything less be uncivilized. That's why I can't, move with all kind of shit. That's crazy. I'm fucking up the people's status and the system. I can't do all of that. I have to be real sure, like trash and all kind of, nope. And myself, I'm just not comfortable with them type of people anyway. But, so that's one thing. And the motherfuckers around here that I'm cool with, that, we got whatever. I'm gonna make sure they know that I appreciate their motherfucking ass. And you can break your motherfucking neck trying to find out who everybody is. Good luck. Fucking weirdos. But, so that's never going to happen. So, yeah, we're going to do stories upon some shit. I might motherfucking designate a night as story and spades night and shit. Hell, I don't care. Hey, Derry. What it do? They even try to weaponize the fact. I mean, just sitting there, just jealous and ugly and looking crazy and shit at the computer screen or whatever. I can imagine. Just weird vibes. Just give trash vibes. Nothing, nobody vibes. Ugh. Somebody needs to do a live on what makes you who you are. And I bet you nobody won't do no live about that. Because they know it ain't about shit. Nobody would do a live about that. Nobody. And be telling the truth with proof. Bet you. I bet that. And then I'm trying to tell you, let me tell you what they do. Then they try to make not being about shit okay. When has that ever been okay? What friend group, family, job, whatever is okay with a person not being about shit? You can be trusted. But that's how they try to, get around the fact that we know you ain't about shit. And then they try to shield not being about shit. And you have to watch these because Yvette was a master at it. Shield not being about shit by being nice and sweet. Baby, I can break a motherfucker down. Yvette will loan you every motherfucking dime in her pocket. Put you up. You should meet you on a Monday. You can be in her motherfucking house by Friday. Oh yeah, but baby, she has come to me with some diabolical ass shit to do, or she has done some fucked up ass shit to people. Or and the list goes motherfucking on. I'm like, bitch, how can you sleep at night? Be like, damn, you will take a bitch out. They can't fool me, baby. I might not say nothing, and I'm okay, chilling and tripping with you. But baby, if it comes down to some bullshit and you coming for me, you're gonna have a problem on your hands. Like, that's what they motherfucking do. If a stranger, honey, she'll loan your motherfucking ass $100, don't even know you. There's reasons they do all of that. I can't give you all the information. I'm gonna stop giving all the game and all the information and shit. That's, But I'm telling you, there's reasons why they do that. Some is personality reasons. Some it has to do with manipulation. There's a lot of shit. You have to watch them motherfuckers. Like my family used to say, you have to watch the quiet ones talking about me. Right, I know y'all living quiet, but I am. Oh, you have to watch the quiet ones. Because at one point, I was doing it, everything right. Just about or whatever. There was something behind it. And it was so crazy. They cast the same expression on my little cousin as you heard him talk about it. Talking about the family, say how he be moving, how he be getting. I be like, well, what? And my family is good for if you don't tell them or what they don't know, they gonna put something together. And it can be further from the truth. They done gave me I don't talk about that, but they be thinking I'd be married all the time. It's all kind of shit, honey. So my family shit may be different from your family shit, but it's still, had me like, huh? And I want to deal with, certain bullshit with them. But all that aside, and that ain't that serious. All that aside, I wouldn't want to be raised by no other motherfuckers, no other family. And I said this before I even knew I had crazy people and all that type of shit on my motherfucking back. I would put my friends and family up against anybody's friends and family. I don't even know you motherfuckers or what y'all can goddamn bring to the table. I said that without even knowing. I said I would put up my men, friends, and family against all. You know what I'm saying? Yes, sir. And I still say that. Oh, I really say that now, baby. Anywhere. The court, anywhere. I got a few people that will not miss a shot. I'm talking about threes. I'm talking about I done sit there and seen somebody take motherfucking from the free throw, shot after shot after shot, and tell me I'm lying. I might get him or another witness on the line right now. Please tell me I'm fucking lying. Shot is automatic. Yes. And you know about them sports and stuff like that. I get goddamn an emotional orgasm. Shit, I gotta find out one for sports. Shit, what kind of orgasm? A basketball orgasm. Hell, because my motherfucking ass until about 13, 14 years ago, I was so impressed. Yeah, I told you the small shit impressed me. About people that can spin the damn ball on their finger. I'd be like, oh, I'm falling in love. Grown ass motherfucking woman. 30s and 40s. I'm falling in love. I'm so in love. Oh my gosh. He can spin the ball on his finger. Oh my God, look at him. He is wonderful. Oh, look at him. All of that stopped when I saw a third grade girl spin the ball on her finger. I was like, oh, fuck no. So I went and told all my friends, because you know, I have to bring them back to games, you know, because we don't be out on the street with the street people too much. We don't know certain things all the time. So, you know, me, I'm a person that's always seeking knowledge. Fine, I went to her, I said, hey, we can't be impressed by that shit no more. It's a third grade girl, goddamn, spinning the ball on her fucking fingers. Like, what the fuck? We done been tricked out our numbers and shit over somebody spinning the ball over our finger. And of course, they think if I get, get all, oh my God. So they feel like that's the right thing to get. Oh my gosh. Well, Evangelist says that, he spinning the ball on his finger is so wonderful. Then, guess what? And another thing, right? When you see them quarterbacks throwing them balls, and listen, I done figured out something for myself. When I see one soaring in the air and it stays straight, I love him. Maybe I need to get my life in order. Oh, I love him. He's the best in the world. Oh my gosh. Yes. Yes, sir, Derek. Basketball. I love it. Basketball and boxing. Those are my first 1 and 2. And I can go anywhere after that. Probably track, maybe tennis. It all depends. But yeah. Oh my gosh. Y'all, child, I done been tricked at my goddamn mama so much about bullshit. I ain't even know. I'm like, wait a minute. A third grade girl is spinning the ball on her finger. And I done sat up here and done broke my goddamn neck trying to get in the eyesight of this goddamn nigga so he could do the rest of the work. I done sat up here and smile back and all this shit, this goddamn nigga, because now I understand. Now slam dunking and shit like that, but you understand that. Now, of course, that's gonna give you orgasm. But I'm up here acting like a damn fool, putting in all this damn work. And yes, New Black, I do put in, little work. But not the work you talking about. I ain't gotta do all that. That's bullshit. I ain't gotta do all of that. To get somebody that apparently having problems with getting somebody. That's correct. I don't do no motherfuckers like that. I don't want nobody that nobody else don't want. And I want them to have the same principles. Have the same principles. Mm-mm. You know what? And a nigga I done been with, Lord have mercy, with like, but with like a sexy red, or probably them city girls. I don't know about that. Probably could be out. Maybe Nikki, because sometimes she can be the mule or whatever. But, honey, they particular. They and a few of them done had a chance to get with celebrities and shit like that. They be like, no, thank you. I know somebody that had an opportunity to get with Erykah Badu. But I don't like to tell industry stories. I really don't like being put in a snitching position or whatever, and especially because just telling, you know, stories and shit like that and showing receipts and shit, it, made y'all so upset, honey. But yes, so y'all, so just so you know, you see a dude that can spin the ball on his fingers, that shit is not impressive. So don't give up your numbers or your ass. Okay? Because a lot of them can do that. Treat me at my damn number. Oh, bunch of you outside. I be in love. Oh. Let me get back to Miss Love.
And we just don't need to be rehashing everything. And we also need to think redirect is supposed to only cover things that are in cross, and recross is only supposed to cover things that were in redirect. So please get more focused. And to the extent that people make the 403 waste of time objection, I'm going to take it seriously.
Well, I think Reeves addresses, I guess, a lot of that and the need for us to raise 403 by eliminating that and eliminating the courts, or reducing, according to the judge in that case, eliminating the need for the court to spend a lot of time on 403s, because it forces the state to be more efficient in their presentation of the case. And to say that the state is moving with any degree of efficiency or I just don't know what to say about the plotting rate that the state plows through the direct examination. And I don't see anything. I mean, we're 100 witnesses in. We got 100 witnesses to go. I know that's a rough number.
I'm hoping we don't actually have 100 witnesses to
Well,
go.
that seems
I really
to be a
would
bottom.
like that to be narrowed down, but I don't think we've gotten to the point yet where we can turn to that topic. But I mean, I've said a couple of times that the state needs to take a very close and careful look at the witness list that still exists and do everything you can to make sure that we're not being cumulative with our witnesses. And I hear you saying maybe we should be doing the same thing about a time limit. And y'all, I mean, and I know it's not a trial, but incredibly important issues get decided in appellate courts all the time.
And if it is, if it does, this does keep going, I see the judge is warning, not to get it cumulative. Cumulative runs afoul of 403. So y'all, watch out for that. They start making up objections with the state's witness based on Rule 403.
You get, 20 minutes to talk about something that could be groundbreakingly different. So, I'm not saying that at some point I might not just say, all right, you've got 5 hours for this witness's direct and you can do it in that amount of time. I'll need to know more about what you need to cover with that witness, but it's not outside the realm of possibility. I do think that given how long Mr. Copeland was on the stand, that we've made real progress in that we've now been able to finish 2 witnesses in far less time than that. But yeah, I hope 3 witnesses in far less time than that. So I feel like it is progress, but we could probably get more targeted than we are.
Girl, you sneak this mistake.
In as much as I'm probably the most verbose of us all, but I can make my questions tighter.
Okay.
The intent on redirect has always been to respond to things that I hear brought up on cross, and to the extent that I can be more precise in pointing out the specific question that was raised on cross that I'm trying now to have the witness explain further or give an explanation for, I will do that as well.
All right, and I do not want to call anybody out in front of the jury. I also don't want to excuse the jury constantly. That takes a lot of time just for them to even file in there and file back. So, you know, I'm telling you all this now in the strong hope that what you're saying you're going to do, you're actually going to do. But if I see that it still is as, I don't know the right words, but depending upon what I see, I may have to deal with it further.
Okay. Thank you, Honor. And I wouldn't keep raising this if my client wasn't stuck at Rice Street. So that's the reason I bring this up every once in a while.
Well, I mean, I think it's fair to bring up regardless.
Thank you, Honor.
So-
I appreciate you hearing me
Okay.
out.
And Your Honor, I also, just for the record, and so that the victims that are named in our cases are aware, we are appreciative of the courts affording the state the opportunity to effectively present to the jury all the evidence that we have in this case without being cumulative and without being redundant. But our victims obviously deserve every bit of attention that we have to offer to this, and I appreciate the court's willingness to afford that to the state.
Okay. All right, if there's nothing else, then let's convene at 9 tomorrow.
Thank you, Judge.
She is dismissive as hell, honey. And I don't got time for that. Yeah, they look innocent today. Them 2 over there, they look innocent today, y'all. They look really innocent today. Yeah, so that was very, very interesting. That lady wants to tighten up on the question, and that's a reasonable ask. Like I said, I'm being real reasonable. 3 additional questions to get your shit together, land your shit, and move on. Move on. I think another thing is I think that the state realized that they have created a weird ass RICO, and they got to overstate. They got to over-establish what the hell is going on, right? What I want to do is I'm gonna put my own self on motion. I'm trying to limit my personal interjections, but you know, when shit is brought back up at my motherfucking ass. You know, it tends to bring back memories, right? So, anyway. Yes, child. Motherfuckers spinning their ball on their goddamn fingers. Done treat me out my goddamn number, and in 6 weeks, treat me out my damn ass. The fuck? Oh my God. And y'all don't ever been somewhere sitting like in the gym with your girlfriends or something. They come, somebody coming in the door. Y'all hitting each other, hitting each other. Like, yeah. Man, listen. Sometimes you have to put plans in action. Okay? Now, when I say this, you got an idiot that's going to try to apply it to their motherfucking ass. I'm not talking about, there's not a motherfucker out here that I'll come up with some plan to do nothing. Oh my gosh. Are you serious? I have no idea why y'all think my people picking process, my definition of trash, who's worth whatever, don't extend to this motherfucking goddamn shit. Are you crazy? Extend to every motherfucking body. So, I told you about, the planning process. I told you how I had to, because crazy man wasn't playing with no goddamn mind. I had to figure out something to do because I wasn't leaving that gym without his number. Something was going to happen. I tell you, it'd be impossible. You know how crazy it is for me? Like, like a couple of times I've had to do this. But you know how crazy it is to get somebody that ain't paying you no attention to pay you some attention and to make him realize that he, want to holler at you and it ain't you wanting to holler at him the whole motherfucking time. You know how hard it is to do all of that? Thank God, just, I was blessed with a coochie selling walk. I was walk on by, and you do something. I remember this one boy, I told y'all, he's in the DMV. And it seemed like I was getting there, whatever, and I saw what agitated him about me, took care of that. So I do put in work what I want. I mean, if it's worth it, because oh my God, he was so good. Oh my God, he probably some kind of preacher now. So I'm going to see if I can find his ass on Facebook and stuff like that. He is at DMV. He's from Maryland too. I had everybody in on that plan. I mean, I saw that he didn't like the fact that, a bunch of guys always be in my face or be around me and stuff like that. I shut that down. I wasn't going on no dates. I shut that down. I just showed him, listen, hello, I can be a good person without all that shit, okay? And then I was like, okay. I mean, they had to, help me set up an ambiance. I don't know how many walks on the beach we done had. Walks by the water. Walks at Lover's Lane. And we'll get there, and then it'd be like, we'll get to a point, and it'd be like, it's not like he don't back away, he just don't take the next step. Well, I ain't gonna take it. I'm the female. I was like, this motherfucker either gay or married, because this don't happen to me. Hey, this motherfucker must be gay or married. Y'all know how y'all be saying that, ladies and gentlemen, stop playing with me. I'm like, this motherfucker is gay. I'm married. Oh my gosh. We with that one that many, but we tried every motherfucker. I'm like, this some bullshit. Some bullshit. This too much work. But yeah. So y'all, I don't know if I'll be back to do the debate. Hopefully I will be, because I got something I really need to do. I'm trying to get my hours up. I'm trying to make sure my algorithms stay pure in the sectors I need to be in. So I'm doing everything I read. But yeah, that was crazy. I wonder what it's like. And you know what? It's another friend of ours who, y'all heard these other guys say that we can't find them or whatever. His ass is in the DC area. It's just like they just fall off the map. And my people finding goddamn shit is on point. It's like they fall off the map. Shit. We literally are looking for your ass. What are you? Well, yeah. He probably had the potential to be the next Adrian Abella, honey. Surely did. That one that's somewhere in Maryland. Yeah, honey. I don't know what was that about. I mean, so fit. Oh, God. Absolutely gorgeous. Black as a tire. He wasn't 6 foot, but he was like maybe 5'11". You talking about bitch ass. It's very nice. If I hadn't jumped all the guns, honey, I done took him to meet my mom. Of course, I introduced him as like a friend, Child, listen, I was putting it where I wrote him a letter, maybe letters, but I know I did write this one. I don't know what was going on. I was like Yvette. I was like, and this other girl, named Michelle. I don't know what is going on with this, but he's either gay or married. There ain't no way in hell. This is crazy. I'm a nice person. He wasn't giving off nothing gay or whatever. I was just like, what the fuck is going on? But I didn't want him to see me as as no fun girl, no party girl, or whatever. So I shut all that down. Baby, we ain't shaking what your mama gave you. We ain't doing no stanky leg. We ain't partying. We ain't going to no events. Now, not this one. Y'all can go. But I'm being a nice little girl. I'm changing. Oh, Lord. Oh. New black, I do put in work. A little bit. It was so crazy. Like we would um like be out or whatever and just said pee on the wall. Do y'all call it this? We'll be like we playing the wall. That means we on the wall, being cool, chilling out. We play in the parking lot. That means we outside the parking lot. I ain't just say that. So he would be over there playing the wall, whatever. And the thing about it is, I ain't never seen him talk to no girl. Never. So I don't know what the fuck was going on. Where's Justy so she can clown my ass? But yeah, I don't know what the hell was going on with that. But he will always be around, us, jumping and call with us and stuff like that. But I couldn't get that one, y'all. The girl took a L, child. Oh, man. I am not riding up and down on Maryland to look for his motherfucking ass. I am not doing that. Now, wait a minute. As I was riding up and down the streets looking for Adrian's daddy's house. Oh, shit. Mm, mm, mm. I don't know. Let me see that boy face right now. But he went back to Maryland. And I remember the night before he left, it seemed like we was going to kiss. What? So he was gay. Something wrong. Got me fucked up. Something had to be wrong with him. He was probably, you know what? And I can picture him being one of them old love makers. Lord have mercy, Jesus. You run into one of them old love makers, that's danger. Danger, child. Like mystical say, that's danger. Adrian is love maker. Policeman is love maker. Red community love maker. Tony is love maker. That's your daddy. That was the other husband. Oh Lord, look at the numbers going up. I'm talking my numbers. Oh shit. Trust me, baby. It was coming to an end. Hell, I'm old shit. I've been here a minute. Yeah. You gotta give back the more love makers, honey. And shout out to them non-love makers. Honey, I did not see a future with your motherfucking ass. Although I married one and was engaged to another. I don't know how that worked out. I was not seeing no future with your motherfucking ass. Cause I don't even understand. Then by somebody tells you, hey, and stops you. and you still go back to it after you be good for like one or two sexual escapades and go right back to the motherfucking shit, knocking my hairstyle all out my motherfucking head and sending me down by the damn to the damn headboard and all that bullshit. If I got time for that. That was ain't no orgasm going on with that. Straight up and down. Because I'm too busy in my head thinking, oh my God, when is this gonna be over? Go this way, go that way, go this way, go that way. I'm telling y'all, once they find out your ass is flexible, you are doomed, bitch. They be like, okay, hold on. There ain't no way in hell. She got all that ass, and her legs can do all of that. Them motherfuckers, they be like, okay, we finna put it to a test. Y'all know how the men think. I'm like, what the fuck? I'm like, are we playing Twister or what are we doing? And you can say, regular old love making, sex is boring. I don't care. Yeah, old man sex or whatever. I don't give a damn. I got time all the time. Your ass got a shit. Look like you done been through it. Hell, you get finished, you got to rub ice hot all on your ass and shit. I got time for that. All on your arms and shit, ice hot. You go to work because you are light. Them people looking at all them bruises and shit. Like, what happened? And I ain't finna lie. I'm just sitting there looking crazy. And then it's always the guys that catch on what the fuck done happened. Because I be bruised. Like, what the fuck is this about? And I ain't talking about just from nobody just holding on to you tight. Like, I'm talking about like me trying to withstand all this pressure. And I told y'all I was in the wrong, position for the doggy. I ain't know. I know you're supposed to be down and arched down. I thought you're supposed to be up like a dog. Oh shit. You're supposed to be up like a dog. Ain't nobody told me shit. But to that girl, I met Louis Vet. I'm like, no, bitch. I was complaining to her. I'm like, girl, I'm tired of this shit. I'm about to cry. She's like, no, that ain't how you supposed to be. I said, they keep sending me to the damn headboard. I ain't had no other, no, I don't have no girlfriend that we talk about this type of stuff. Mm-hmm. You're like, bitch, I'm always be going on with you. Hey, how you? She know everything, honey. She said that the Cosmopolitan magazines talk about sex in there, and that's why she was ordering them Cosmopolitan magazines. I'm like, oh. But anyway, y'all, let me get off no time. I'm making goofy. I'm still delirious, so I'm sleepy as hell. But I'll try to be back. If not, y'all know I'm looking at the debate. See, and listen, you can tell Trump is old punk motherfucker. He's so upset that Kamala, that Joe done released this shit to Kamala, because he knows she's gonna get the bump and she's gonna be a better debater. And watch how, because really, I don't know what all she's done or whatever. I don't know. But he's going to have to try to tie her to Joe Biden's record. Watch, let me tell you. He's going to have to tie her to Joe Biden's record. So, and it'll be interesting how she get from up under it. Will she throw Joe semi up on the bus? Will she embrace it? But make herself stand out, and the best thing would be, you know, to embrace and admit, yeah, she worked, you know, well with Joe, what have you, but you know, she could say something like, but I plan to take some of the policies that are working and making them even better, some of the policies that aren't working quite well, and make some improvements to them. But after all, I'm running for president, and I have my own, you know, ideas and agendas that I would like to present to the American people and possibly have them accepted by the world, right? Yeah. So, I don't know. Be interesting to see how she how she'll do this, right? It'll be very interesting. So, anyway. Come on, Kamala. Put this one out for us, girl. Don't get me emotionally invested like that no more. Hillary Clinton shit almost killed me. Had me rocking back and forth singing Negro spirituals. My spare time. Don't get me no more. Got all these goddamn black Trump. God, who is rewriting history? They're rewriting history. Oh, let me get off here because I go get into politics. That's another hour. All right, y'all. As always, make sure you do something good for yourself and somebody else. Peace out and stay live till next live.